Give a date, my lords.
What can I say?
My lords, one submission, my lords. The suit is of the year 2000.
List according to.
My lords, earlier hearing application was allowed and the suit is of the year 2009.
List
my
after 2 weeks ಅಂತ ಬರಕ್ ಕಳಿಸಿ ಅವ್ರು.
lords. Grateful, my lords.
2 weeks ಆಗ್ಬೋದಾ 4
No,
weeks?
any earlier date, my lords, please. Some date may be fixed, my lords. Please.
ತಗೊಂಡು yes. ನಿಮ್ದು ಅಷ್ಟೇನೆ.
The urgency is that my lord respondents trying to alienate the property, my lord. That's why survey is also they
You are
applied
the
for.
appellant.
I am for the appellant.
When you have filed the appeal?
July 2024, my lords.
When the
All the
second-
objections are all the office objections.
Correct. July 2024 ದಿಂದ objection comply ಮಾಡಿಲ್ಲ
No,
ಇಲ್ಲಿವರೆಗೂ.
my lords. Initially, it was presumed that it is coming before the single bench, my lords. But subsequently, after clearly evaluating the appeal memo, my lords, it is division bench.
That
Our own error, my lords. I am not denying.
the court ಕಳಿಸಿ.
Now they are filed for the survey and trying to alienate, my lords. That is the urgency I am seeking.
ತಗೊಂಡು ಕಳಿಸ್ಬಿಡಿ.
Adjournments, page wise, list 1, page 1, cell number 1, page 2, cell number 2 to 5, page 3, cell number 6 to 9.
Mr. Swami Malad is out of station, Malad.
He is appear for the.
He requested-
Application for withdrawal of the amount deposited by the appellant. Case of death, my lord. Yeah.
Yes, managed.
Monday, I told you. He requested me to take time. He is, since he is out of station.
It is from 2021.
ಅಲ್ಲ ಇನ್ನು ಪ್ರೊಸೆಸ್ ಕೊಟ್ಟಿಲ್ಲ ನೀವು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 4 ಗೆ.
ಅವ್ರು ಹೇಳಿ just now only informed me, man.
I for climate, my lord. I will permitted to withdraw the amount. They challenge the.
No, we do not know what is the liability, whether liability,
They have not challenged liability. Quantum they have challenged.
we do not know. ಆಯ್ತು ಮಂಡೇ ಹಾಕೊಳ್ಳಿ. What is
Monday.
ಮಂಡೇ ಹಾಕೊಳ್ಳಿ. As
Serial number 1, your lordship.
as a final charge. Monday
17.
17. Yes.
16 Raja.
17.
17.
He said 17. Yes.
Page 4, cell number 10 to 12, page 5, cell number 13 to 15, page 6, cell number 16 to 19, page 7, cell number 20 to 22, page 8, cell number 23 and 24, page 9, cell number 25 to 27, page 10, cell number 28 to 30.
For the responder, already intimated to other side counsel.
30.
30th.
30, I appear for appellant, my lord.
He is seeking adjournment.
Today
Non-
my-
Next week on date, next week, my lord, on date may fix, my lord,
Sir,
some
the
urgency.
counsel. Have you received the copies?
I received the copy.
Respond number 1 and 16. Huh?
To press time to objection to.
Appear for respond number 1. 16 Nandish Kauda.
I am for the one.
You have received the copies?
Yes, you.
You have served the copies on Nandish Kauda also?
Also served, my lord, already served, my lord.
The counsel corresponding that he has received the copies. Okay. As requested by the appellants, you are, as requested by response counsel, list on
Next week, 19.
Next week on
19.
date may,
19.
please, my.
Page 11, cell number 31 to 34, page 12, cell number 35 to 40, page 13, cell number 41, page 14, cell number 42 to 44, page 15, cell number 45, page 16, 46 to 47, page 17, cell number 48 to 51, page 18, cell number 52 and 53, page 19, cell number 54 to 57, page 20, cell number 58 and 59, page 21, cell number 62 to 62, page 22, cell number 63 and 64,
Serial number 63, my lord. I am appearing for my lord, respond number 7, owner of the vehicle lordship. And the insurance company, my lord, has filed, my lord, regarding liability question is there, my lord. I seek 2 weeks time. my lord.
Interim
I will-
order is there. Interim order ಇದೆಯಾ?
I will,
Finally. Pradeep,
please, I
you
will,
have informed him.
please, my lord.
Urgent request of counsel for respond number 7.
list number 2 for
Okay.
non-compliance, second time,
Serial number 3, my lord.
cell number 1 to 16,
Second time.
Number-
2 weeks time. we are
Number 3, my lord.
granted. 1 to 16.
1 week time.
2 weeks ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಮೇಡಮ್.
Then what?
Serial number.
Office objection comply ಮಾಡಿದ್ರೆ why they were listed in office objections? You check that. But what it requires finally 2 weeks time is granted to do the needful.
Serial number 14.
ಎಲ್ಲ 2
Serial
weeks.
number 5.
2 weeks,
1 to 16, 2 weeks. Yes.
please.
For for third time, serial number 17 to 23.
My lords,
2 weeks.
serial number 18, my lords.
Appeal shall stand dismissed. 17 to 23.
Serial number 18, my lords.
Yes, what is 18? We are granting 1 week time.
My lords,
17 to 23.
could it be listed on 20th, my lords?
Why you have complied the office objection?
Yes, my lords, fees has been, court fees was our office objection, my lords.
Is
That has been, I'll verify, my lords. Could it be listed on 20th, my lords, please, my lords?
Finally, 1 week time is granted to the needful, failing which the appeal shall stand dismissed. You go and comply it, then they will list it.
20th, my lords.
No, we do not know. You must comply the things.
Great.
You are putting the hands before the.
Serial number 22, madam.
Same 1 week time we are granting in all the matters, failing which the appeal shall stand dismissed.
Oblige.
For fourth time, serial number 24 to 29.
There anybody is there in these cases? Why should we?
Interim will pay.
Hmm.
Earlier, RF is maintainable up to 10 lakhs. After amendment of act,
ಕೆಲಸ ಮಾಡಿ ಸರಿ ಇದು ನೋಡೋಣ 24, 25, 28, 29 no representations for the appellants. Despite granting sufficient opportunity, faithful is not done. No purpose, there is no justification to grant further and hence appeals are dismissed. From Tagapudi 27, 26,
26 alva sir.
14, 14. How much is the valuation?
10 lakhs.
10 lakhs ಇದ್ರೆ ನಮಗೆ ಇವನ್ ಅದರ್ವೈಸ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಗೆ ಬರೋದಿಲ್ವಲ್ಲ 10 lakhs ಇದ್ರೆ
Earlier amendment act ಆಗಿದ್ಮೇಲೆ RF now it is maintainable. I got Gulbarga, I got state.
ಒಂದ್ ನಿಮಿಷ ನೋಡೋಣ ಆಫೀಸ್ ಅದು ಒಂದೇ ಇಲ್ವಲ್ಲ
ಬೇರೆ ಇದೆ apply ಮಾಡಿ.
necessary correction to be carried out in the entire appeal memo, proper court fee to be made good as per section 49(3), actual number of delays days to be stated, appeal and IA to be page initiated, ranking of the appellant at cost title of appeal to be correctly stated, pin code to be stated, marking of the appellants to be removed, details of memo for violation to be stated, second set to be filed, provision of law in RFA be correctly stated. ಇದರಲ್ಲಿ ನೀವು ಹೇಳೋ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅವ್ರು ಹಾಕೇ ಇಲ್ಲ. Why should we grant you time? 4 times and you are not aware what are the office objections. Sumni you try to mislead us saying that office objection is regarding maintainability. Sorry, we don't grant you any time. If at all we have to grant you, we will impose very heavy cost. Court fee ಕೊಟ್ಟಿಲ್ಲ ಮೊದಲು ಇನ್ ಕಾಸ್ಟ್ ಹಾಕಿದ್ರೆ
2 days, only 2 to 3.
At request, we will impose 5,000 rupees cost. At request, 1 week time is granted to do the needful. 1 week time is granted. On payment of cost of this 5,000 payable to the High Court Legal Service Authority. If costs are not paid and needful is not done within the specified time, appeal shall stand dismissed. Yes. Yes.
For orders, serial number 30, government advocate.
Yeah, wait, notice your lordship.
The other matter, permission to.
And we have also filed application for additional.
Connected matter, there is delay condonation.
Oh,
30.2 null.
30.2 null, I have to file my objections, madam.
You want to file objection.
639.
30.3 nulli non-compliance of office objections. Government advocate.
please, your lordship, will very.
30.2 and 30.2 nulli at request 2 weeks time is granted to find the counter to IA 1 of 2023. 30.3 nulli 2 weeks time is granted, at request 2 weeks time is granted to comply the office objection. List after 2 weeks.
Oblige.
Serial number 31, Ramesh Chandra.
I appear for the appellant, my lord. There are 3 office objections. One with regard to the non-serving of the copy on the caveator. ನನ್ನ ಮೇಲೇನು ಕೇವೇಟ್ ಹಾಕಿಲ್ಲ ಅವರು ರೆಸ್ಪಾಂಡೆಂಟ್ 2 to 7 ಮೇಲೆ ಹಾಕಿರೋದು. I was not a party in the trial court.
But same case then.
ಕೇಸ್ ಸೇಮು ಬಟ್ ಕೇವೇಟ್ ಆಯ್ತು ಮಾಡ್ತೀನಿ. ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ನಾನು ಐ ಹ್ಯಾವ್ ಸಾಟ್ ಫಾರ್ ಎ ಪರ್ಮಿಷನ್.
That should not be a means to defeat
ಇಲ್ಲ
the KV.
ಡಿಫಿಟ್ ಅಲ್ಲ
Yes.
ಪ್ರಶ್ನೆ ಇದ್ರಲ್ಲಿ ನಾವು ಏನಿಲ್ಲ ಅದ್ರಲ್ಲಿ 99 ಲಕ್ಷ ಕಟ್ಟಕ್ಕೆ ಹೇಳಿ. ಐ ವಿಲ್ ಸರ್ವ್ ವಿದಿನ್ 1 week. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಟೈಮ್ ಬೇಕಂಡ್ಲಿ. ಇನ್ನೊಂದು ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ಬಾರ್ಡ್ ಬೈ ಟೈಮ್ ಮೆಲಾಡ್, ಬಿಕಾಸ್ ಆನ್ ದಿ ಡೇಟ್ ಆಫ್ ಕಮಿಂಗ್ ಟು ನೋ ಐ ಫೈಲ್ ದಿಸ್ ಅಪೀಲ್ ಮೆಲಾಡ್.
You filed the copies so that we will be having the benefit of hearing in.
ಮಚ್ ಒಳ್ಳೆ. ಸೆಕೆಂಡ್ ಸೆಟ್ ಅಲ್ಲಿ ಸೈನ್ ಮಾಡಿದ್ದು ನನ್ನ ಹತ್ರ ಉಳಿದಿದೆ, ಅದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
Entire second set and I had to be duly signed.
ಅದೇನಾಗಿದೆ ಅಂದ್ರೆ ನಾವು ಸೆಕೆಂಡ್ ಸೆಟ್ ನಾನ್ ಸೈನ್ ಮಾಡಿದ್ದು ಇಲ್ಲೇ ಇಟ್ಬಿಟ್ಟು ಬೇರೆ ಹೊಲ್ದು ಬಿಟ್ಟಿದ್ದಾರೆ. ಅದನ್ನ ಇದೆ ಇಲ್ಲಿ ನಾನು ಅದು ಅದ್ರ ಕೊಟ್ರೆ 1 ವಾರದಲ್ಲಿ ಎಲ್ಲ ಮುಗಿಸ್ಬಿಡ್ತೀನಿ.
In cost rate with regard to dispensation of notice to 2 to 7. That request 1 week time is granted to comply with office objection.
1 week time. Much of.
Your Lordship, list number 1. Lordships for previous matter. Serial number 13.
13?
I need pass.
ಯಾವ್ದದು?
30.
30 ಅವೆಲ್ಲ ಹೆಜ್ಜೆ ನಾನು ಹೋಗ್ಬಿಟ್ಟಿದೆ ನೋಡಿ. 30 ಯಾರೋ ಟೈಮ್ ಕೇಳಿದ್ರಲ್ಲ ಕೌಂಟರ್ ಹಾಕ್ಬೇಕು.
Urgency.
Whom do you represent here?
States appeal.
State ಅಲ್ಲಿ your
Yes,
state
deadline.
advocate was there.
Because I am appearing in this matter, so your Lordship.
ಅದ್ರಲ್ಲಿ ಕಂಪ್ಲೈನ್ಸ್ ಇದೆ, ಕಂಪ್ಲೈ ಮಾಡಿ 1 ವಾರ ಟೈಮ್ ಕೊಟ್ಟಿದೀವಿ ಕಂಪ್ಲೈ ಮಾಡೋದಕ್ಕೆ.
But one order has to be clarified. This honorable court has granted stay.
ಸಾರಿ ಸರ್, ನೀವು ಬಂದು ಇಂಟರಪ್ಟ್ ಮಾಡ್ತೀರಾ ನಮ್ಮ ವರ್ಕ್ ಅನ್ನ.
I'm sorry.
Is it the mode of the government?
No.
Interrupting in the work. ಕೇಸ್ ಕರೆದಾಗ ಬರೋ ಹಾಗಿಲ್ಲ, ಮಧ್ಯದಲ್ಲಿ ಬಂದು ಇಂಟರಪ್ಟ್ ಮಾಡೋದು.
Apologies. List number 1, frauders, seal number 1, Naveed Ahmed, N.
Your Lordship, a week's time may be granted, Your Lordship. I'll pay the PA of.
Steps to be taken, answered proposed R18. You are
For respondent number 1, my Lordship.
One is dead, it
For
seems,
N.
no?
Timegowda.
One is dead, Your Lordship.
1
For
year.
LRs, I have to file them.
Deviator respond. N. Timegowda, I'm appearing on behalf of them.
Correct. Are you going to take notice for the LRs also?
Yes, my Lordship.
They are going to file wakalat.
Yes, my
Here
Lordship. We will file.
whether you have instructions.
In this, no, I don't have any instructions. I will instruct the
1
Yavasika.
week time is granted to the.
Seal number 2, HP Leeladhar,
Good job.
Pawan Kumar.
For the appearance matter. Respondent number 1, postal share has not claim ಅಂತ ಬಂದಿದೆ sir.
Only one respondent.
Only one respondent.
Filing of paper books. Service. Who is respondent number 1? Plaintiff.
ಗೌರಮ್ಮ
75 years ಅಂತ ಇದೆ ನೋಡಿ.
ಇಲ್ಲ ಇದಾರೆ ಅಂತ ಒಟ್ಟಿನಲ್ಲಿ ಕೇಳಿದ್ವಿ. ಅಲ್ಲಿ ವೆರಿಫೈಡ್ ಮಾಡಿ. ಎನ್ಕ್ವೈರ್ಡ್ ಅಬೌಟ್ ದಟ್ ನಂಬರ್ 1.
ಮಾಗಡಿ ಕೋಟ. Service and sufficient. As per the list is not, as per the records, respondent number 1 has not claimed the notice. Service and respondent number 1 is held sufficient. Paper books are
ರೆಡಿ ಇದೆ ಸಿಂಪಲ್ ಮಾಡಿ.
2 weeks time is granted to file.
ಪ್ಲೀಸ್.
Seal number 3, Abhijit MM.
Notice to R2 for the second time. Who is R2? Sunil Kumar. Contest ಮಾಡಿದ? R2, somebody had appeared for him in the trial court. Liability is fastened to insurer. Now, consider the appearance submits memo for dispensation of notice to respond number 2. Dispense with as per for. ಏನಾಗ್ಬೇಕು ಮುಂದೆ ಇದ್ರಲ್ಲಿ ಈಗ? ವಿಜಯ್ ಕುಮಾರ್ for R3.
We cannot file.
ಏನ್ ಲೋಕದಾಲತಿಗೆ ರೆಫರ್ ಆದ್ರೆ ಸೆಟ್ಲ್ ಆಗೋ ಚಾನ್ಸ್ ಇದೆ? ಏನಾದ್ರೂ ಅಶ್ಯೂರ್ಡ್ ಇನ್ಕಮ್ ಇತ್ತಾ ಅಥವಾ ನೋಷನಲ್ ಇನ್ಕಮ್? Agriculture. What is the error? How much is taken? Accident ಯಾವ ಇರೋದು ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? Accident 2018. 62 ನಾ? ಇನ್ಕಮ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? 8,000 per month ತಗೊಂಡಿದ್ದಾರೆ. ಅದು ಕಡಿಮೆ ಆಯ್ತು ಅಂತನಾ? ಇಲ್ಲ ಲೋಕದಾಲತ್ಗೆ ಹೋದ್ರೆ ಸೆಟ್ಲ್ ಆಗೋ ಚಾನ್ಸ್ ಇದೆ ಅಂತ ಇದ್ರೆ ರೆಫರ್ ಮಾಡ್ತೀವಿ. ಅದು 62 ನೋಡೋಣ ಹೇಳಿ. The matter is referred to local. Yes.
Cell number 4, Hanmantappa A, Muralidharayan. Cell number 5,
ಯಾವ court ಅದು? This is from which place? ಅಲ್ಲ ಇಲ್ಲಿ ನಮ್ಮಲ್ಲಿ ಇಲ್ಲಿ 2001ರಿಂದ ಲಿಸ್ಟ್ 21ರಿಂದ ಲಿಸ್ಟ್ ಮಾಡಿರೋದಿಲ್ಲ. ಆ ರೀತಿ ಕಳ್ಸಿರ್ಲಿಲ್ಲ ಅಂದ್ರೆ
ಕಾಲ್ ಮಾಡಿದ್ದಾರೆ.
ಯಾವಾಗ ಮಾಡಿದ್ದಾರೆ?
1/4.
ಮತ್ತೆ ಅವಾಗ ಆರ್ಡರ್ ಆಗಿರೋದು 28ರಿಂದ. Registration issue, reminder for TCRs, list of the receipt of TCRs.
Cell number 6 adjourned. Cell number 7.
Five ಆಗಿತ್ತಾ?
Oh, sorry.
Five ಕರ್ದಿಸ್ರಾ?
I have cross appeal, I have filed cross.
Oh, sorry.
Five ಕರ್ದಿಸ್ರಾ?
Cell number 5, Maruti G.
Paper publication in respect of R1 and R2. I1 of 2021 and 24 for paper publication. ಏನಂತ ಬಂದಿದೆ ಅವ್ರದ್ದು ನೋಟಿಸ್? Our different address of this is shown in the opinion. Before the trial court, appearance counsel shall take notice to the aforesaid addresses. Officer. I1 is. Have taken steps ಏನಂತ ಬಂದಿದೆ ಅಲ್ಲಿ ಹೋಗಿದ್ದು? ನೋಟಿಸ್ ಹೋಗಿತ್ತ? Awaiting service ಅಂತ. ಯಾವತ್ತು ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ ನಾನು? ಅಲ್ಲ ಈಗ ನಾವು ಅಲ್ಲ ಕರೆಕ್ಟ್ ಆದ ಅಡ್ರೆಸ್ ವಿರಯನ್ಸ್ ಇತ್ತು, ಅದಕ್ಕೆ ನಾವು ಲಾಸ್ಟ್ ಟೈಮ್ ಬೇರೆ ಅಲ್ಲ ಯಾವಾಗ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ? 7/8 ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ. Registration verify the status of service of notice of R1 and R2 on postal track. List of date.
Postal track.
No,
23.
Postal track.
23/9.
23.
Cell number 6 adjourned. Cell number 7.
7 ಅಲ್ಲಿ that I am appearing for the appellant maldat ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಪೇಪರ್ ಬುಕ್ ಅಂತಿದೆ that suit is one for specific performance filed by the respondent maldat. The refund ಗೆ the decree has been passed in so far as was that rate of interest is % maldat. To that extent we have questioning that maldat. At the time of passing the interim order maldat, this honorable court has to direct to deposit the amount 59 lakh plus 8% interest. So it is around about 15 lakh and add agutte. We have deposited the 15 lakh rupees maldat. So your lordship paper book may kindly be dispensed maldat.
2022.
ಅವರೊಂದು ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದಾರೆ.
Cross appeal, seeking for specific performance.
Yeah, file cross appeal also.
Yes, my lord, it may be directed to accept notice in respect of respondent, this cross appeal.
Then, sir, do you take notice to them? ತಗೊಳ್ತೀರಾ ಅದ್ರಲ್ಲಿ?
ಕಾಪಿ ಸರ್ವಿಸ್ ಮಾಡಿಲ್ಲ.
ಕರೆಕ್ಟ್ ನೀವು ತಗೊಳ್ತೀರಿ ಅಂದ್ರೆ ಸರ್ವ್ ಮಾಡಕ್ ಹೇಳ್ತೀವಿ, ಇಲ್ಲ ಸುಮ್ಮನೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಬೇಕು ನಿಮ್ಮ ಮೇಲೆ.
Please ಮಾಡಿ.
You file the paper book and we will issue notice in the
So
connect.
for the requesting your lordship may kindly say that's a short point ಅದಕ್ಕೆ paper book dispense
Correct,
ಮಾಡಿದ್ದಾರೆ.
ಏನ್ ಮಾಡ್ತೀರಿ ನೆಕ್ಸ್ಟ್ ಕೇಸ್ ಅಲ್ಲಿ ನೋಟಿಸ್ ತಗೊಳ್ತೀರಾ ಅಥವಾ
Please,
ನೋಟಿಸ್
ma'am.
ಆರ್ಡರ್ ಮಾಡ್ಬೇಕು?
I will accept the notice and so far as the paper book is concerned mother dispense ಮಾಡಬಹುದು.
ಬೇಕಾಗುತ್ತೆ ಎಲ್ಲ ಎವಿಡೆನ್ಸ್ ನೋಡ್ಬೇಕಾಗುತ್ತೆ ಅಲ್ವಾ? ಏನು there are 6 witnesses,
Please
13
mother.
plus 3, 16 documents.
ಹೌದು ಅವ್ರ ಮೂರೇ ವಿಟ್ನೆಸ್ ಅದಾವೆ, ನಮ್ಮ 3 ವ್ಯಕ್ತಿ.
ಎಷ್ಟು ದಿವಸದಲ್ಲಿ ಹಾಕ್ತೀವಿ? 2 weeks.
But I sought for not to alienate the property during.
ನಿಮ್ಮದ್ರಲ್ಲಿ ಬರೋಣ, ಅದ್ರಲ್ಲಿ ನೋಡೋಣ ಮೊದಲು.
Cross up.
At
And
least 10 days time is
And
granted.
your lordship may grant 2 weeks time, paper book ಗೆ.
ಹಾಗಾದ್ರೆ ಅದ್ರ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ till next hearing date ಒಂದು ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ.
Please.
ನೀವು ನೋಟಿಸ್ ತಗೊಳ್ಳಿಲ್ಲ ಅಂದ್ರೆ ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ.
ಇಲ್ಲ, I will accept the notice for the,
Finally 2 weeks time is granted to file the paper books. ಅದರಲ್ಲಿ ಫಸ್ಟ್ 7 ನಲ್ಲಿ 7.1 cross subsection ಇದೆ. All respondents, there are many respondents.
Defendants, both the appellants in the first appeal.
Shri.
ನಾನು ಹಂಸ ಪರವಾಗಿ
ಸ್ವಲ್ಪ learned
ಅಲ್ವಾ?
person. Under-
ಹಂಸ that respond number 1 ಮಾಡಿದೆ.
ಅಲ್ಲ ನೀವು ಒಬ್ಬರಿಗೆ ಮಾತ್ರ ಅಪೀಲ್ ಆಗ್ತಿರೋದಾ? ಅಪೀಲ್ ಒಬ್ಬರೇ ಹಾಕಿದಾರಾ?
ಹೌದು, ಅಪೀಲ್ ಒಬ್ಬರಿಗೆ ಹಾಕಿದ್ದೀನಿ.
Just see this.
ಅದರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ
Three respondents,
notice has to go.
ಇಲ್ಲ ಅದರ್ಸ್
Three
ಅಂತ ಇದೆ ಅಲ್ಲ.
three appellants on case.
ಇದಾರ
ಹಾ, ಯಾರು? ಹಂಸ, ಹರ್ಷ, ಸುನಂದ.
Sunanda.
ಹಂಸ, ಹರ್ಷ.
Temple.
Same parties are there.
ಪ್ಲೀಸ್ ಮಾಡಿ.
Undertakes to appear for responding 1 to 3 is permitted to file the wakalat in the registry within 2 weeks. The appellant's his name shall be shown in the process accordingly. Appellant's counsel shall serve the copies on him. ಇದರಲ್ಲಿ not to alienate ಅಂತನಾ? Whether they undertake, alienate ಮಾಡೋದಿಲ್ಲ ಅಂತ undertaking ಏನಾರ ಕೊಡ್ತಾರಾ?
ಪ್ಲೀಸ್ ಮಾಡಿ.
His apprehension is that you are likely to alienate the property.
ಇಲ್ಲ, ಅದರಲ್ಲಿ that so far as the decree, so in so far as specific purpose is concerned, suit was dismissed ಮಾಡಿದೆ. That only so far as the refund of amount ಮಾಡಿದೆ. We already deposit that entire amount ಮಾಡಿದೆ.
Claiming to them are hereby restrained till next hearing date from alienating the suit schedule property in any manner. We have granted only till next hearing date. If you want to file objection, you file up.
Please me, please me.
Cell number 8.
And so far as the paper book 2 weeks ma'am. Please ma'am.
Cell number 8, TM Venkat Reddy.
7.1 list of 2 weeks.
Lordship, appearing on behalf of appellants.
Sir, R4 and R5 you have to take.
Yes, R4 and R5 are actually family members of all the respondents, my lord. The husband ಗೆ serve ಆಗಿದೆ, wife ಗೆ serve ಆಗಿಲ್ಲ. And when they had executed,
What you want us to do?
ಅಲ್ಲ ಅಡ್ರೆಸ್ ಅದೇ my lords, but
Husband and ಅಷ್ಟೇ ಪಾರ್ಟಿ ಮಾಡಿ, wife ನ delete ಮಾಡಿಬಿಡಿ.
ಇಲ್ಲ,
Why did you
OS ಅಲ್ಲಿ ಅವ್ರು ಅಷ್ಟು ಜನ ಎಕ್ಸ್ಪರ್ಟ್ ಆಗಿದ್ರು.
But you did not seek dispensation at the initial stage.
Yes.
Ex-parte ಆಗಿದ್ರೆ work out. At request finally 2 weeks time is granted to do the needful in respect of this 1, 4 and 5, failing which appeal against them shall stand. Yes.
Much obliged.
Cell number 9, Vasant Madhava S. L. Subramani.
ಮಾಡ್ತಾರೆ. Paper. ಏನೋ exhibits ಹಾಕಿಲ್ಲ ಅಂತ.
I request your lordships to turn to appeal memo only, page number 25, internal page or page 37, my lord.
What are exhibit P23 to 30?
ಅಷ್ಟೇ ಅಲ್ಲ, page number 25, internal page ನೋಡ್ಬಿಟ್ರೆ, the GP holder of the plaintiff has been examined as PW1 and rendered upon 22 documents. ಆ 22 documents produce ಮಾಡಿದ್ದೀನಿ.
Send
Paragraph 21, my lord.
cash remittance slips, encumbrance certificate, approved layout plan, endorsement.
ಅಲ್ಲ, ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೆ 21 ಡಾಕ್ಯುಮೆಂಟ್.
P5 ಹಾಕಿಲ್ಲ ಅಂತ acknowledge.
ಅಲ್ಲ
Copies of ಇದು ಬೇಕಾಗ್ಬೋದಲ್ಲ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಒಂದ್ ನಿಮಿಷ. ಅಲ್ಲ, ಪೇಜ್ ನಂಬರ್ 25 ಇಂಟರ್ನಲ್ ಪೇಜ್ ತಾವು ನೋಡ್ಬಿಟ್ರೆ ಒಂದ್ ನಿಮಿಷ. ಜಜ್ಮೆಂಟ್ 25,
Page 25.
ಪೇಜ್ ನಂಬರ್ 37, ಇಂಕ್ ಪೇಜ್ 37. ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋದೇ 22 ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
P holder has been examined as PW1 and relied on 22 documents. P1.
ಅಲ್ಲಿ 3 ಜಡ್ಜ್ಮೆಂಟ್ ಒಂದೇ ದಿವಸ ಮಾಡಿದ್ದಾರೆ. ದಿ documents referred in after the judgment is in RFA 166.
ತಪ್ಪಿದೆಯಾ ಅವರೇನೋ?
ಹೌದು ಅಲ್ಲ, 166 ತಮ್ಮ ಮುಂದೆ ಇದೆ. ಅದರಲ್ಲಿ ಇರೋದನ್ನ ಇದರಲ್ಲಿ ಬೈ ಮಿಸ್ಟೇಕ್ ಇಟ್ ಇಸ್ ಬಟ್
ಇಲ್ಲ ಅಂದ್ರೆ will dispense with. Yeah, counsel for the respondent.
Yes,
It
madam.
is been
159
submitted.
ಅವ್ರಿಗೆ
There is an error in the annexure of the judgment. Exhibit-
ಮೈಲಾರಪ್ಪ ಅವ್ರ ಕೇಸ್.
Exhibits number
ಇಲ್ಲ,
actually.
166 ಅಲ್ಲಿ 55 exhibits ಇದೆ sir.
1057.
159 ಮಾತ್ರ.
OS number 1057 of 2017.
1000, my case is OS number 1056 of 17.
1056
of 17.
ಯಾರಿದ್ರು 1057 ಅಲ್ಲಿ ಇದ್ದವ್ರು ಯಾರು?
ಮೈಲರಪ್ಪ.
159 ಅಲ್ಲಿ ನಾವಿದ್ದೀವಿ.
ಅದೇ ಅದರಲ್ಲೇ ಮಿಸ್ಟೇಕ್ ಆಗಿರೋದು ಅಂತ.
ಇಲ್ಲ ನಾವು ಮಾರ್ಕ್ ಮಾಡಿದೀವಿ 1 to 57.
ಎಲ್ ಸುಬ್ರಹ್ಮಣ್ಯ ಅಂತ ಪೇರ್ ಆಗ್ತಾ ಇದೆ.
ಹೌದು ಸರ್ ನಾವು.
ಇದರಲ್ಲಿ he says only 22 exhibits were marked, but in the judgment annexure wrongly that is shown as 55.
ನಮ್ ಸೈಡ್ 22 ಆಯ್ತು ಸ್ವಾಮಿ. ಮತ್ತೆ ಕ್ರಾಸ್ ಮಾಡುವಾಗ ಅವ್ರು ಒಪ್ಕೊಂಡಿರೋದ್ರಲ್ಲಿ
Confront ಮಾಡಿ.
ಅಡ್ಮಿಟೆಡ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆ.
ಅಲ್ಲ ಅದು D1 ಅಲ್ಲಿ ಡಿ ಅಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿದ್ದಾರೆ. ಅಲ್ಲ ಐ ರಿಕ್ವೆಸ್ಟ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ದಯವಿಟ್ಟು ಈ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಬಂದ್ರೆ ಇದೆಲ್ಲ ಬೇರೆ ಕೇಸ್ದು ಇದರಲ್ಲಿ ಹಾಕಿರೋದು ಅಷ್ಟೇ ಸ್ವಾಮಿ. ಐ ರಿಕ್ವೆಸ್ಟ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಟು ಟರ್ನ್ ಟು ಬಂದಿದೆ ಸ್ವಾಮಿ.
PW ನೇನು
ಯಾಕಂದ್ರೆ ನಾವು ರಿಜಿಸ್ಟ್ರಿಗೆ ಚೆಕ್ ಮಾಡಂತ ಹೇಳ್ತೀವಿ ಬರ್ಕೊಂಡು.
PW ನೇನು ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ರೆ ಅದನ್ನ
ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಕೇಸಸ್
ಅಲ್ಲ ಇಲ್ಲಿ ಅದಕ್ಕೇನೆ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಮೇ ಫಿಕ್ಸ್ ಇಟ್ ಆನ್ 17th or 18th. ಐ ವಿಲ್ ಆಲ್ಸೋ ಕೋಆರ್ಡಿನೇಟ್ ಇನ್ ದಿ ರಿಜಿಸ್ಟ್ರಿ.
ಪೇಜ್ ನಂಬರ್ ಎಷ್ಟದು?
ದಿ ಪೇಜ್ ನಂಬರ್ ಡಾಕ್ಯುಮೆಂಟ್ ನಂಬರ್ 23 to
ಪ್ಯಾರಾ ನಂಬರ್ ಯಾವುದು?
21 ಸ್ವಾಮಿ. 21 of the judgment.
Page number 21 para.
21 ಅಲ್ಲ.
Page number 20.
Page number 25 of judgment, in page 37.
Page number 25.
25 paragraph 21.
Para 21 of the impugned judgment submits that before the trial court only exhibit P1 to P22 were marked on behalf of the plaintiff. And there is an error in the judgment, annexure of the judgment. ನೀವೇ DW1 ಕನ್ಫ್ರಂಟ್ ಮಾಡಿ ಮಾರ್ಕ್ ಮಾಡಿಸಿದಿರಾ ಅಂತ ಅಲ್ಲಿ ಬಂದಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 50 ಪ್ಯಾರಾ 51 ಪೇಜ್ ನಂಬರ್ ಎಷ್ಟು? 59.
Really?
Page number 59 internal. It's also evident that DW1 admits
Hello, sir.
work order
Hello.
with respect to also their land as per exhibit P28.
My request to your lordships is,
Just ಚೆಕ್ ಮಾಡ್ತಾರೆ ಎಷ್ಟು ಮಾರ್ಕ್ ಆಗಿತ್ತು ಅಂತ ಹೇಳಿ. ರೆಕಾರ್ಡ್ಸ್ TCRs ನಲ್ಲಿ ಇರುತ್ತಲ್ಲ.
It is already a marker, my lord, that is in the page, even the judgment, page
Error in the annexure of the
60,
judgment.
60 and 61
showing-
discloses the marking of the documents attached with the judgment.
P ಅದು ಮುಂದಿನಷ್ಟು P1 to ಎಷ್ಟಾಗಿತ್ತು ಅಂತ ಹೇಳ್ತಾರೆ? 22. P23
22
23 ನಿಮ್ ಪ್ರಕಾರ 22 ಅಷ್ಟಾಗಿದೆ.
ಅಲ್ಲ ಅಲ್ಲಿ ಇರೋದು ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳೋದೇ ಹಾಗೆ.
23 to 55. Registry shall verify from the trial court records whether exhibit P
23 to
23 to 25 are marked. 23 to 55 were marked and found in the trial court in the records and submit.
My lord is
Submit
9.1, that is RFA, that is 164 bar
submit
2000.
within 1 week ಅಂತ ಮಾಡಿ.
2 submit, that is the 164 euro, my lord.
9.1 ಅಲ್ಲಿ.
That is, I filed applications for the release the amount it was deposited by the appellant, my lord. And
I'll
it is
file my-
filed, it is filed even to more than 6 months. my
I'll
lord.
file
It is
my
there.
statement of objections. It is ready. Sign but I'll see it that it is.
My lord,
Lordships
that
may take
that
it up on
he is
17th.
enjoying the same. In the 3 cases, the lordships is pass orders to deposit of monthly of 75,000 every month. See, there is the beneficiaries. The appellant is the beneficiaries to get the rents from the tenants. And also he leased out to the even to
The
the.
appellant seeks time to comply the office objection. Last time, Lord Counsel for response seriously opposed judgment. As a final chance, 10 days time is granted on payment of cost of rupees 2,000. ಯಾಕೆ ಇವ್ರೆ ನೀವು ಬರೀ ಇದ್ರಲ್ಲಿ
Yeah, ಮಾಡ್ತೀನಿ. I'll see that it is fine. ಯಾಕೆ ಸ್ವಾಮಿ?
And
ಅಲ್ಲ ಕಾಸ್ಟ್ ಇದು
ಅಲ್ಲ ನಾನು ಕೊಟ್ಟಾಯ್ತು ಲಾಸ್ಟ್ ಟೈಮ್.
ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀರಿ. Why ಈಗ?
ಅಲ್ಲ this was the problem, my lord.
Application is filed subsequently. When did you file?
ಅಲ್ಲ he has filed it.
my lord is after passing of the orders, the deposit, I filed my lord on the 12 January 2024.
1 January 2024.
Yes, my lord.
It was not listed?
That
It was not listed?
ಇಲ್ಲ ಇವತ್ತೇ ಬಂದಿರೋದು ಫಸ್ಟ್ ಟೈಮ್ ಲಾಸ್ಟ್ ಟೈಮ್.
it is even the last occasion, it is also the notified.
ಹೇಗಿದ್ರು ಅದಕ್ಕೆ ಒಂದು ವಾರ ಟೈಮ್ ಕೊಟ್ಟಿದೀವಲ್ಲ, ಇದಕ್ಕೆ ಒಂದು ವಾರ ಟೈಮ್ ಕೊಡ. Next week ಅಲ್ಲ.
17th ಅಂತ.
My lord, it is more than 10 lakhs is kept under the
The appellant seeks time.
account of this honorable court.
I have 1 of 2024. Okay. 9.1. List on date hearing.
17th, 18th, if your lordship.
19th, office subject, I'm sorry, counter shall be, counter to I1 of 2024 shall be filed within that time.
Please.
9.2 ನಲ್ಲಿ ಏನದು TCS kept.
ಏನಿಲ್ಲ ಅಷ್ಟೇ.
TCR.
Yes, next.
Cell number 10, R Shashidhara, P Vijay Kumar.
There is office subsection and memo.
I withdraw that memo, my lords.
You are withdrawing that memo.
I am withdrawing that memo, my lords.
It is filed by you only.
Yes, my lords. By oversight, in my case only, I am filed the memo.
Connected as ilvalla.
Connected ಇದೆ.
ಅಲ್ಲ ಇದೆ ಇದೆ.
MFA 176/23 is the appeal filed by the insurance.
KSRTC.
Submit that memo disposed as withdrawn. Recording the submission memo is.
It may be posted along with MFA 176/2023.
One submission, my lord.
The matter. Hey.
One submission, my lord.
Yes, yes. Hey.
My lord, my name may be deleted for R2 because Mr. G. Lakshmi Rao has filed appeal on behalf of KSRTC.
Three, who is R3? R3.
SV Hegde is there. Well, R2 and R3 both are KSRTC.
ಇಬ್ಬರಿಗೂ ತಗೊಂಡಿದ್ರಾ ನೀವು notice?
Both are KSRTC.
R2 and 3.
SV Hegde, R5 and.
R2 and 3. R2 is managing director KSRTC, chairman KSRTC, na?
So both are one and same.
It is submitted that Lakshmi Shah Learned Council has filed appeal in MFA number
176/23, 2023.
That is by response 2 and 3 hearing. Therefore, he is requested to accept notice in this case for response number 2 and 3. His name shall be shown in the copies accordingly. You serve the copies.
Please.
Appellant's counsel shall serve the copies on him. Name of D. Vijay Kumar shall be deleted.
Much obliged.
List along with MFA number
176/2023.
number of.
Bill number 11, KV Satish Chandra.
Appellant in this matter.
Permission.
Notice of this court is already served on the respondent, my lord. Same is reflected in the,
Sufficient address ಅಂತ ಬಂದಿದೆ ಅಂತಲ್ಲ.
but in website it's showing it's served on the respondent, my lord.
Postal share ಇಲ್ಲಿ ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ಯಾವ ವೆಬ್ಸೈಟ್ ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ ಇನ್ಸಫಿಷಿಯಂಟ್ that request
ನಮ್ಮ-
is granted to do. Yes.
Bill number 12, Vijay Kumar T, SV Hegde Mulkan.
Second set of appeal memo to be filed. Okay,
A week's time may be granted.
ಇನ್ನೊಂದ್ರಲ್ಲಿ ಇದು ಕೊಡ್ಬೇಕು ಸೆಕೆಂಡ್ ಸೆಟ್ ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಹೇಗ್ರಿ?
I'll file the counter, my lordship. Kindly a week's time may be granted.
ಎರಡರಲ್ಲೂ ಅಷ್ಟೇ. ಇನ್ನೊಂದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಹೆಗ್ಡೆ ಉಳ್ಕೊಂಡು ಅವ್ರು ತಗೋಬೇಕು ನೋಟಿಸ್.
Lordship placed the expert before the
Who was placed expert in?
respondent number,
Your lordship was placed expert in.
respondent number 2, my lordship,
ಆಗಿದೆ ಆರ್ಡರ್
in
ಆಗಿದೆ.
connected appeal.
Second set of appeal memo to. be
Please,
filed.
I will file that. Any date may be given in next,
2 weeks. You file it.
please.
Cell number 13, Suresh K, Pawan Chandra Shetty.
I appear for the appellant, my lord. 2 weeks time may kindly be granted. I file an application for sub-service by paper publication, my lord.
Request 2 weeks time is granted to the at 12.1 ನಲ್ಲಿ ಹಿಂಗ್ ಮಾಡ್ಕೊಳ್ಳಿ. No representation for the appellant. Finally, 2 weeks time is granted to do the needful, failing which appeal against R1 shall, R2 shall stand dismissed. 1.1 ನಲ್ಲಿ.
Cell number 14, Suresh Latur.
Permission of first set of I1 of to issue notice to R2, memo for issue notice to R1.
Second set up.
Who is second set of the notice to R2 notice ಕೊಡೋದು.
Expert.
Satish Kumar. Totally expert. Section ಏನಾಗಿದೆ? ಆಗ್ಲೇ ಅನ್ನೋದು. Respond number 1 had not contested the matter before the trial. Response or joint. Under the impugned order, liability is fastened to respond number 2, the insurer. Therefore, notice to respond number 1 is dispensed with as paid. No is disposed of accordingly. 2 weeks time is granted to the in respect of respond number 2.
Seal number 15, Shantraj K.
Second, your representation for the appellant. Finally, 2 weeks. Finally, 2 weeks time is granted to do the in respect of respond number 2, failing which appeal against it.
Seal number 16, Nagaraj Hegde. 45 rupees.
45 rupees deficit ಇದೆ ಅಂತ
ಮಾಡಿದ್ದೆ ಕಟ್ಟಿದ್ದೇವೆ ಸ್ವಾಮಿ
That request 2 weeks time is granted.
ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದೆ ಕಂಪ್ಲೈಂಟ್
ಇಲ್ಲಿ ಬಂದಿಲ್ಲ ಇದ್ರೆ ನೋಡಿ ಎಲ್ಲಿ ಮಾಡಿರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಮಾಡಿ.
ಇಲ್ಲ ಸ್ವಾಮಿ ಮಾಡಿದ್ದೆ.
Yes, next.
Seal number 17, Jagan Mohan MT.
Lord, matter appellant residing same address. Notice March ಅಲ್ಲಿ issue ಆಗಿದೆ. June ಅಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ, ಸೇಮ್ ಅಡ್ರೆಸ್ ತೋರಿಸಿ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. ಅದು ನಾಟ್ ಫೌಂಡ್ ಅಂತ ಬಂದಿದೆ. ಇಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್ ಸೇಮ್ ಇದು ಮಾಡಿದ್ದಾರೆ.
Execution case ಅಲ್ಲೇ ಸರ್ವ್ ಮಾಡಿದ್ರಿ ಹಾಗಿದ್ರೆ. Yes, sir. Defendant number 1. Defendant ಒಬ್ಬರೇ defendant ಇದ್ದಾರೆ.
For recovery of money now, execution filed by showing same address. ಅದು ನಾಟ್ ಫೌಂಡ್ ಅಂತ ಬಂದಿದೆ. ಅದು ಹೇಳಿದ್ರು ಸಫಿಶಿಯಂಟ್ ಅಂತ ಹೇಳಿ ಮಾಡೋದು. ನಾವು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
ಅಕೌಂಟ್ ಅಂದ್ರೆ ಹೇಗ್ರಿ ಸಫಿಶಿಯಂಟ್ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡೋದು? ಇದು ಯಾವ ಜೂರಿಸ್ಪ್ರುಡೆನ್ಸ್?
ಅಲ್ಲ, ಸೇಮ್ ಅಡ್ರೆಸ್ ಅಲ್ಲೇ ಇದಾರೆ. ಅವ್ರು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಫೈಲ್ ಮಾಡಿ ನೋಟಿಸ್ ಇಶ್ಯೂ ಆದ್ಮೇಲೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಫೈಲ್ ಮಾಡಿದ್ರೆ ಸೇಮ್ ಅಡ್ರೆಸ್
ಅಕೌಂಟ್ ಅಂತ ಬಂದ್ರೆ ಸಫಿಶಿಯಂಟ್ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಬೇಕು ಅನ್ನೋದು ಎಲ್ಲಿ ನಾವು ನಾಟ್ ರೆಡ್ ದಿಸ್ ಕೈಂಡ್ ಆಫ್
ವಿಲ್ಫುಲ್ಲಿ ಅವಾಯ್ಡ್ ಅಂತ ಮಾಡುತ್ತೆ ಇರುತ್ತೆ.
ವಿಲ್ಫುಲ್ಲಿ ಅವಾಯ್ಡ್ ಮಾಡಿದ್ರೆ ವಾಟ್ ಸ್ಟೆಪ್ಸ್ ಯು ಹ್ಯಾವ್ ಟು ಟೇಕ್, ಯು ಹ್ಯಾವ್ ಟು ಟೇಕ್. ಹೌ ಕ್ಯಾನ್ ಯು ಆಸ್ಕ್ ದ ಕೋರ್ಟ್ ಟು ಹೋಲ್ಡ್ ಇಟ್ ಸಫಿಶಿಯಂಟ್? There was only one defendant.
ಒಂದೇ ಒಬ್ಬರೇ ರೆಸ್ಪಾಂಡೆಂಟ್.
ಇಲ್ಲ, ಯಾರೋ ಬ್ರಾಂಚ್ ಮ್ಯಾನೇಜರ್.
ಎರಡು ಬೇರೆ ಬೇರೆ ಇದೆ.
ಇಲ್ಲ, ಸೇಮ್ ಅಡ್ರೆಸ್.
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ನೀವು ಅಪೋಸಿಟ್ ಸತಿ ಟೆಂಪಲ್ ಅಂತ ಇಟ್ಟಿದ್ರಿ, ಇದು ಸಾಯಿ ಟೆಂಪಲ್ ಅಂತ ಇದೆ.
OS 202 of 2020 ಅಲ್ಲಿ more than one defendants ಇದ್ರು. That is correct.
ಸೇಮ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಸೇಮ್ ಅಡ್ರೆಸ್.
If they have filed execution ಅಂದ್ರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ ಅಡ್ರೆಸ್ ಕೊಟ್ಟಿದ್ರು ತಾನೆ. ಡಿಫೆಂಡೆಂಟ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಅಲ್ವಾ?
ಒಬ್ರೇ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇರೋದು.
ಇಲ್ಲ, ಇದ್ರಲ್ಲಿ ಉಳ್ದವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ವಾ ನೀವು? 2 and 3 VP ಎಕ್ಸ್ಟೆನ್ಷನ್ ಮೇನ್ ರೋಡ್ ಅಪೋಸಿಟ್ ಸೈಡ್.
ಇಲ್ಲ, ಒಬ್ರೇ ಪ್ಲೇಂಟಿಫ್, ಒಬ್ರೇ ಡಿಫೆಂಡೆಂಟ್
ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ.
ಅದು ಡಿಫೆಂಡೆಂಟ್ 2 ಮೇಲೆ ರೆಸ್ಪಾಂಡೆಂಟ್ 2 ಮೇಲೆ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಸೂಟ್. ಅದು
ಶ್ರೀ ದೇವರಾಜ್ ಅರಸ್ ಎಕ್ಸ್ಟೆನ್ಷನ್
ಅಲ್ಲ, ಅದು ಅಪೆಲೆಂಟ್ ಅಡ್ರೆಸ್. ಇದು ರೆಸ್ಪಾಂಡೆಂಟ್. ಇದು ನನ್ನ
KN ರಾಜು ಅಂದ್ರೆ ರೆಸ್ಪಾಂಡೆಂಟ್.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಹೌದು.
ಮತ್ತೆ ಅದನ್ನ ಓದ್ತಾ ಇದ್ದೀನಿ.
ಸಿವಿಲ್ ಕಾಂಟ್ರಾಕ್ಟರ್ ರೆಸಿಡೆಂಟ್ ಶ್ರೀ ದೇವರಾಜ್ ಅರಸ್ ಎಕ್ಸ್ಟೆನ್ಷನ್, ಸಿ ಬ್ಲಾಕ್ 6th ಕ್ರಾಸ್, ದಾವಣಗೆರೆ.
Execution proceedings and evading notice. If needful is done, execution petition, execution case number 97 of 2024. Same court alwa, first edition before the trial court, and evading the service. If needful is done, you have to pay the process fee, but issue notice to the respondent.
Like at least ಸ್ಟೇ ಕೇಳಿದೀವಿ. ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆದ್ರೂ ಸ್ಟೇ ಆಗ್ಲಿ, ಫರ್ದರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್.
ಈಗ ಒಂದ್ಸರಿ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ, ನೀವು ಬೇಕಂದ್ರೆ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ತಗೊಳ್ಳಿ. ಆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲೇ ನೋಟಿಸ್ ಸರ್ವ್ ಮಾಡೋದಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ. through the execution court in execution number 97 of 2027. ಈ ಕಾಪಿನ ಮೆಮೊ ಹಾಕೊಡಿ. List on date
30th 39. Number 18, Jwala Kumar ಅವರಿಗೆ ಅರ್ಜಿ.
I appear for the appellant, my lord. My lord, respondent number 4 is BMTC. Any panel advocate or D Vijay Kumar may be permitted to serve the copy to him.
Non-furnished 50% deposit. 50%
Like that, one week's time may be granted. I will ascertain and keep him.
ಇದರಲ್ಲಿ 4 and 5.
Respondent number 4 is BMTC.
4 is managing director and 5 is some private person.
Private party. For 5, I will take steps.
ನಾವೀಗ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಕೊಡೋದಿಲ್ಲ, ಯಾಕಂದ್ರೆ ಕೊಟ್ರೆ ಅವ್ರನ್ನೇ ಎಂಗೇಜ್ ಮಾಡ್ತಾ ಇಲ್ಲ, ಬೇರೆಯವ್ರನ್ನೆಲ್ಲ.
Then I'll take steps, madam.
Request to which is granted to the yes.
Seal number 19, GS Marlaya, HC Shivramu.
Company appeal. 73 lakhs awarded. Quantum challenged. Kindly ready to pay.
Furnished
Deposit.
PF ಅಂತ ಇದೆ ಏನ್ರಿ?
Also at stay may on that.
ಸ್ಟೇ ಆಗಿ ನೋಟಿಸ್ ಆಗಿತ್ತು.
Summon serve ಆಗಿದೆ ಪದ್ಯ appeared.
ಸಮನ್ ಸರ್ವ್ ಆಗಿದೆ.
Sir, Shivaram is here.
ಮತ್ತೆ ಇದು ಯಾರಿಗೆ? R4
R4 owner is R4 is the owner.
ಕ್ಲೇಮೆಂಟ್ಸ್.
Climate serve ಆಗಿದೆ is appeared.
ಏನು
Case of death, my lord, 73 lakhs rupees has been
50%
awarded.
ಡೆಪಾಸಿಟ್ ಮಾಡಿ ಸ್ಟೇ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
Yes, ma'am.
ಕಂಡೀಷನ್.
Yes, sir. And that may be ordered to be released in the immediately after release of.
ಅಲ್ಲ
ಯುವರ್ ಪ್ರೇಯರ್ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತಾರೆ ಅನ್ನೋದೇ.
ಆಕ್ಚುಲಿ 1/3 ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ.
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಎಕ್ಸಿಕ್ಯೂಷನ್.
Execution ಇನ್ನೂ ಆಗ್ತಿಲ್ಲ.
ಇಲ್ಲ ಆಕ್ಟಿವ್ ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ ಅಲ್ಲಿ ಮೈಸೂರಿನಲ್ಲಿ.
ಆಗಿಲ್ಲ ಇನ್ನು.
R4 ನೋಟಿಸ್ ಮೊದಲು ಫಸ್ಟ್ ಟೈಮ್ ಯು ಹ್ಯಾವ್ ನಾಟ್.
R4 is the owner.
ಅಲ್ಲ ನೀವು ಅದನ್ನ ಇನ್ಸಿಸ್ಟ್ ಮಾಡಿಲ್ಲ, ಫಸ್ಟ್ ಟೈಮ್ ನೋಟಿಸ್ ಮಾಡೋದಕ್ಕೆ ಆರ್ಡರ್ ಆಗಿದೆ.
ಹೌದು.
Many of
ಇಲ್ಲ ಇನ್ಸಿಸ್ಟ್
more particularly in motor accident cases and LIC cases, advocates do not appear. ನಾವೇ ಒಂದು ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಂತ ಹೇಳಿ.
ಇಲ್ಲ ನಾನು ಅಪಿಯರ್ ಆಗಿದ್ದೆ ಬಟ್ ನೋಟಿಸ್ ಹೋಗಿ ಬರ್ಲಿ ಎಮರ್ಜೆನ್ಸಿ ನೋಟಿಸ್ ಹೋಗಿ ಬರ್ಲಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟೆ ಮಾಡಿದ್ರು ಬಟ್ ದೇ ಆರ್ ಅಪಿಯರ್ಡ್ ನೀವು ಅಪೆಲೆಂಟ್ಸ್ ಅದಕ್ಕಾಗಿ ರೆಡಿ ಟು ಡೆಪಾಸಿಟ್ ಸ್ಟೇ ಮೇ ಕ್ಯಾನ್ ಲಿವ್ ಗ್ರಾಂಟೆಡ್.
ಅವ್ರದ್ದು ಸಬ್ಮಿಷನ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಳ್ತೀವಿ. 50% ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರೆ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡೋದಿಲ್ಲ ಅಂತ.
50%
ಅಲ್ಲ ಡೆಪಾಸಿಟ್
ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ. 50% subject to deposit of 50%.
the normal course this pass
Submits that response 1 to 3 are likely to execute the award and seeks interim stay.
Yes.
Under the circumstances, interim stay of the execution of the impugned award till next hearing date, subject to the appellant depositing 50% of the award amount before the tribunal within 4 weeks from the date of this order.
Yes, ma'am.
Okay, the next hearing date ವರ್ಗು ಮಾತ್ರ, ಯಾಕಂದ್ರೆ fourth respond 2 weeks time.
ಅಲ್ಲ ಅವರು ಇಸ್ ನಾಟ್ ನೆಸೆಸರಿ ಅನ್ಸುತ್ತೆ ಪಾರ್ಟಿ ಬೇಕಾಗಿಲ್ಲ. ಎಸ್ ಮ್ಯಾಮ್ ಐ ವಿಲ್.
Yes, we are fed up with this.
Yes.
ಬೇಡ ಅಂದ್ರೆ ಮೆಮೊ ಫೈಲ್ ಮಾಡ್ಬೇಕು. ಫೈಲ್ ಮಾಡ್ತೀರಾ ಇವತ್ತು?
ಇಲ್ಲ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ನೋಡಿ
ಅದಕ್ಕೊಂದು ಕ್ರೆಡಿಟ್. ಯಾಕೆ ಇಲ್ಲ ಒಂದು ಪೇಪರ್ ತಗೊಂಡು ಬರೆದು ಕೊಡ್ಬೋದಲ್ಲ? ಬೇಡ ನಮ್ಮ ಆಫೀಸರ್ ಮತ್ತೊಂದು ಸರಿ ಲಿಸ್ಟ್ ಮಾಡ್ಬೇಕು ಅದಕ್ಕೆ.
ಐ ವಿಲ್
ಗ್ರಾಂಟಿಂಗ್ ಅಬ್ಸಲ್ಯೂಟ್ ಸ್ಟೇ ಆಲ್ಸೋ.
ಐ ವಿಲ್ ಡೆಪಾಸಿಟ್ ದ ಅಮೌಂಟ್ ನೆಕ್ಸ್ಟ್ ಐ ವಿಲ್.
ಅದೇ ಶೂರ್ ಲಯಬಿಲಿಟಿ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದಾರಾ?
ಲಯಬಿಲಿಟಿ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡೋರು ಒಂದು ಸಲ ಜಾಸ್ತಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಇಲ್ಲ ಲಯಬಿಲಿಟಿ ಇಸ್ ನಾಟ್ ಡಿಸ್ಪ್ಯೂಟೆಡ್, ಕ್ವಾಂಟಮ್ ಇಸ್ ಡಿಸ್ಪ್ಯೂಟೆಡ್.
ಮತ್ತೆ ಅದಕ್ಕೆ
ಲಯಬಿಲಿಟಿ ಅಂದ್ರೆ ಕ್ವಾಂಟಮ್.
ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಮೆಮೊ ಫೈಲ್ ಮಾಡ್ಬೇಕು.
Liability Scotland Insurance Company.
ಲಯಬಿಲಿಟಿ ನಾಟ್ ಅಂಡರ್ ಡಿಸ್ಪ್ಯೂಟ್, ಕ್ವಾಂಟಮ್ ಇಸ್ ಅಂಡರ್ ಡಿಸ್ಪ್ಯೂಟ್.
ಹಾಗಿದ್ರೆ ಮೆಮೊ ಫೈಲ್ ಮಾಡಿ ಅಂತ
ಮಾಡ್ಬೇಕು
ಹೇಳ್ತಾರೆ. ಅದಕ್ಕೂ ರೆಡಿ ಇಲ್ಲ ಅವ್ರಿಗೆ. ಇಂಟರಿಮ್ ಸ್ಟೇ ಬರಿಬೇಡಿ ಅವ್ರಿಗೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ ಐ ವಿಲ್.
ಆಯ್ತು, ಲಿಸ್ಟ್ ಆಫ್
ಐ ವಿಲ್ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಐ ವಿಲ್. ಇಲ್ಲ ಐ ಆಮ್ ರೆಡಿ ಟು ಡೆಪಾಸಿಟ್ 50% ಮೈ ಲಾರ್ಡ್. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಐ ವಿಲ್.
ನೆಕ್ಸ್ಟ್ ಕರ್ಸಿ. ದಿಸ್ ಶುಡ್ ನಾಟ್ ಬಿ ದ ಆಟಿಟ್ಯೂಡ್ ಲರ್ನರ್ ಕೌನ್ಸಿಲ್.
ಮೈ ಲಾರ್ಡ್ ಐ ವಿಲ್. ಸಾರಿ ಮೈ ಲಾರ್ಡ್.
ಈಗ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿತ್ತಲ್ಲ, 2 weeks ಟೈಮ್ ಕೊಡ್ತೀವಿ, ಅವ್ರ ನೋಟಿಸ್ ತಗೊಳ್ಳಿ.
Yes, I will take the notice, my lord.
Seal number 20.
50% deposit may kindly be.
Seal number 20.
We are not the customers of insurance companies to impose conditions like this. Yes, next curse.
Seal number
For
20.
appellant, madam, will furnish a correct copy of appeal memo.
ಏನದು 5 sets issue notice. R1 to R5 first time at that. Just 2 weeks time is granted to me.
Please, ma'am.
Yes.
Seal number 21. Vijaya AM.
Waiting please.
Take notice for the respondent. Filing wakalat for respondent.
ಎರಡರಲ್ಲೂ ಸರ್.
One I am filing,
Yaake
other,
served
we will file in the other also.
ಕರೆಕ್ಟ್. ಯಾಕೆ ಸರ್ವ್ ಆಗಿಲ್ಲ, ಇಮಿಡಿಯೇಟ್ಲಿ ಅಪಿಯರ್ ಆಗಿಲ್ಲ, ಸರ್ವ್ಡ್ ಅನ್ರಿಪ್ರೆಸೆಂಟೆಡ್ ಅಂತ ಹೇಳಿ.
That is because I received it only yesterday.
ಆಯ್ತು, ಯು ಕ್ಯಾನ್ ಫೈಲ್ ಇಟ್ ಇನ್ ದ ರಿಜಿಸ್ಟ್ರಿ ಬೋತ್. ಎರಡು
Please.
ಏನು ಹೆಸರು ಹೇಳಿ?
Dilip Kumar.
Dilip Kumar.
Learned counsel undertakes to appear for the respondent in both the cases. He is permitted to file the wakalat in the registry within 10 days. ಅಲ್ಲಿ ಹಾಕ್ತೀರಾ? 10 days.
Please.
Within 10 days, his name shall be shown in the cause list accordingly. Copies ಬಂದಿದೆ ಅಲ್ಲ, ಸರ್ಡ್ ಅಂತ ಇದೆ ಅಲ್ಲ ಇದರಲ್ಲಿ.
Please, madam.
ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರ ಹತ್ರ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿಸ್ಕೊಳ್ಳಿ.
ಹೌದು.
ಎಸ್, ಇದರಲ್ಲಿ ಲಿಸ್ಟ್ ಆಫ್ಟರ್ ದ ರೆಸಿಪ್ಟ್ ಆಫ್ TCS ಬಂದಿಲ್ಲ. ಮೈಸೂರು ಕೋರ್ಟಾ? ಯಾವಾಗಿಂದ ಆರ್ಡರ್ ಆಗಿದೆ?
PCR called on 29/8.
29/8 ಹಾಗಾದ್ರೆ ಬಂದಿರೋದು ಲಿಸ್ಟ್ ಆಫ್ ರಿಸಿಪ್ಟ್ ಆಫ್ ರಿಸಿಪ್ಟ್
Interim order may be.
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್
Yes.
ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ದ ರೆಸ್ಪಾಂಡೆಂಟ್ ಸಬ್ಮಿಟ್ ಹಾ
Interim stay.
interim order granted earlier is extended till next meeting. Yes.
Hearing on IA, cell number 22, Murthy DL, Lalita PM.
Ma'am, for the appellant this matter, ma'am.
Yes.
22 and 22.2. And for the appellant.
22 for orders, further orders and IA 888 days delay na. And ಇದರಲ್ಲಿ second set of appeal to be filed. Dabali your second set ಹಾಕ್ಬೇಕಾ? 22.1 ನಲ್ಲಿ have to file. 22.2 ನಲ್ಲಿ
Ready, second set is ready, my lord.
further orders on CD of 820. Second set of appeal memo to be filed.
Second set is ready, my lord. If permit,
Both of you have to file. ಆಯ್ತು ಒಂದು ವಾರ ಟೈಮ್ ಕೊಡ್ತೀನಿ ಫೈಲ್ ಮಾಡಿ.
any date may be fixed, my lord.
2 weeks, 1 week time is granted. 2008.
Any date may be fixed, my lord, in the accident in the year 2014.
ಒಂದು ವಾರ ಆಗಿದೆ date this time.
21,
So that applications can be considered together ಎಲ್ಲದ್ರಲ್ಲಿ.
LCR.
21/9,
LCR. Dear. LCR.
21/9.
LCR.
ಮೊದಲು ಕಂಪ್ಲೈ ಮಾಡ್ರಿ, ಸೆಕೆಂಡ್ ಸೆಟ್ ಕೊಡದೇನೆ LCR ಕಾಲ್ ಫಾರ್ ಮಾಡೋದು ಡಿಲೇ ಇದೆ ಮತ್ತೆ 880 days. Next question.
Cell number 23,
2000.
Rangana movie, Anjaliya AB.
ನಂಗೆ ಇದೇನು ಈ ಕೇಸ್ ಏನು ಆ ಸೆಕ್ಷನ್ 444 ಆಫ್ ಕ್ರಿಮಿನಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ, ಇದೇ ಕೇಸಾ ಶ್ಯೂರಿಟಿ ಕೊಡೋದಕ್ಕೆ?
ಹೌದು 441A
ಅದೇ ಕ್ರಿಮಿನಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್ ಇಲ್ಲ ಅಪ್ಲೈ ಆಗುತ್ತೆ.
appellant file.
Learner Council, you have filed this application under section 441 CRPC. Security furnish ಮಾಡೋದ್ರೆ ಒಂದು ಅಫಿಡವಿಟ್ ಹಾಕಿ ಅವ್ರ ರೆಕಾರ್ಡ್ ಹಾಕ್ಬೇಕು. ಅಲ್ಲ ನಮ್ ಪ್ರಶ್ನೆಗೆ ಉತ್ತರ ಹೇಳಿ, CRPC ಇಲ್ಲಿ ಹೇಗ್ ಬರುತ್ತೆ ಅಂತ. You have filed it or anybody else ಬೇರೆ ಅಡ್ವೊಕೇಟ್ ಹಾಕಿರೋದ? ಶ್ಯೂರಿಟಿ ಅಡ್ವೊಕೇಟ್ ಸಿಗ್ನೇಚರ್ ಕೂಡ ಇಲ್ಲ ಇದಕ್ಕೆ. ಯಾವಾಗಿಲ್ಲ? 2023 ಏನಾದ್ರೂ ಆರ್ಡರ್ ಆಗಿತ್ತಾ ಇದ್ರ ಮೇಲೆ? This was 31/5/2023. Non-compliance of office subsection on 2/2023. Second set of IA to be filed. Adhe 2/2023. Now we'll dismiss this application. Not maintainable at all.
And also I am not able to execute my decree against the appellant matter because of this pending of
ಅವ್ರು ಇದು ಕೊಡ್ಬೇಕು.
proper application.
50%
Money decree.
Yes, sir. Subject to furnishing security for 50% of the decretal amount. In the date of that order, the said security shall be furnished to the satisfaction of the registrar judicial within 1 week ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ. ಅವತ್ತು 38 ಅಲ್ಲಿ. ಇನ್ನು ನೀವು
That one I will use the facilities because I could not able to contact the concerned person. He is out of pressure because he is between the virtual church. Could not able to do the necessary things.
on 30/8/2024. Interim stay is granted subject to furnishing security for payment of 50% of the decretal amount. Therefore, IA 2/2023, which is strangely filed under section 441A of the criminal procedure code to furnish security, does not survive and disposed of accordingly. 1 week ಆಯ್ತಾ ಈಗ? 38 ಅಂದ್ರೆ 1 week ಮುಗಿದೋಗಿದೆ ಅಲ್ಲ ಇವ್ರೆ? ಅವ್ರು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಬಿಡಿ ಹಾಗಿದ್ರೆ. Correct, 1 week time was granted. This is
ಇದು 1 ವರ್ಷದಿಂದ ಹೀಗೆ ಹೋಗ್ತಾ ಇದೆ ಸರ್.
appeal. 2023 appeal, now 1 year is over. Suit have year
2020.
2020. That contested or not?
Contested
Furnish it. At request, finally, 1 week extension is granted for compliance of the order dated 30/8/2024 regarding furnishing of the security. If needful is not done, the respondent decree holder is applicable.
One submission.
The decree.
Instead of security, kindly direct them to pay the, deposit the amount, my lord, because I can withdraw that amount.
ಆಗಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು, ಅದಕ್ಕೆ ಸೆಕ್ಯೂರಿಟಿ ಏನಾದ್ರು ಕೊಡ್ಲೇ
20 ಲಕ್ಷ ಇದೆ ಇದ್ರಲ್ಲಿ.
ಈಗ ಮಾಡಿಲ್ಲ ಆರ್ಡರ್ ನಾವು ಒಂದ್ ವಾರದಲ್ಲಿ ಅವ್ರು ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಕ್ಯಾನ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ವಿ ಆರ್
No, today is their execution petition, but trial court is getting scared to execute, issue the orders.
take today's order, take the copy of the today's order.
I
we can
am producing that
It's
order
not-
copy also before the trial court.
19.
Hmm.
19 Cell number 24, Suresh T. Deshpande, KV Hiremat.
Reading the exponent.
I one mark is filed by my mother. Maybe allowed me.
ಇದು ಒಂದು state ಇದು P&C. Why P&C was required for that?
The trial court observed that I have to take the. The thing is, my lord, my maternal aunt has executed the will. In the will, there is a recital that I should not alienate the property. For that, I filed a suit before the trial court for declaration.
When the order was, you have said in your application that mother should have been made a party and the court observe ಮಾಡಿದೆ.
Coordinate bench has orally directed me.
Orally
to
directed.
include the my mother as a respondent.
Order sign number 1 of 2025 filed by the respondent.
Pleadings.
The above application is filed by the mother of the appellant to include her as respondent. The appellant sought declaration alone in declaration in respect of a will said to be executed in favor of his father.
The father was the first beneficiary. After the death of my father, the property devolved upon me.
His father and he was also a beneficiary. Sentence filed. One Allah. Where he also claimed to be a beneficiary. The trial court has dismissed the said suit against which the above appeal is filed. The circumstances, the proposed respondent is necessary party. Therefore, the party to the proceedings, therefore application is allowed. The applicant is permitted to come on record as respondent in the above appeal. Appellant's counsel shall amend the constitution of the appeal memo and furnish the copy of the amended appeal memo accordingly. What is this 2 of 2024?
2 of 22 is
24 permission and
24. Permission to examine the attesting witness to.
that we have to, while hearing you, we have to consider.
Yes.
I 2 of 24 being the application for additional evidence shall be considered along with the main matter. ಇದರಲ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ವಾ? ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿ
Last night, kindly have next week, madam.
List.
Covered by the judgment of this honorable court. Such a recital is against to the public policy and section 10.
ಕರೆಕ್ಟ್ ಅದು ಮಾಡಕ್ ಬರೋದಿಲ್ಲ, ಮೊದಲು ಬಿಲ್ ಪ್ರೂವ್ ಆಗ್ಬೇಕಲ್ಲ. ನಾಟ್ ಎಕ್ಸಾಮಿನ್ ದಟ್ ಅಟೆಸ್ಟರ್ ಆಲ್ಸೋ ಇಟ್ ಹ್ಯಾಸ್, ಇಫ್ ಎಟ್ ಆಲ್ ವಿ ಹ್ಯಾವ್ ಟು ಅಲೋ, ಇಟ್ ಹ್ಯಾಸ್ ಗೋ ಬ್ಯಾಕ್ ಟು ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್. ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಾಗೋದಿಲ್ಲ, ಇಲ್ಲಾಂದ್ರೆ
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ.
ಎಲ್ಲಿದೆ ರೆಕಾರ್ಡ್ಸ್? ಕೆಪ್ಟ್ ಬಿಲ್ ಅಂತ ತೋರಿಸಿಲ್ಲ, ಅದು ಎಕ್ಸಿಟ್ ಆಗಿಲ್ಲ. ಸೆಂಟ್ ಬ್ಯಾಕ್ TCR ಸೆಂಟ್ ಬ್ಯಾಕ್ ಟು ದ ತಿರುಗಿ ಹೋಗಿದೆ ಅಲ್ಲ, ಇಲ್ಲಿದೆ CPS ಏನೋ ಬ್ರಾಂಚ್ ಕಳ್ಸಿದ್ದ ಅದು ಎಲ್ಲ ಇದೆ. ಆಯ್ತು ನೀವು ಕಂಪ್ಲೈ ಮಾಡಿ ನೆಕ್ಸ್ಟ್ ಲಿಸ್ಟ್ ಇಂದ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಹೇಳಿ ಲಿಸ್ಟ್ ಫ್ರಮ್ 21 ಇದೆ ಅಲ್ಲ ರೆಕಾರ್ಡ್ಸ್
ಇದೆ madam. 21/9. Cell number 25, Prasad Hegde,
7 minutes.
Halesh Sharji,
108 ambulance, my lord, they were having a insurance with the KGID, my lord. They were, the KGID, there was an insurance, my lord, they have not made the insurance as a party. KGID is the insurance, my lord, therefore we implement. Yes, madam, Karnataka government.
District Health Officer.
District Health Officer is the ambulance is in his name, man. 108 ambulance in his name.
The 2 vehicles were involved.
Yes.
Motorcycle number case.
Yes, yes, yes.
Idu United India Insurance Company, the motorcycle.
Liability fixed on this KGID, my lord.
I am appearing for the tenth respondent, your lordship. in this
First
case.
dependent is a medical health district health of hospital ಮೇಲೆ. In hospital ambulance ಇತ್ತು. Ambulance insurance ಕೊಟ್ಟಿರೋದು ಕರ್ನಾಟಕ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಆಫ್ ಇನ್ಸೂರೆನ್ಸ್
General
KGID.
insurance.
ಅದ್ರದ್ದು ಕಾಪಿ ನಂಬರ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್. ಆ ಕಾಪಿನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಅವ್ರು ಬಂದು ಅದ್ ಒಂದ್ಮೇಲೆ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಲೋ ಮಾಡಿದ್ರೆ ಕೇಸ್ ಆಫ್ ಡೆತ್ ಆ ಗ್ರೌಂಡ್ ಮೇಲೆ ಇದು ಮ್ಯಾಟರ್ ಮೇ ಬಿ ರಿಮೈಂಡೆಡ್ ಟು ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮೇಲೆ. ಯಾಕಂದ್ರೆ ಆ ಇನ್ಸೂರೆನ್ಸ್ ಪಾಲಿಸಿ ಮೇಲೆ ಅವರು ಎವಿಡೆನ್ಸ್ ಮಾಡ್ಬೇಕು. ದಿ ಕೇಸ್ ಆಫ್ ಡೆತ್ ಆಗಿರೋದ್ರಿಂದ ಆ ಗ್ರೌಂಡ್ ಮೇಲೆ ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಪ್ಲೀಸ್ ಟು ರಿಮೈಂಡ್ ದಿ ಮ್ಯಾಟರ್. 19th ಅಲ್ಲಿ ಇದೆ ಆಕ್ಷನ್.
Ambulance vehicle number. K51. Complete ಮಾಡಬೇಕಲ್ಲ ಡಿಲೇ ಕಂಡೋನ್ ಆಗಿದೆ ಇಲ್ಲ
ಇಲ್ಲ.
No objection ಅಲ್ಲಿಗೆ.
ಅದು ಕಂಟ್ರೋಲ್ ಮಾಡಕ್ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಮೇಲೆ
ನೀವ್ಯಾರನ್ನ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡೋದು
ನಾವು ಕ್ಲೈಮೇಟ್ ಡಿಪೆಂಡೆನ್ಸ್ ಆಫ್ ದಿ ಡಿಸೀಸ್ಡ್
ಶಿವನ್ನೇಗೌಡ
1 to 7
for R10.
R10, I am Manjula Tejasvi, I have filed wakalat for respondent.
ನಿಮ್ಮ ಹೆಸರು
Yes, your
ತೋರಿಸಿಲ್ವಾ ಆಗಿದ್ರೆ
ಇದೆ ಸ್ವಾಮಿ, ನಿನ್ನೆ ತೋರಿಸಿದ್ದಾರೆ ಫಾರ್ R10 ಅಂತ ತೋರಿಸಿದ್ದಾರೆ.
ಶಿವನ್ನೇಗೌಡ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ 25 ತಾನೆ ಸೀರಿಯಲ್ ನಂಬರ್ 20.
ಅವರು ಫಾರ್ಮಲ್
ಯುನೈಟೆಡ್ ಇನ್ಶೂರೆನ್ಸ್.
Formal party, my lord.
ಫಾರ್ಮಲ್ ಪಾರ್ಟಿ ಮಾಡಿದ್ರೆ ಅವ್ರಿಗೆ ವಕಾಲತ್ ಹಾಕ್ಯಾರ. ಯುನೈಟೆಡ್ ಇಂಡಿಯಾ ಲೈಬಿಲಿಟಿ ಫಿಕ್ಸ್ಡ್ ಅಂತ.
Srimati Manjula and Tejasvi has filed wakalat for respondent. Only her name shall be shown in the cause list for the said respondent. Okay. Please don't get out.
ಕರ್ನಾಟಕ ಗವರ್ನಮೆಂಟ್ ಇನ್ಸೂರೆನ್ಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಮೋಟಾರ್ ಬ್ರಾಂಚ್ ಬೆಂಗಳೂರು 1 ರೆಪ್ರೆಸೆಂಟೆಡ್ ಬೈ ಡೈರೆಕ್ಟರ್.
ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಹೋಗಿತ್ತಾ?
ಅಲ್ಲಿ ಗವರ್ನಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ is appearing, madam.
ಗವರ್ನಮೆಂಟ್
Taken notice.
Yes, madam.
Have you got any objection for impleading?
For allowing condone, I will verify it, lordship, in respect of.
ಈ application allow ಮಾಡಬೇಕು.
ಅಲ್ಲ ಅದೇನು ತೊಂದರೆ.
ಅವ್ರ ಹೆಸರು ತೋರಿಸಿದಾರ ಇಲ್ಲಿ?
HCGP
ತೋರಿಸಿದ್ದಾರೆ.
Propose?
R11.
ಅಲ್ಲ ವೆರಿಫೈ
Propose. Learned exceed.
ಕೊಟ್ಟಿದ್ದಾರಾ?
Concedes for allowing file number 2 of 2023, that is to implead KGID as a respond number 11. Admittedly, vehicle was insured with KGID.
Yes,
KGID.
we produced the copy also.
ಕಾಪಿ ಕೊಡಿ.
The proposed. So admittedly ಬೇಡ ಅಂದ್ರೆ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ ಪಾಲಿಸಿ ಅಂತ ಹೇಳಿದ್ರು. Admittedly ಬೇಡ. It is agreed that the offending vehicle was insured with the proposed respond number 11 at the relevant time. Under the circumstances, the appellant is permitted to implead KGID as proposed as respond number 11. Okay, delay condonation ಗೆ ನೀವು ನೋಡಿ ಹೇಳ್ಬೇಕಾ?
Please, lordship.
Delay condonation ಗೆ have any?
I have no objection, lordship. Only for verification of that policy what he has produced.
That you can.
I will verify.
Delay ಎಷ್ಟಿದೆ delay?
And the matter has to be remanded, your lordship, for fresh consideration.
51 days, sir. ಉಳಿದವ್ರು ಯಾರು? Only you are the affected party ಅಲ್ವಾ?
ಪ್ಲೀಸ್ ಮೇಲೆ
Climate.
ಡಿಪೆಂಡೆನ್ಸ್ ಆಫ್ ದಿ ಡಿಸೀಸ್ ಡೆತ್ ಕೇಸ್ 1 to 7.
Delay condonation ನಿಮ್ಗೇನು objection?
No ಮೇಲೆ
Response council consider for consider that for delay condonation, accepting the reasons assigned. The delay of 151 days and filing the appeal is condoned in the interest of justice. I have 1,022 accordingly. ಹೀಗೆ ಯಾಕೆ ರಿಮೈಂಡ್ ಆಗ್ಬೇಕಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ?
ಇನ್ಸೂರೆನ್ಸ್ ಪಾಲಿಸಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಜೊತೆ, ಅದನ್ನ ಮೇಲೆ ಟ್ರಯಲ್ ನಡಿಬೇಕಾಗುತ್ತೆ ಸುಮ್ಮನೆ ಕೆಳಗಿನ ಕೋರ್ಟಲ್ಲಿ. ಆ ಗ್ರೌಂಡ್ ಮೇಲೆ ಇದು ರಿಮೈಂಡ್ ಮಾಡಿದ್ರೆ ಇಮಿಡಿಯೇಟ್
ಡಿಸ್ಪ್ಯೂಟೇ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ಟ್ರಯಲ್ ಕೋರ್ಟಿಗೆ ಹೋಗ್ಬೇಕಾದ್ರೆ
ಅದು ಇಲ್ಲೇ ಮಾಡಿದ್ರೆ ಇಟ್ಸ್ ಗ್ರೇಟ್ಫುಲ್ ಟು ಲಾರ್ಡ್ಶಿಪ್.
ಅಲ್ಲ, we are not a party before the trial court, your lords.
ಅಲ್ಲ ಈ ಪಾಲಿಸಿ
And regarding that quantum, your lordship.
ಜನರಲಿ quantum we can decide here.
ಅಲ್ಲ, ಆಮೇಲೆ
It's a case of death ಅಲ್ಲ?
ಹೌದು.
ಹ. ಏನು
ಅಲ್ಲ, ಕಾಂಟ್ರಿಬ್ಯೂಟರಿ ನೆಗ್ಲಿಜೆನ್ಸ್ ಇದೆಯೋ
ಓನ್ಲಿ ಲಯಬಿಲಿಟಿ ಮೇಲೆ ಬಂದಿದೆ ಸ್ವಾಮಿ ಅವರು.
Liability fixed on the appellant, therefore.
petition stands dismissed against 4 and 5. 4 and 5 were the owner of the motorcycle and ಇದಲ್ವಾ insurer.
Here, as well as 10th respondent herein.
Entitled to so and so. Petitioner 6 and 7 are entitled to so and so. Respondent number 1 is directed to pay the compensation amount within 2 months. Respondent number 1 was district health officer.
Please.
ಅಲ್ಲಿ ಎಕ್ಸ್ಪರ್ಟ್ ಆಗಿದ್ರ ಅವರು?
Yes.
ಅವ್ರು ಎಕ್ಸ್ಪರ್ಟ್ ಆಗಿದ್ದಾರೆ.
ಅಂದ್ರೆ
ರಿಮೈಂಡ್ ಆಗ್ಬೇಕು.
ರಿಮೈಂಡ್ ಆಗ್ಬೇಕು.
ಯಾರು ನೀವು ಇಬ್ಬರನ್ನೂ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತೀರಾ?
ಇಲ್ಲ, ಅವರು ಹೆಲ್ತ್ ಆಫೀಸರ್ ಅಪಲೆಂಟ್. ನಾನು
ಯಾಕೆ ಅಪಿಯರ್ ಆಗಿಲ್ಲ ನಿಮ್ಮವರಲ್ಲಿ?
The notice was misplaced, it seems.
Please, ma'am.
Both counsel submit that. Both counsel submit that the present appellant was respondent number 1 was
subject to verification of policy model.
Had not contested the matter. The records show that the insurer of offending that is ambulance pairing number KA51 G5176 was not made party before the tribunal. Now the insurer is also impleaded as ಇಲ್ಲಿ ಮಾಡಿದ್ರೆ ಅಲ್ಲೂ ಮಾಡಬೇಕಾಗುತ್ತೆ ನೀವು ತಿರುಗಿ. Respondent, it is just and appropriate that a reasonable opportunity shall be given to both the parties. Under circumstances, it is a fit case to remand the matter to the tribunal for fresh consideration after giving opportunity to the appellant and after impleading the KGID. ಅದು ಪೂರ್ತಿ ಫಾರ್ಮ್ ಹಾಕೊಳ್ಳಿದ್ರೆ KGID as respond number 6 ಅಂತ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ. As respond number 6 in the claim petition.
4836.
Claim petition ಅಂತ ಅಷ್ಟೇ ಹೇಳಿ. Claim petition. Hence the circumstances the following order, the appeal is allowed. The impugned judgment and award ಇಲ್ಲಿ 50% ಡೆಪಾಸಿಟ್ ಮಾಡಿದಾರಾ?
ಇಲ್ಲ, ಅವ್ರು ಬಂದು ಈ ಆನ್ ರೆಕಾರ್ಡ್ ಬಂದು ಪಾಲಿಸಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ಮೇಲೆ
set aside. The matter is remanded to the tribunal for fresh consideration in the light of the observations made in the body of this order to avoid further delay. ನೀವು ಸೋಮೋಟೋ ಅಪಿಯರ್ ಆಗ್ಬೇಕಾಗುತ್ತೆ.
ಹೌದು, ನಾನು ಅದು ವೆರಿಫೈ ಮಾಡಿಸ್ತೇನೆ. ಅದು ನಮ್ಗೆ ಅದು ಪಾಲಿಸಿ ಇದೆಯಲ್ಲ ಅಂತ ವೆರಿಫೈ ಮಾಡ್ಬೇಕು, ಅಲ್ಲೇ ಮಾಡ್ತೇನೆ. ಸಬ್ಜೆಕ್ಟ್
parties are hereby directed to appear before the tribunal on date next month. ಒಂದು ವಾರ ಬಿಟ್ಟು ಹಾಕೊಳ್ಳಿ, ಯಾಕಂದ್ರೆ ಕಾಪೀಸ್ ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಲ್ಲ.
1 month ಬೇಕಾಗುತ್ತೆ.
1410 on such appearance of the parties ನೀವು ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ the claimants ನೀವು ಇಂಪ್ಲೀಡ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ. ನೀವು ಇಂಪ್ಲೀಡ್ ಮಾಡ್ಬೇಕು.
ನಾನು ಮಾಡ್ತಾ ಅವರು ಇಲ್ಲಿ ಹಾಕಿದಾರೆ ಅಪ್ಲಿಕೇಶನ್, ಇಫ್ ಇಟ್ ಇಸ್ ಅಲೌಡ್ ನಾನು ವಿಲ್ ಫೈಲ್ ನೆಸೆಸರಿ ಅಪ್ಲಿಕೇಶನ್.
They have to file.
I will do it.
ರೆಕಾರ್ಡ್ ಬಂದಿಲ್ಲ ಅಲ್ಲ, ಇಲ್ಲಿ ಬಂದಿದ್ರೆ ಇಲ್ಲ ಕೊಡ್ತಿದ್ವಿ ನಾವು ಬೇಕಾದ್ರೆ. ಕಾಲ್ಡ್ ಅಂತ ಹೇಳಿ ಅಲ್ಲ, ಇಲ್ಲಂದ್ರೆ ಇಲ್ಲೇ ಅಮೆಂಡ್ ಮಾಡಕ್ ಪರ್ಮಿಷನ್ ಕೊಟ್ಬಿಡ್ತಿದ್ವಿ.
ಇಲ್ಲಿ ರೆಕಾರ್ಡ್ ಬಂದಿಲ್ಲ ಅಂತ ಮಾಡಿ
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದ್ದಾರೆ, ಎಕ್ಸಿಕ್ಯೂಷನ್ ಕೇಸ್ ಅಲ್ಲಿ ಫೈಲ್ ಹೋಗಿರ್ಬೇಕು.
ಬಂದಿಲ್ಲ ಅಂತ ಯಾಕಂದ್ರೆ ಡಿಲೇ ಇತ್ತಲ್ಲ, ಕಾಲ್ ಫಾರ್ ಮಾಡಿರೋದಿಲ್ಲ.
ಮಾಡಿಲ್ಲ, ಇನ್ನು ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಆಗಿಲ್ಲ, ಕಾಲ್ ಫಾರ್ ಮಾಡಿಲ್ಲ.
ಸಚ್ ನೀವೇ ಇಂಪ್ಲೀಡ್ ಮಾಡಿ, ನಿಮ್ಗೆ ಕೊಡ್ತೀವಿ ಡೈರೆಕ್ಷನ್. ದ ಅಪಿಲೆಂಟ್ ಶಾಲ್ ಇಂಪ್ಲೀಡ್ KCIC, which is respondent number 11 in this appeal as co-respondent First point. The tribunal shall give opportunity to both the parties and dispose of the matter as expeditiously as possible. At any rate, within ಎಷ್ಟು ದಿವಸದಲ್ಲಿ ಮಾಡಕ್ಕೆ ಹೇಳೋದು?
Everybody is in
Two
hurry.
months,
Lordship, that
only policy producing.
ಅಲ್ಲ subject to verification of the policy ಇರ್ಲಿ ಸ್ವಾಮಿ ಅದ್ರ
Always available to them.
Expeditiously as possible.
Always available.
ಹೋಗಿ appear ಆಗ್ರಿ. Yes.
ಒಬ್ಳೆ
IA 3 of 2002 first days to dispose of. Yes.
Please.
PCR 5824 ಅಂತ ಕಾಲ್ ಮಾಡಿ.
ಅಲ್ಲ ಈಗ ಅದು ಇದು ಹೋದ್ರೆ ಅದು ರಿಟರ್ನ್ ಹೋಗೇ ಬಿಡುತ್ತೆ. Yes.
Cell number 26, N Kumar, P Pradeep for R1.
One counsel.
161 days delay. ಇನ್ನೊಂದ್ರಲ್ಲಿ
Two appeals, one is filed by the insurer, the other is filed by the.
Pardon?
One is filed by the insurance company, Pradeep has filed, another is by the claimant for enhancement.
ನೀವ್ ಯಾವ್ದ್ರಲ್ಲಿ represent here?
I represent Mr. B. Pradeep.
ಪ್ರದೀಪ್ ಅವರು. ನಿಮ್ದು ಯಾವ್ದು ಹೆಸರಿಲ್ಲ ಇಲ್ಲ.
His grandmother passed away, so he's out of station.
ಡಿಲೇ ಕಂಡೋನೇಷನ್ ಅವ್ರಿಗೂ
Delay
ಬಂದಿಲ್ಲ. ಎರಡು ನಿಮ್ ಕೇಸಲ್ಲೂ ಡಿಲೇ ಇದೆ.
ಅದೇ ಎರಡರಲ್ಲೂ ಡಿಲೇ ಕಂಡೌನ್ ಮಾಡ್ಬೋದು.
ಎರಡು ಕಾಮನ್ ಆಗಿ ತಗೊಂಡ್ರೆ. Third, considering the reasons assigned to explain the delay, delay of 161 days and 91 days in filing IMF number 6862 of 2023 and 5099 of 2023 respectively is condoned in the interest of justice. I number 1 of 2023 in both the cases are disposed of accordingly. Okay. ನೀವು ಡೆಪಾಸಿಟೆಡ್ ಅಮೌಂಟ್ ಹಾಕಿಲ್ಲ.
We have deposited on 14/3/2024. Adakila, the acknowledgement will get it. They have complied.
ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ ಫಾರ್ ಮಾಡಬೇಕಾ?
ಹೌದು, because it's so.
TCRs. List of receipt of TCRs.
Cell number 27, B Latif, SB Hegde Mulkan.
55 days. ವಕಾಲತ್ ಹಾಕಿಲ್ವಾ ಅವ್ರು ಇನ್ನು? ಯಾರು SB ಹೆಗ್ಡೆ ಮಾಡ್ಕೊಂಡು ಎಲ್ಲಿದೆ? ನಾಟ್ ಫೈಲ್ಡ್ ಅಂತ ಬರ್ದಿದಾರಲ್ಲ, ಇದ್ರಲ್ಲಿ ಹಾಕಿದಾರ?
ಇಲ್ಲ
ಬಂದಿಲ್ಲ.
ನಿಮಿಷ
ನೋಡಿ ವೇಟಿಂಗ್ ಸರ್ ಅವ್ರ ಹೆಸರು ತೋರಿಸಿ ಕೆಳಗೆ ವಕಾಲತ್ ನಾಟ್ ಫೈಲ್ಡ್ ಅಂತ ಬರ್ದಿದ್ದಾರೆ ನೋಡಿ. ವೇಟಿಂಗ್ ಸರ್ವಿಸ್ R2
29/1/24 ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ.
ಎಲ್ಲ ಅಲ್ಲಿದೆಯಾ? ಮತ್ತೆ ರಿಜಿಸ್ಟ್ರಿ ಹಾಕ್ಲಿಕ್ಕೆ ಬರ್ದಿದ್ದಾರೆ 29. ಅಲ್ಲ ಇದು ಪ್ರೆಸೆಂಟೇಶನ್ ಫಾರ್ಮ್ ನೋಡ್ರಿ, ಅದು ಡೇಟ್ ಅಲ್ಲ 29 January ಕರೆಕ್ಟ್. The records show that Shri SB Hegde Mulkan Learner Council has filed wakalat for respondent to rank ಏನಾರು ತಪ್ಪು ಬರ್ದಿದ್ದಾರೆ. Respondent 2 ಅಂತಾನೆ ಬರ್ದಿದ್ದಾರೆ. Respondent 2 on 29/1/2024 itself. Registry shall show the same in the cause list. List after non-filing having served the copy on R2. Yeah, served the copy?
No.
List after the notice on respondent 2. He himself has filed for respondent 2 alva. Respondent 1 ಗೆ dispense with ಆಗಿದೆ. Therefore, office subsections regarding respondent 2 do not survive for consideration. 1 week time is granted to serve the copies. Sir, 1 ವಾರದಲ್ಲಿ ಸರ್ವ್ ಮಾಡಿ ಅದು.
Number 28, Krishnamurthy D, Sandesh Shetty.
Case of death mallots. I filed an IA mallots for condonation of delay mallots. It is delay of 29 days.
Company. ಸರ್ವ್ ಆಗಿ ಅಪಿಯರ್ ಆಗೋದೇ ಇಲ್ಲ.
And the respondent number 1 only.
Appeal is by whom?
Appeal is by the claimant mallots for enhancement.
What is the order first? Partly allowed. Claim fiction is partly allowed or what is?
Partly other than contributory negligence of 40%. So that's why they.
Represent ಮಾಡೋದು? You are for the owner.
Owner.
ಎಲ್ಲಿದ್ದಾರೆ ನಿಮ್ಮ ಇನ್ಶೂರರ್? ಸರ್ವಿಸ್ ಆಗಿ ಅಪಿಯರ್ ಆಗೋದಿಲ್ಲ. ಯಾರಾದ್ರೂ ಇದೀರಾ ಇಲ್ಲಿ ಓರಿಯೆಂಟಲ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿಯವರು? ಯಾರು ಇಲ್ಲ ಅನ್ಸುತ್ತೆ.
Oriental.
ನೀವು ನಿಮ್ಮವ್ರ ಸರ್ವಿಸ್ ಆದ್ರೂ ಅಪಿಯರ್ ಆಗೋದಿಲ್ಲ, ನಾವಿಲ್ಲಿ ಯಾರಿಗಾರ ಅಸೈನ್ ಮಾಡಿದ್ರೆ ಅವ್ರು ಕೊಡೋದಿಲ್ಲ. ನೋಟಿಸ್ ತಗೊಳ್ತೀರಾ ನೀವು?
GS Muralaya.
Shri G.S. Pallaya, Loyal Standing Counsel for Respondent number 2 is requested to accept notice for Respondent number 2. His name shall be shown in the cause list accordingly. Appellants one set ಕೊಟ್ಬಿಡಿ ಅವ್ರು. Appellants counsel shall serve the copies on him. 29 days delay ಇದೆ ಕಂಡೋನ್ ಮಾಡ್ತೀವಿ.
Please.
Case of death ಅಲ್ವಾ, minors ಎಲ್ಲ ಇದಾವೆ.
Case of death.
The reasons assigned to extend the delay of 29 days in filing the appeal is condoned in the interest of justice. I one of present 23 is disposed of accordingly. You may have point only quantum and you are on which point? Appeal. Quantum.
Well, it's liability as well as quantum knowledge. Liability is fixed at 40% knowledge.
Negligence.
Negligence.
Issue number 1 ಮೇಲೆ partly affirmative ಅಂತ. Yes. Admit, then we'll call for that. Admit, call for TC.
Please.
Just after this.
Till number 29, Sunil Kumar Patel.
Last letter feeling conflict directly citation, file an application.
Where he was, the deceased was last recent. We'll copy there. TCR ಬಂದಿದೆ.
TCR received.
ಸಿದ್ಧಗಂಗಮ್ಮ also expert. ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಅವ್ರ ಅಡ್ರೆಸ್ ಅದನ್ನೇ ತೋರಿಸಿದಾರ. Testator was your grandmother.
Yes. Appellant's father. Studying at Locus City.
You don't have any other siblings?
Have not, but he bequeaths his property to his only son.
No, he has only son or any other children? Where
Other
class 1 years ಬೇರೆ ಯಾರು ಇಲ್ವಾ? ಮತ್ತೆ ಅವ್ರಿಗೆ ಸೈಟೇಷನ್ ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕು ಅಂತ ಇದೆ ಅಲ್ವಾ ಇದು P&SC. If it is filed by beneficiary, ನಾವೊಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡಿದ್ವಲ್ಲ ಇದರಲ್ಲಿ ನೆನಪಿದೆಯಾ? Then you have to implement your other his other class 1 years also. We were not aware of that.
In the will, he has bequeathed his all properties.
That is correct, but what is the Indian Succession Act read that? If a beneficiary files it, then it should be as letters of administration ಅಂತ ಆಗ್ಬೇಕು ಅಂತ ಇದೆ ಅಲ್ಲ?
He must take steps against all.
You have to take when notice to the other relatives also.
They were not made of the party before the.
Respondent ಅಂತ ಮಾಡಬೇಕು, ಮಾಡಿರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಾವು ನಮ್ದೊಂದು ಜಜ್ಮೆಂಟ್ ಇತ್ತಲ್ಲ ಇದ್ರ ಮೇಲೆ. ಅದು 272. Your petition was under section 276. 276. Password ಮಾಡಲ್ವಾ ಇಲ್ಲಾಂದ್ರೆ ಸುಮ್ಮನೆ ಅದು. You just go through this statement. You go through this statement and we'll see later. Section quote ಮಾಡಿದ್ವಿ 29 section quote ಮಾಡಿದ್ವಿ. Probate only to the appointed executor. Only executor, section 222, probate only to the appointed executor. Probate shall be granted only to an executor appointed by the will, whether you are appointed as executor into the will, so you are beneficiary.
On that ground only Telecast has dismissed my,
Correct, I hear that.
I'm playing on the.
Grant of administration of universal or residuary legatees. 232, when the deceased has made a will but has not appointed an executor, deceased has appointed an executor, etc. A universal or residuary legatee may be admitted to prove the will, and letters of administration with a will annexed may be granted to him. If beneficiary applies, then letters of administration applies. In that event, section 272 comes into picture. So in that case, application for the letters of administration shall be made by the petition distinctly written as aforesaid and stating the time and place of deceased death, family or other relatives of the deceased and their respective residences. And notice shall be taken to them anta ಇದೆ.
I'm laying on one judgment. I placed the.
Judgment of which court?
Sonville Court, Division Bench Court. Diana Parveen versus Will.
Which year?
That, 2019.
2023 judgment ಇದೆ
Let's go
subsequent.
through that one.
ನೋಡಿ.
Miller circumstances.
You want us to pass it over or? Pass over ಮಾಡ್ಬೇಕಾ ಇನ್ನೊಂದು ದಿವಸ ಹಾಕ್ಬೇಕು?
Kindly have it next week. I just. go through
ನಾನು
it.
ಅಲ್ಲಿ ಜಡ್ಜ್ಮೆಂಟ್ ಬರೆದು ಬಿಡ್ತೀವಿ ಇಲ್ಲಾಂದ್ರೆ ಮರ್ತಾ ಬಿಡ್ತೀವಿ. ನಾನು ಕನ್ಸಲ್ಟೆಂಟ್ appellant to submit regarding the legal principle enunciated by this court ಇದೆಲ್ಲ ರಿಪೋರ್ಟ್ ಆಗಿದೆಯಾ?
Proceeding according to 255.
ಅದೇ citation letters of administration ಕೊಡ್ಬೇಕಂದ್ರೆ citation ಅವ್ರಿಗೆಲ್ಲರಿಗೂ ಹೋಗ್ಬೇಕು. Legal position as enunciated by this court in Mallama versus Muni Reddy. MFA number ಇದೆಲ್ಲ ರಿಪೋರ್ಟ್ ಆಗಿರ್ಬೇಕು. MFA number 7321 into bracket ISA. Data DD 27/7/2023. I think this is reported answer. At least after 1 week. Yes, yes. Date. List on the date.
20th, 29. Till number 30 adjourned. Till number 31, Madhukar Deshpande.
Loss of deceased D3 na. D3 or R3?
D3 private portal is oversight of the party.
ಅಲ್ಲಿ ಇಲ್ಲಿ ಹೇಗ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ಈಗ ಅವ್ರ ಎಲ್ಲಾರ್ಸನ್ನ ನೀವು ಇಂಪ್ಲೀಟ್ ಮಾಡ್ಬೇಕಷ್ಟೇ.
Also filing, but one more application has been tried to bring in.
Permission to 4 application. 4 applications. Even if that is the case.
D3 died on 12/7/2020.
Correct. You have filed 3 applications to bring the LR setting aside the abatement and condonation. You have filed another application IA 5/2024 to bring the LRs of deceased defendant number 3 on record. Why if I saw you could have maintained 1 application or either of these 3 applications. These 3 applications.
Objection when they are bringing meeting as a party for the first time in the appeal, the separate application also has to be.
You want to bring them on record? ಏನಂತ ತಗೋ
27 and 28. Respondents 27.
27 and 28. ಅದನ್ನು ಒಂದು ಕರೆಕ್ಟ್ ಆಗಿ ಟೇಬಲ್ ತರ ಹಾಕಿದ್ರೆ ಆಗುತ್ತೆ. Issue notice of I number 1 to 4 of 2024 to propose the respondent number 27 and 28. List on. Notice court ಇದ್ದದ್ದು ಹೋಗಿಲ್ಲ. ನೋಟಿಸ್ ಆನ್ ಐ ಆಯ್ತು ಅವರಷ್ಟೇ ಇಲ್ಲ ಬೇರೆಯವ್ರಿಗೂ ನೋಟಿಸ್ ಹೋಗಿಲ್ವಾ? And notice of appeal to the other respondents. List on.
2210.
22.
Till number 32, Hanmantappa A.
Partition super ಎಲ್ಲ ಬೇಕಾಗುತ್ತೆ ಅದು ತಗೋದಿಲ್ಲ. Oh, 31 days delay, na? Claim petition is allowed or not allowed? Partly allowed. Issue notice to the respondents. Next down, ಎಲ್ಲ ಹೇಳಿದ ಮೇಲೆ ಮಾಡೋದು. Why dispensation? ಇಲ್ಲ ಕರೆಕ್ಟ್ ಕೊಡಿ ಅಂದ್ರೆ you should do it immediately, no? Lawyer counsel for the appellant, beginning ನಲ್ಲಿ ಬರ್ತದೆ. Lawyer counsel for the appellant submits memo for dispensation. ಇನ್ನೊಂದ್ ಸೆಟ್ ಕೊಡಿ. Submits memo for dispensation of notice to respondent number 1. The records show that under the impugned award, the liability is fastened to correspond number to the insurer. Contest to ಮಾಡಿರ್ಲಿಲ್ವಾ ಅವರು? Respond number 2 filed objections. This one has not filed. Respond number 1 had not contested the matter before the tribunal. Therefore, notice to respond number 1 is dispensed with as paid for. Issue notice to respond number 2. List 8.
1610.
1610.
Till number 33, B. Pradeep.
Appellant counsel, appeal is by the insurance company challenging the liability on the contributory negligence on the part of the
70 lakhs.
70 lakhs is 50% item.
Issue notice to respondents. Interim stay of execution of the impugned award till next year in date, subject to appellant depositing 50% of the award amount before the tribunal within 4 weeks from
4
the date of this order. List down 4 weeks only.
1610. Till number 34, G.S. Marlaya.
Challenging the quantum. 25,000 income taken. It's the higher side.
There were two cases. ಎರಡಿತ್ತ?
ಒಂದೇ ಫೈಲ್ ಮಾಡಿರೋದು. First case.
So 3-2.
2032.
Any other point of quantum or liability?
Quantum.
Quantum. Issue notice to the respondents. Interim stay of the execution.
Ready to deposit 50%.
Next year indeed, subject to the appellant depositing 50% of the award amount before the tribunal within 4 weeks from the date of this order. List down
2110.
20.
For admission, till number 35, Prithviraj N.M. B. Pradeep for R2.
Kothar mood. Why it is moved? Kothar mood ಅಂತ ಇದೆ. ಮೂವ್ ಮಾಡಿದವರು ಇರೋದಿಲ್ಲ. ಅವ್ರು ಮೂವ್ ಮಾಡಿ.
ಕೈಲಿ ಪಾಸ್ ಅವ್ರ ಮೇಲೆ ಸೀನಿಯರ್ ಇನ್ಕಮ್ ಇಲ್ಲ.
ಎಲ್ಲಿದ್ದಾರೆ? Who is that?
ಸೀರಿಯಲ್ ನಂಬರ್ 35 ಮೇಲೆ. ಕೈಲಿ ಪಾಸ್ ಅವ್ರ ಮೇಲೆ ಸೀನಿಯರ್ ಇನ್ಕಮ್ ಇಲ್ಲ.
Why? For what purpose? For what purpose? The notice to respond number 1 is already dispensed with.
Dispensed, my lord. R2 Pradeep is taken notice, my lord.
But records call for ಮಾಡೋದು ಅಷ್ಟೇ. ಬಂದಿದೆಯಾ?
LCR ಬಂದಿದೆ ಸರ್.
Next week.
45,000 is awarded. You are on the point of quantum.
Please, my lord.
What is the error?
Senior ಬರ್ತಾರೆ ಸರ್, ಬೇರೆ ಕೋಟಲ್ಲಿ ಎಂಗೇಜ್ ಆಗಿದ್ದಾರೆ, ಕೈಲಿ ಪಾಸ್ ಅವ್ರ ಮೇಲೆ.
Senior engage ಆಗಿದ್ದಾರೆ. ಇನ್ನೊಂದು ದಿವಸ ತಗೊಳ್ಳೋಣ ಹಾಗಾದ್ರೆ. Admit to list of final hearing on 30. 1510.
ಈ ಮಂತ್ ಅಲ್ಲಿ ಒಂದು ಡೇಟ್ ಆಗ್ಬೋದು.
36.
This month only, madam.
Till number 36, yes, Raju. Krishna.
I'm appealing for the respond number 3 in this case, your lordship.
Copies are served on you?
Yes, your lordship, copy has been served.
Learner counsel for respond number 3 submits that she has received the copies. Therefore, office objections should comply. Yes.
Owner repeat, madam.
I will.
Represent claimant, sir.
I will appear for him.
Appear. Okay.
The insurance company was exonerated on the ground that the
driver had no driving license.
Hmm.
Charge sheet only was produced. Para 19 of the judgment, Your Lordship.
Para 19.
19. Next page.
Yes.
Yes.
Valid and effective driving license.
Yes.
Hmm.
So to prove that,
Hmm.
they relied on
279, 304A, 134A and B of.
and section 3(1) read with 181 of MV Act. So for that purpose, they also produced this charge sheet. And also officer of the insurance company is examined. My humble submission is the production of these and the evidence of the insurance company will not discharge the burden of their proof of requirement of valid driving license. In the instant case, actually the owner had represented before the court by an advocate. So mere interrogatory would have been sufficient. If we are asking for production of driving license by the owner, we would have produced. So it is until they ask, the burden does not shift on me. They should ask for that. Number one, the mode of proof of absence of driving license is either by examining the driver or by examining the RTO or by calling upon the owner to produce the driving license. On this aspect, there is also a judgment of the apex court and also all those judgments of our high court.
Records ಬಂದಿದೆ ಇದರಲ್ಲಿ.
Record ಬೇಕಾಗಲ್ಲ, ಇದು ಒಂದೇ ಪಾಯಿಂಟ್.
Only one point.
And as an
ನೀವಿಬ್ರು ಒಟ್ಟಿಗೆ ಹೇಳ್ತೀರಿ ಈಗ. He could have produced the driving license when they had taken the.
Yes, Your Lordship. Yes, my submission is the same here. They had appeared before the tribunal.
No,
It was being submitted that records are not required. It can be had because there is a Supreme Court judgment.
yes.
You should have
Your
examined the RTO or the driver.
My submissions in this regard are that, Your Lordship, no, the owner had appeared before the tribunal and through the council also. The submission made by the other side council just now is that we could have interrogated them is not correct, Your Lordship. Yes, sir.
But he is
Yeah,
saying that there is a Supreme Court judgment, which is that judgment you did not give us.
Your Lordship, ಅಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಇದ್ದಿದ್ರೆ ಇದು ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಎಲ್ಲಾದ್ರೂ ಇದ್ರೆ ಅಥವಾ ಇರ್ಲಿಲ್ಲ ಇನ್ವ್ಯಾಲಿಡ್ ಇತ್ತು ಅಂತಂದ್ರೆ ನಾನು ಕೂಡ ಎಕ್ಸಾಮಿನ್ ಸಮ್ RTO. He had no driving license at all. Therefore, the tribunal had exonerated the liability of insurance company. Today, now before this honorable, my only submissions are this, Your Lordship. They have produced the driving license before this honorable court. Now, that is in the year 2024.
It is only as an
The
abandoned
claim
portion.
petition, 1 second, sir, now let me complete my submissions. Before the tribunal, the matter was pertaining to 2017. The owner appeared. He knew very well that the charge sheet has been filed stating that no driving license is there under section 3(1) also 181, 187, everything. Despite that, he keeps quiet. He doesn't choose to appear before the court and say that no, I had a driving license. Now, before this honorable court, also the appeal has been filed on in the year 2020, Your Lordship. But
We have to see the records. Which is that judgment you are which is that judgment you are relying?
I am relying on two judgments. One is judgment of this court, which reviewed all the earlier judgments of the Karnataka High Court.
Citations
What
ಹೇಳಿ
was the
sir.
parts of that case? In that case, driver had appeared or not appeared?
ಇದರಲ್ಲಿ owner had appeared, one of the cases.
Owner of the vehicle.
ಆಮೇಲೆ
ಅಲ್ಲ,
owner had also appeared.
2018
And notice was also served. ಎಲ್ಲ ಮೂರು ಕೇಸು ಇದೆ, ಮೂರು ಟೈಪ್ ಕೇಸು ಇದೆ.
ಯಾವ್ದು? Supreme Court ಯಾವ್ದು?
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ 98/9 ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಕೇಸಸ್ 161.
1998.
ಹೌದು. ಅರ್ಲಿಯರ್ ಆಕ್ಟ್ ಮೇಲೆ
Records.
ಎರಡು ಕೊಡ್ತೀನಿ ತಮ್ಮ.
My lords, I request the council to kindly tell the submissions,
I will,
citations, Your Lordship.
ಮಾಡ್ತೀವಿ ಅಷ್ಟೇ ಮಾಡಿ.
ಅಡ್ಮಿಷನ್ ಬೇಡ ಹಂಗೇನು ಮಾಡ್ಬೋದು.
ಡೇಟ್ ಕೊಡ್ತೀವಿ ಅಷ್ಟೇ.
ಏನು
ರೀಚ್ ಆಗಲ್ಲ ಸ್ವಾಮಿ ಅಡ್ಮಿಟ್ ಮಾಡ್ಬಿಟ್ಟು.
ಎರಡು ಕೊಟ್ನಲ್ಲ.
ಅಲ್ಲ ರೀ, ನಿಮ್ದು 2020 ಕೇಸ್ 14-15 ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇದಾವೆ. ಒಂದು ವಾರದಲ್ಲಿ ಇರ್ತೀವಿ. ಬೇಕಾದ್ರೆ ಇಲ್ಲ ಸ್ವಲ್ಪ ಮಾಡಿ ಹಾಗಿದ್ರೆ ಇಂಟ್ರೆಸ್ಟ್ ಸ್ಟೇ ಕೊಡ್ತೀವಿ. ನೀವು you appear correct. You have produced the driving license.
As an append as
ಮಾಡಿಸ್ಕೊಂಡಿರ್ಲಿಲ್ವಾ ಅದನ್ನ? No, he is submitting that the driving license was produced before the trial court.
No, no.
No, your lordship, only before this honorable court I have produced, your lordship, not before the tribunal.
Yeah,
Urgent ಇದೆ ನಮಗೆ ಅಂದ್ರೆ ಹೇಗೆ? If you want interim stay, will he deposit some amount, will grant. Brother is showing duty of the owner to motor vehicle to give information, section 133 notice ಕೊಡೋದಕ್ಕೆ. ಕೊಟ್ಟಿದ್ರಾ notice? ಮಾಡಿರೋದಿಲ್ಲ ಅದನ್ನ. Give the information regarding name and address of the license held by name and address of and the license held by the driver or conductor which is in his possession
Yes.
or put by reasonable diligence be ascertained by him. 133 notice ಕೊಟ್ಟಿಲ್ಲ.
Yes. Or the
If you are insisting for interim stay, pay at least some amount, we'll pass the order.
25%.
Almost 17 lakhs is there amount. The execution also filed on 2020.
Next week, your lordship may dispose of.
Records ಯಾವೂರಿಂದ ಬರ್ಬೇಕಿದು?
In Bangalore only.
Admit call for TCS, list down, date here.
May I submit, your lordship, in view of, sorry to submit like this, your lordship, since I have got a fracture in my right foot, I'm unable to appear physically before your lordship.
Motor accident, what is the problem?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಮನೆಯಲ್ಲೇ ಸ್ವಲ್ಪ ಎಡವಿ ಬಿದ್ದು ಫ್ರಾಕ್ಚರ್ ಆಗಿದೆ ರೈಟ್ ಫುಟ್ ಅಲ್ಲಿ.
You can appear virtually. Let them
Yes,
furnish
sir.
the copies. ಅವ್ರಿಗೇನೋ
Yes,
fracture ಆಗಿದೆ ಅಂತೆ. ನೀವೇ ಕಾಪೀಸ್ ಅವ್ರಿಗೆ ಕಳಿಸ್ಬಿಡಿ. Then
ಅದು ಸೈಟೇಷನ್ಸ್ ಯಾವ್ದು ಅಂತ ಹೇಳಿದ್ರೆ ನಾನು ನಮ್ಮ ಕಲೀಗ್ ಕಡೆಯಿಂದ ತರಿಸ್ಕೊಂಡು ಐ ಗೆಟ್ ರೆಡಿ ಫಾರ್ ದಟ್.
ಕೊಡ್ತಾರಂತೆ. ಕೊಡ್ತಾರೆ.
We will send it by
Obliged.
message.
ಮೆಸೇಜ್ ಅಲ್ಲಿ ಕಳಿಸ್ತಾರೆ.
24/9.
Obliged, your lordship.
Get well soon. Yes.
Obliged, thank you.
Madhusudan Adigabi, yes, Nagesh.
Appear for the case. A challenge.
For some time, your lordship, senior is not. We will argue the matter, your lordship.
I am challenging OS 6147 of 2019.
You are
Appellant.
the appellant is what was his name? Sole defendant, huh?
Sorry?
Sole defendant. Sole defendant.
The sole defendant.
You
The
said-
I am submitting. Suit between partition between brother and sister. My contention is gone by a will. Testamentary succession, not interstate succession. But the judgment is given under the Succession Act. Entitled for equal half share.
So you set up a will, you admitted the relationship and nature of the property.
Relationship is not disputed.
Will is not proved ಅಂತ hold ಮಾಡಿ.
Will, minor contradictions in the form of will is executed suspicious. On the basis
That
of
we have
minor
to examine.
contradictions.
Declare that suit property is available. Issues one of the. Again, at the most, we stay only drawing up of the final decree. We don't stay the entire proceedings.
FDP ಹಾಕಿದ್ದಾರೆ ಅವರು.
Correct, FDP ಹಾಕಿದ್ರು drawing up of the final decree only we stay. Because you have set up the will, burden was on you to.
No, no,
do
no.
that.
She says it is concocted will. Burden is
No,
on
you
her to
see,
prove that it is.
initially you have to establish, then concocted other things.
ಹೌದು ನನ್ನ ಎಸ್ಟಾಬ್ಲಿಷ್ she has not ಅಲ್ಲ
1956
one submission she said that signature is forged. It is her burden to refer it to the handwriting expert. He has not at all discharged that burden.
59 ಯಾವ್ದಾದ್ರು prism ಅವ್ರು-
ತಿಮ್ಮಜಮ್ಮ ವರ್ಸಸ್ ತಿಮ್ಮಜನ ವೆಂಕಟೇಶಯ್ಯ
ಹಾ.
AR
1959 ಅವಾಗಿಂದಾನೇ ಇದೆ. First who sets up the will, he has to prove it. Then
I have discharged my burden. She has not discharged her burden. She has not referred it to the handwriting expert. Minor contradictions, time, execution, number of witness, ಅದ್ರ ಮೇಲೆ will is suspicious ಅಂತ ಹೋಲ್ಡ್ ಮಾಡ್ತಾರೆ.
Subject to an interim stay only for drawing up of the final decree till further orders. And in the third admit call for TCRs, paper book, appellant's counsel shall submit the paper books within ಎಷ್ಟು ದಿವಸದಲ್ಲಿ ಹಾಕ್ತಾರೆ paper books?
6 weeks.
Within 6 weeks. Okay. Interim stay only for drawing up of the final decree. Pursuant to the impugned preliminary decree. Till further orders. I have 1/2024 is disposed of accordingly. List after 6 weeks. Yes.
Cell number 38, Raghu Prasad BS.
Plaintiff's appeal against the dismissal of this her suit for declaration and injunction.
Before my learned friend proceeds, my lads,
Connected matter,
Yes, my lord.
the connected RFA, it is filed after 17.5 years. That is not served. I am one of
Because
the,
they were not party in 2001 suit.
Yes.
they were not parties, but they are not now challenged it.
Correct.
Other copies.
They claim that they were
Correct.
not
Please.
parties.
And
I'll serve a copy on him. His
Let them
grievance
serve
is copy is
copy.
not served.
And
I'll serve a copy.
940, ಸೆಕೆಂಡ್ ಸೆಟ್ ಹಾಕ್ಬೇಕು ಅದು ನೋಡೋಣ ಬಟ್ ನಾವು ಇದರಲ್ಲಿ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಕನ್ಸಿಡರ್ ಮಾಡೋಣ.
In fact, my lord, based on the earlier judgment, my lord, the court holds that I have not proved. Only on the basis of that judgment. My lord, in that judgment, the question,
ಪ್ರೇಯರ್ ಇಸ್ ನಾಟ್ ಟು ಎಲಿನೇಟ್ ಅಷ್ಟೇ ಅಲ್ವಾ?
yes, my lord. Not to interfere, my lord.
ಇಲ್ಲ.
A temporary injunction is sought.
ಅಲಿನೇಟಿಂಗ್ ಅಂಡ್ ಕ್ರಿಯೇಟಿಂಗ್ ಎನ್ಕಂಬ್ರೆನ್ಸ್ ಅಂತ ಇದೆ ನಿಮ್ ಪ್ರೇಯರ್. Admit call for TCS. Appellant's counsel shall submit the paperbooks within
Since the property is in his name,
ಎಷ್ಟು ದಿವಸದಲ್ಲಿ ಹಾಕ್ತೀರಿ ಪೇಪರ್ ಬುಕ್ಸ್?
4 weeks.
Within 4 weeks. ಜಾಸ್ತಿ ಇದೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಲ್ಲ 43 and 17. Within 4 weeks. Respondents are available. ಒಬ್ಬರೇ ಇರೋದಲ್ವಾ ಇದರಲ್ಲಿ?
ಅಲ್ಲ ಅದರ್ ರೆಸ್ಪಾಂಡೆಂಟ್
Other respondents are there.
ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾಗುತ್ತೆ.
Issue notice to you appear for only first respondent.
1 and 2 minutes.
1 and 2. Srihari for R1. Issue notice to respondents 3 to 5. 3 to 5. Long series of sales ಎಲ್ಲ ಇದೆ. Respondents are now who is the last owner?
Presently, I am the owner.
No. Last. Now he holds only the decree.
Yes, my lord. He holds an earlier decree.
Claiming to them are restrained from he restrained till next hearing date from alienating the suit shaded property in any matter. In any matter. List on 4 weeks ಆದ್ಮೇಲೆ ಹಾಕೊಂಡಿದ್ದೀನಿ.
29/10.
29/10.
Meanwhile,
Next matter ಅಲ್ಲಿ non-compliance of office objection 4th time ಅಂತ ಇದೆ ಅಲ್ಲ ಇದು.
My lord, since it was connected, Lord, they refused to give the books for complaints since it's already. Sorry. Yes. And my lord, the other objection is, Lord, a dead person is made a party.
20 Pratap Ram Gupta alias Ramaya to be.
He is dead, my lord. So, my lord, we had arrayed the LRs as party. In the connected matter also, the LRs are available. So, my lord, the office has raised an objection.
Filed by the LR only.
No, my lord, the original suit was filed by the LR's father. My lord, the office now wanted the,
Person who filed the suit.
yes, he is already dead.
She was not a party in that case.
Yes. We have already arrayed the LRs as party. The office has raised an objection that the cost title differs because we have made LRs as party to the appeal. And the cost title reflects the dead person's name.
Cost in the cost title, where have you mentioned? Below his name only. What?
My lord.
Eಲ್ಲಿ mention ಮಾಡಿದಿರಿ?
Mention ಮಾಡಿರಲಿಲ್ಲ. The office objection raised ಮಾಡಿದಾಗ we have stated, my lord,
State in the appeal memo. no? You have
I
to-
shall
you
do
have to
so. my
state
lord. I
in
shall
the
comply the requirements, my lord.
The appeal. Since appellant's counsel submits that since original plaintiff died, the appeal is filed against respond number 1 and 2. No? Who are the LRs?
1 and 2. The LRs are 1 and 2.
He's a-
We have mentioned him as dead.
He shall make an endorsement to that effect in the appeal memo. And furnish the copy of the amended appeal memo. The office objection is disposed of accordingly. ನೀವು ನೋಟಿಸ್ ತಗೊಂಡಿದ್ದೀರಾ ಇದರಲ್ಲಿ ಆಲ್ರೆಡಿ?
ಇನ್ನ ಇಲ್ಲ.
ಇಲ್ಲ. I'll serve a copy on him.
ನಾ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ.
ಸೆಕೆಂಡ್ ಸೆಟ್ 2 weeks ಟೈಮ್ ಇಸ್ ಗ್ರಾಂಟೆಡ್ ಟು ಅಲ್ಲ ಅವ್ರ ನೋಟಿಸ್ ಅದು ಅಟ್ಲೀಸ್ಟ್ ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಅವ್ರ ಹೆಸರಾದ್ರೂ ಬರುತ್ತಲ್ಲ ತಗೊಂಡ್ರೆ ಎಷ್ಟಿದು 949. You accept notice for them in this
1 and
case?
2, 1 and 2 I accept.
1 and
I don't
2
know what is the
1 and
status.
2. 1 and 2 only.
Pratap Singh, his LRs, you appear for them, no?
Please, madam. ಇಲ್ಲ ಸ್ಟೇಟಸ್ ಏನಿದೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ ಅದಕ್ಕೆ.
They are shown as respond number 1 and 2.
Then I'll accept 1 and 2.
Saraswati Amma and Sridhar
Please,
Babu.
please, please. ಹೇಳಿ.
1 and 2.
1 and 2.
3 and 4.
Same persons.
Same.
Please.
Next.
ಇಲ್ಲ ಅದರಲ್ಲಿ before accepting notice, let them serve a copy. I'll file my objections to the condemnation of delay application minutes.
Because for
ನೀವು ವಕಾಲತ್ ಹಾಕದೆ ಅಬ್ಜೆಕ್ಷನ್ ಹೇಗೆ ಹಾಕ್ತೀರಾ? ನೀವು ಅಂಡರ್ಟೇಕ್ ಮಾಡಿ ವಕಾಲತ್ ಹಾಕಿ ಅದರಲ್ಲಿ.
ಮತ್ತೆ that should not be taken as a matter is admitted or
ಅಡ್ಮಿಟ್ ಎಲ್ಲ ಆಗಿದೆ, ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಡ್ಮಿಟ್ ಮಾಡಿದೀವಿ. ಇದ್ರಲ್ಲಿ ಅಡ್ಮಿಟ್ ಮಾಡಿಲ್ಲ. You only said that there is delay in filing the appeal.
ಹೌದು 17 ವರ್ಷ ಇದೆ.
ಹೇಗಿದ್ರು ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ಇದೆ ಅಲ್ಲ.
ಹೌದು.
ಶ್ರೀಹರಿ AV Learned Counsel undertakes to appear for respondent number 1 and 2. His name he shall file the wakalat in the registry within 10 days. Appellant's counsel shall file serve the copies and correct. ಇನ್ನಿಬ್ಬರದು ನೀವು ಸೆಕೆಂಡ್ ಸೆಟ್ ಕೊಟ್ರೆ ನೋಟಿಸ್ ಆಗುತ್ತೆ.
Very well. I shall.
Other office subsection shall be complied within 10 days.
Well.
If needful is done, issue notice to response 3 and 4.
Right.
So, 29.
Please.
Bill number 39, Keshavyam Datar, Joseph Anil Kumar.
You have to file objections on the IAM.
Appearing for the appellant, my lord.
Yes.
My lord.
These are filed afresh. When did you appear? You have filed KVIT.
I have
Copies
His
are-
file KVIT. I've served a copy.
Last week it was served, my lord. I have filed for certified copies of the order sheets
The sheets of?
of the trial court suit, my lord, where the appellant has undertaken. That has to be secured.
Appellant has undertaken for what?
Undertaken to vacate the premises before the execution court, my lord.
Correct.
My lords,
Then till next hearing date, till you filing objection, at least undertake that you will not execute.
I am not
You have
pursuing.
filed execution.
I have filed execution, my lord. In the execution, the appellant appears before the court.
Correct.
my lord, it's
and-
my
and
appeal.
Undertakes, my
Is
lord.
that correct? He says that your
My
appeal
lords,
is undertaken then?
The appellant is a 67-year-old lady.
Hmm.
Okay, and she is related to the defendant. She is, has some medical issues as well because of her age. In view of which, I don't know what submissions has transpired.
You do not.
I am not personally aware of that knowledge, but even if that may be so, this is, though that she has preferred the present appeal, is prior to that undertaking given or alleged to have been given. So which is why I only pray that permit me to kindly argue on this matter. my lord.
May I submit?
Let there be an interim stay till they file objections
Grateful.
I'll file it tomorrow.
tomorrow.
Please.
My lords, in that case,
If I
one
secure the certified copies
if-
today,
if
my
I
lord,
may-
along with that, I'll file it tomorrow, sir.
Yes.
one submission, my lords. The issue in lists is with respect to adoption is concerned. Whether the appellant is the adopted daughter of one Kamala Shankar Rao. Kamala Shankar Rao and her brother, Mr. S.S. Patbidri, had jointly purchased a property and constructed a building. Now, the trial court, without going into that aspect, has passed the impugned judgment. At para 27, my lords,
They were framed and they were answered.
my lord, at para 27, page number 36, they go on an assumption. The trial court goes on an assumption. However, even assuming the fact that Kamala Rao had interest in the property, when she had interest in the property, she has adopted child. That is not an disputed fact at all. They say it in their plain documents that I am the adopted grandniece of Kamala Shankar Rao. So when that is the case, in terms of section 12 of Hindu Adoption and Maintenance Act, I have an interest in the property. When I have an interest, how can I be evicted?
Correct.
Lord, kindly consider, Lord. The adoption is never proved, my lord.
See, this is a matter of 2018. They
Lord,
had a-
I am not young, my lord. My lord,
You are related.
I am also 68 years old. I have no place to stay.
Correct. Till next hearing date.
My lord, may kindly consider, My lord,
Because this is a first appeal.
please,
When
my
it is
lord.
a statutory appeal, they have
My lord,
right of appeal.
kindly consider,
To suit for possession.
Lord, I have no house to stay.
My lord,
in
he's
my age,
residing in Australia.
I have to come back. I have no place to
That's all.
stay.
I want to stay
That's
with,
all.
in my old age, in my house, my lord, which is
Ah,
bequeathed to me.
Still serial number.
Lord,
39 minutes.
page number 68, maybe, Lord, page number 68, my lord, para number 7.
68. What is page number 68?
Page number 68 is a will which the appellant is claiming rights on, my lord.
I have an independent right as an adopted
Let me
child.
submit, my lord. Let me submit. My lord. Page number 68, para 7, my lord.
Oh. Yes.
Lord, para 7, it says,
Hmm.
I and my elder brother, so and so, have had few agreements in family agreements in 1983, wherein we had reached an agreement that I construct a building on the first floor of the property. Lord, thereafter, after the address Bangalore 56, and I and my elder sister, so and so, shall have a life interest in the said property, and after we pass away, the property shall devolve on the younger son of my brother, that is me, my lord. That is the plaintiff.
Yes.
In the
I
suit.
may be permitted
My
to
lord,
continue reading, my lord.
Lord, 1 second.
I have constructed a RCC.
Let him complete. Why do you do like this, like a market?
Apologize me.
Yes.
Lord, the defendant has claimed her rights over this document, my lord.
Correct. Life interest now that gets enlarged in view of section 14.
No, my lord, life interest only to my sister, my father's sister.
Right?
Not-
That lady
not-
Kamala Rao, she says here that we have life interest.
True,
only.
my lord.
You are trying to say that if only life interest and they are in position, that
They are not in possession, my lord. The appellant is in possession.
did you seek the possession of the property?
Lord, after the death of my father's sister,
We-
Lord, may kindly hear me, my lord.
Yeah.
Lord, may kindly hear. My lord, the facts is this. My father purchased the property in the year 1972 or 1974, my lord. Thereafter, a property was constructed only in the ground floor in the year 1983. My sister was a spinster. Both the sisters were spinster, who was being referred in para number 7, which I have read, my lord. Since they were spinsters, we had an agreement that they would construct on the first floor of my property and stay. They had the life interest, my lord. The appellant here and claims that she was a distant relative of the my father's auntie.
We have disputed the relationship.
We have not, my lord. She is staying. She claims that,
First, answer our
my
question.
lord, as on the date of the suit, appellant was in possession of the property.
Our question, you are not directly answering. Whether you have disputed her relationship with the deceased Kamala?
Yeah, we have not disputed. We have said she is a distant relative. She doesn't have the lifetime interest, my lord. It has been,
Right, we'll consider that. Consider the heard.
kindly have it next week, my lord.
Let us consider the respondent. The cavator seeks time to file counter to I-8, 2 and 3 of 2024. What is that injunction you have sought?
My lord, not to interfere with possession, my lords. And application for stay, because they filed execution proceedings. Let them not interfere with my possession until the appeal is heard and disposed of by the school.
Suit itself was for possession.
Please, my lords.
Interim stay of execution of the interim decree. This is statutory appeal matter requires to be heard on receiving the records under circumstances. Interim stay of the execution of the interim decree. And till next hearing date. Admittedly, the appellant was in possession as on the date of the suit. Therefore, stay ಆದ್ರೆ ಅವ್ರು ಮಾಡಕ್ ಬರೋದಿಲ್ವಲ್ಲ ಮತ್ತೆ why is another
Stay the judgment and decree, my lords, and
correct. See, now you say they have filed execution petition to take the possession.
Possession.
That itself goes to show that they want to do it lawfully. Why do you seek possession?
my lords, now
Interim injunction.
my only apprehension is that because I'm a 67-year-old lady, they could use force, my lords.
Sufficient. Stay is sufficient.
I'll bow down to your lordships.
till next hearing date. Paperbooks, when do you file the paperbooks?
My lords, 8 weeks time, my lords. Because there are close to around 50 exhibits.
Within 6 weeks. 6 weeks, okay. List on, we'll grant date before that, 6 weeks only. For you, to enable you to file objection. List on
411.
for,
Allah, next week, I have to file objection.
You file the objection. We
But
are
I have no place to stay in other country also. I'm not young, I'm also 68.
date
23/9, 23/10.
Grateful,
Date.
grateful. My lords, may I seek for hand delivery, my lords, because executing matter is listed day after.
Take steps on that, my lord.
Yaar power of attorney, yaar produce note officer. CP. No, you have not produced the power.
I'll produce.
Caveat, along with the caveat now, if that is the case, no right of audience.
CP I produce, my I'll produce.
I remember. At request, now. Then 2083. At request, 2 weeks time is granted to comply the office objection on CP and file counter.
My lords, may I seek for hand delivery, my lords?
File a memo. and
Please,
the
ma'am.
order is
Grateful.
filed. Yes.
Bill number 40, P. Pradeep.
Stay. How much is awarded? 46 lakhs. Third admit, issue notice to the respondent. Issue notice to the response. Third admit, call for TCS, issue notice to the response. Interim stay of the execution of the interim award. Subject to appellant depositing 50% of the award amount before the tribunal within 4 weeks from the date of this order. List on
29/10.
29.
For further hearings, bill number 41, Manjunath BS, Gaurav GK.
Completed our argument.
Totally.
I also have one written argument. ಅವರು
They have
file-
already filed. Both
ಒಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀನಿ ಅಷ್ಟೇ ಇನ್ನೇನು
ಹಾಕ್ತಾ ಇದ್ದೀರಾ?
ಅವ್ರ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಸಿ.
I filed it on Friday itself, madam.
ಅಲ್ಲ ಇಲ್ಲಿದೆ, that we have seen. ಅಂತ ಇದ್ರಲ್ಲಿ 1940 ಇದು arbitration. What is that new thing you want to say here?
ಇಲ್ಲ ಏನಿಲ್ಲ ಅದೇ.
Anything new?
They
to
have
say?
raised a new point telling that 14(1) and 2 non-issue of notice is not a ground which is contemplated under section 30 or 33 of 1940 to set aside the award.
You are referring to. Now you argued only on 2 points.
I am
One
only
is 1 point, that is
ultimately
misconducting of the proceedings and non-service of 14 notice. Erade ground alva.
court of jurisdiction has not issued any notice.
Only 2 grounds had argued.
I had pointed out only 2 misconducts about the that
Misconduct means
the
misconduct of the proceedings.
the
The arbitrator or umpire.
legal misconduct of the umpire in the context that there is an admission the drawings meant for this project was not given. It is on record admitted. But despite that, the umpire says, no, you have to pay for that. He refers to his own personal
Right.
opinion of comparing car gears and this, and then says you have to pay.
No, that comes under which misconduct of the arbitrator.
Umpire.
That is appreciation of question of fact.
That's exactly. In fact,
So whether question of fact can.
the
be different.
2013 judgment, that is why I have cited, wherein it says it can be reappreciated.
What is the meaning of misconduct here?
That's
Legal
an
misconduct.
example that the honorable umpire gives.
Correct.
Preceding to that,
What is the exactly meaning of misconduct?
I have
If an arbitrator or umpire has misconducted himself or the proceedings, What is the meaning of misconduct?
My lord, in the legal jargon, going in the misconduct is, as now the settled position is that if it is totally contrary to the terms of the agreement or opposed to public policy.
That is now.
Yeah.
ಈಗ 1996
ಅಲ್ಲ,
Act ಅಲ್ಲಿ.
ultimately it is boiled down to that only.
ಅಲ್ಲ,
ಇಲ್ಲದೆ ಇದ್ರೆ
1940 Act ಅಲ್ಲಿ
Misconduct.
misconduct some ಏನಾದ್ರು
ಅಷ್ಟೇ ground
He
specified.
travels beyond the terms of the agreement and excessively exercises his jurisdiction beyond the terms of the agreement itself. Is
1940
misconduct.
Act ಅಲ್ಲಿ ಆಗಿರೋದ್ರಲ್ಲಿ ಆಗಿರೋದು.
Misconduct. I've relied on a latest judgment, 2022, which clearly says even personal opinion cannot amount to misconduct. Here is a case where the honorable umpire explains the entire evidence on record, principles of law, and then gives an example that does not amount to expressing any personal opinion.
Meaning in knowledge. According to section 14(3), notice was not given.
14, 1 and 2.
1 and 2, that is about arbitrator.
ಹೌದು.
Court notice.
14, 2.
But 14(2) notice is required.
Yes. What happens, my lord?
14(2) is, that is about filing of the award in the court.
Yes, only then.
It appears you argued court also had not issued the notice.
Yeah, yes,
Court.
14.2, court has to issue notice.
No, 14(2), the arbitrators or the umpire shall at the request of any party to the arbitration agreement or any person claiming under such party or if so directed by the court and upon the payment of the fees and charges due in respect of arbitration and the award and of its costs and charges of the filing of the award, cause the award or a signed copy of it together with any depositions, documents, etc. may have been taken and proved before them to be filed in the court.
Yes.
This is the arbitrator's notice.
No, my lords. And further it says, and the court shall thereupon give notice to the parties of the filing of the award.
In fact, section 119.
Section 14(1) stipulates for the honorable umpire to give the notice. 14(2) pertains to court giving notice.
14(3) said that the arbitrators or the umpires state a special case under clause B of section 13. The court, after giving notice to the parties and hearing them, shall pronounce its opinion.
ಅದಿಲ್ಲ ಇದರಲ್ಲಿ.
Not applicable to the
Only
facts of
two.
the case.
Only 2. Because 119, my lord, Article 119 Limitation Act commences on after I receive the notice under 14(2).
119A is not applicable when the arbitrator himself.
Because
When your written synopsis.
Please.
the jurisdiction of the court is invoked under 14(2), wherein the challenge to the filing of the award commences only 192, my lord. A and
ಇದು arbitration.
119A, my lord.
Limitation act.
Madam,
Arbitration ಅಂತಾನೆ ಕೇಳಿಸಿ.
A, my lord.
The date of service of the notice of making of the award 30 days for filing of the, of filing in court of an award. So the first, after the award is made, within 30 days, it has to be filed in the court,
Now, 30 days,
30 days.
30 days.
The date of service of the notice of the making of the award. This refers to 14(1). When an umpire files the award, this does not apply.
This.
When
for
umpire
filing-
files,
See, this article is applicable for filing in the court of an award. What is the period fixed for?
yes,
3 days.
date of service of
The date of service of notice of
the making of the award, that is under 14(1). Because the umpire is, after making the award and signing the award, issues notice to the parties about making of the award.
Right, in this case, award was filed by the party himself before the
Yes,
court.
yes. That
Please,
is
my
why,
lords, that
it-
is
that
because
is,
he has filed it on behalf of the umpire.
No,
So it
no,
is
no,
as
no.
good as the umpire filing it.
No.
What is disputed is my authorization. The appellant is not present on the date when the award is passed. Had he been present, it could have been assigned to him as well. But appellant is not present for whatever reasons known. No reasons.
In your submission, we have noted that, we have noticed that. You say that this applies only, this doesn't apply to the arbitrator filing the award.
Please, my lords. What happens, my lords, in a general situation, arbitrator issues notice saying, I have made an award. After issuing that notice, the parties go before the jurisdictional court and say, file an application for filing, getting the award from the honorable umpire. Here, I was caused to file it. So it is as good as the umpire himself has filed the award.
Award was passed on
26/6/2016,
It was filed in the court
3/8/2016,
26.
7 days.
notes is the clerk. General Burden, check.
Date of award, please repeat that.
26/6/2016, my lords.
2016 is the, we have noted somewhere.
The date of the award, the date of filing of section 14 and section 17 applications are 3/8/2016.
My contention is that is not before the court of jurisdiction. On 3/8/2016 is filed before a court without jurisdiction.
Lords, objections have been filed on 22/9/2016 before the court which did not have jurisdiction itself.
Yes. Yes. That's the first. Learned counsel for working arguments, rebuttal arguments. The same thing, whatever you have argued is.
Same,
highlighted.
same.
Anything else, new thing? Regarding argument,
I only answered that one point which they have raised.
that date.
I've also limited to the reply given by the learned and I've also limited to the reply given by the learned advocate for the appellant.
Post arbitration award. So shall we go through this with the arbitration or? No, no. We'll just go through your submission also. Pass over ಮಾಡಿ ಮಧ್ಯಾಹ್ನ we'll try to go through this. ಅಥವಾ ನೀವೇ ಯಾರೊಬ್ರು ಓದಿದ್ರು ನಾವು ಮುಗಿಸಿ ಹೋಗುವ.
ಆಯ್ತು. ಅಲ್ಲ, my lord, we are ready.
Material is.
The same submissions that my learned senior
Same,
friend
you have gone through
made.
that.
I have gone through, I've served now, same submissions that was made.
Okay, we'll do one thing. Till we come to the point for this consideration of these points, we'll dictate, otherwise these things keep pending only.
Please.
I had earlier filed one synopsis.
Yeah, filed it, both of you
Both
have
of
filed.
No, no,
already. We have-
only for the purpose of my lord to get the sequence of
The dates.
facts.
Even she.
ಯಾತಕ್ಕೆ
even-
contract,
It's also detailed.
either of one can be looked into.
ಅದನ್ನೇ,
Either of,
we have gone through that, they are very concise, we can go through that one. We can go according. I think there is no difference between these
Yeah, it is-
sequencing, there is no
No
dispute at all
difference.
about that. Third both side. These are things are fine. Silent. And ಒಂದು these are things are fine, challenging, and the following orders of the senior civil judge and JNSC, Sriranpatna. The particulars of the interim orders are as follows. The table and hakonde. The appellant, the brief facts of the case are as follows. That appellant, ನಿಮ್ಮ ಫ್ಯಾಕ್ಟರಿ ಹೆಸರೇನು? ಪಾಂಡವಪುರ ಸಹಕಾರಿ ಸಕ್ಕರೆ ಕಾರ್ಖಾನೆ.
ಪಾಂಡುಪುರ ಸಕ್ಕರೆ ಕಾರ್ಖಾನೆ.
ಕೋಆಪರೇಟಿವ್ ಅವಾರ್ಡ್ ಅಲ್ಲೂ ಬಂದಿದೆ ಅಲ್ವಾ ಅದು? ಯುವರ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್
Award ಅಲ್ಲೇ ಬಂದಿದೆ.
ಅವಾರ್ಡ್ ಅಲ್ಲಿ
ಬಂದಿದೆ.
the appellant. It's a cooperative society, no? It's a cooperative society running which runs a factory, sugar factory called Pandavapura Sahakari Sakkare Karkhane in Pandavapura town. It is within the limits of Pandavapura town, not in Pandavapura town, it seems. This factory is not in Pandavapura town. Have you seen that?
Outskirts.
It comes within Pandupura only.
ಅಲ್ಲ ಸಿಟಿ ಒಳಗಿಲ್ಲ.
Limits ಅಲ್ಲಿ ಬರುತ್ತೆ ಅದು.
Town
Town
ಒಳಗೆ.
ಇಲ್ಲ ಅದು.
ಪಾಂಡುಪುರ ಟೌನ್ ಸ್ವಲ್ಪ ದೂರ ಇದೆ.
Outskirts ಅಲ್ಲಿ ಇದೆ.
ಸ್ವಲ್ಪ ದೂರ ಇದೆ.
In the limits of Pandavapura town. Please take your seat. The respondent. The company. Registered company having its office at Lucknow in Uttar Pradesh state. The respondent carries on business of supply of sugar machinery and installation of sugar plants on turnkey basis in various parts of the country. The appellant invited tenders for converting its existing sugar unit, sugar factory, by expanding its its crushing capacity from 1,500 tons cane per day, bracketly TCD, to 3,500 ton TCD. On 6/12/1989 date ಮೊದಲು ಬರ್ತದೆ. On 21/9/1990, the respondent submitted its offer in response to the said tender invitation. After negotiations, the tender price was fixed at rupees 1,545 lakhs. This amount, this is correct, no? All.
Yeah, it's correct, madam.
1,545 lakhs. Both the parties entered into an agreement dated 21/9/1990 for designing, preparing, supplying, supervising, manufacture, erection and commission of machinery and equipment for expansion of from 1,500 TCD to 3,500 TCD. Commissioning of the sugar plant was scheduled. So the work was to be executed on or before 1/6/1990.
Please.
The contract work was to be executed on or before 1/6/1992. To enable the respondent to install the machinery, etc. As per clause 11(2) of the agreement was required to provide necessary infrastructure like civil work, as per is first this thing is 8-8. Both of you have filed an 8-8 only. Two mobilization funds. What was the amount of the two mobilization?
74 point, awardal ಇದೆ 74.5. I'll just point out. 74.5 lakhs. I'll just point out, Manu.
Because in your synopsis, you
13 of the award. Award of the honorable umpire.
ಇಲ್ಲ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆಯಾ? ಜಜ್ಮೆಂಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್
Judgment ಅಲ್ಲಿ ಇದೆ.
ಚೆನ್ನಾಗಿ ಬರೆದಿದ್ದಾರೆ.
73.25 lakhs. Judgment.
With a grace period of 15 days.
Judgment, it's at
Just we are saying.
page number 5.
As per the terms of the agreement, the appellant paid first and second mobilization advances, advance amount. Third mobilization, admittedly, third mobilization amount fell due for payment immediately after IFCI loan was signed, or within 180 days from the date of signing of the agreement, whichever is earlier. However, the same was not paid to the respondent. For securing for guaranteeing the performance of its contractual obligations, the respondent had submitted the bank guarantees the appellant. The third bank guarantee was invoked, no?
Please,
By the
note,
appellant.
both bank guarantees were invoked.
Okay, but trial court says third bank guarantee was invoked.
First two bank guarantee.
The trial court says that third bank guarantee, and as such, he had also submitted the third bank guarantee ಅಂತ ಹೇಳಿದ್ದಾರೆ. ನೀವು argument, while arguing also, you had
third mobilization fund ಕೊಟ್ಟಿದ್ದಿದ್ರೆ third
that was not given.
bank guarantee
That
ಕೊಟ್ಟಿದ್ದೆ.
was not reliable.
Two bank guarantees were submitted.
Only first two were
First two and first two were invoked.
Two bank guarantees. The appellant invoked those bank guarantees alleging violation of contractual obligations. Disputes arose between the parties. To settle that, on 16/1/1992, a meeting of monitoring committee was held. In that meeting, the appellant extended the period for completion of the work from 1/6/1992 to 1/6/1993. So monitoring committee also noticed that civil work was not
40% agila. So adukoskara you extend the commissioning work.
on the ground that the appellant had not completed the civil work and that has caused delay in the execution of the contract by the respondent. Further, in monitoring committee's meeting held on January 1992.
16/1/1992. 16/1/1992.
16/1/1992. No, note by the judgment note. He can correct me. 16/1/1992. The managing director of the committee directed the managing director of appellant to make payment to the plaintiff as per the agreement, to make payment to the respondent as per agreement towards third mobilization amount of rupees 73.25 lakhs. For design amount was not paid. The respondent alleged that despite offering to complete its work, the appellant did not accept it. The same in the guise of shortage of funds. There was a suggestion for reappreciation of the project cost. There was a IFCI. There was a suggestion by IFCI to reappreciate the project cost.
Alla IFCI in the loan togondu third mobilization.
ಕೊಡಬೇಕಾಗಿತ್ತು, but the judgment says that there was a suggestion by IFCI to reappreciate the project cost ಅಂತ ಹೇಳಿ. You abandoned the work first. The respondent invoked the arbitration clause of the agreement. and filed an application before Civil Judge Srirangpatna in AS number 1 of 1993. One of seeking appointment of the arbitrator. Original agreement was in their possession.
Please, my lords. There was a prayer for and not engage
For
any other.
permanent injunction. Then the appellant from carrying out the work, pending work through any other agencies. On 17/12/1994, Lord Civil Judge allowed AS number 1 of 1993, directing the respondent to file the original agreement containing the arbitration clause and refer the matter to two arbitrators, namely Honorable Justice, two former judges. Srivastava was from UP and the
Allahabad, High Court of Allahabad.
Two former judges. Refer the matters to Honorable Justice UC Srivastava, former judge of Allahabad High Court, and Justice PP Bopanna, Honorable Judge of Honorable former Judge of High Court of Karnataka. That was on 3/12/1994. On 3/12/1994.
Letter was sent.
Civil Judge directed its registry to send the records to the Honorable arbitrators by 12/12/1994. The Honorable arbitrators heard the matter. Justice UC Srivastava gave his award on 11/11/1997, allowing the claim of the respondent in part. On 12/12/1997, Honorable Justice PP Bopanna rendered his award, rejecting the claim of the respondent and allowing the counterclaim, claim of the appellant in part, so partly allowing the claim of the appellant. Since there were divergent findings of two arbitrators, former Chandrasekhar could not proceed with the work, proceed with the arbitration proceedings. For a long time. On 8/6/2006, as the parties did not appear before the court and nothing was heard regarding the arbitration proceedings, Lord Civil Judge Srirangpatna closed the proceedings in AS number 1 of 1993. Liberty was not given, dismissed, closed anta madidare, dismissed anta madidare.
No, it is there in the judgment that is referred. It just said closed for the time at present.
We have mentioned dismissed, but we have seen that it is closed.
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 Stand corrected.
Close the proceedings for the time being. After the demise of Honorable Justice D.M. Chandrasekhar, The umpire, I'm sorry, arbitrators appointed Justice G.P. Mathur, the former judge of Supreme Court of India, as umpire. The letter was sent by the umpire to the son of the Justice D.M.
Please, for the purpose of retrieving the records.
On 3/6/2014, addressed a letter to Shri D.C. Shivdev, son of late Justice D.M. Chandrasekhar, informing about the arbitral proceedings and to hand over the records of the arbitration proceedings to the umpire. In response to that, on 11/7/2014, Shri D.C. Shivdev addressed a letter saying that the records are not traceable. Honorable the umpire, by order dated 12/7/2014, directed counsel for the respond herein to reconstruct the entire records and submit. Accordingly, the counsel for the respondent who appeared before the before the umpire reconstructed the proceedings and submitted the same to the umpire, serving a copy on the appellant, serving the copies on the appellant. On 13/9/2014, the honorable umpire recorded that authenticity of the reconstructed records were admitted by the appellant and service of non-appellant, e-proceedings, appellant hearing, and the copies were served on it. On 6/6/2016, the honorable umpire sent a notice to the appellant and respondent informing that the award will be signed and pronounced on 26/6/2016. Notice was served on both the parties. On 26/6/2016, the honorable umpire pronounced the award partly allowing the claim of the respondent, namely awarding rupees 86,45,454 with interest at 14% per annum from the date of the reference, that is 17/12/1994, till the date of the award, and 16% per annum from the date of the award till the date of realization of the amount. And cost of the proceedings were awarded to the respondent. The counterclaim of the appellant was rejected. In the proceedings stated 26/6/2016, the honorable umpire recorded as follows. award and records B ಅಂತ ಕರೀತಾರೆ. The award and records were handed over to the counsel of the claimant to proceed further to cause the award to be filed in court. C. The respondent, despite receipt of the notice, was not present at the time of pronouncement of the award. The present respondent filed AA number 5001 of 2016. ಇಲ್ಲಿ ಸ್ವಲ್ಪ ಪಾರ್ಟ್ಸ್ ಇದೆ ಯಾಕೆ ಮಲ್ಟಿಪ್ಲೈ ಆಯ್ತು ಅಂತ. Under section 14 and 17 of the Arbitration Act, before third additional district and session judge Mandya, sitting at Srirangpatna, to accept the award and drop the decree in accordance with the award. Go to notice of when this order was passed in 2017.
Please, my lords. 28/1/2017.
28/1/2017.
Column number 24. Refer it my synopsis, serial number 24.
Yes. See, this 5001 of 2016 was to accept the award and pass the decree.
Please, my lord. That's
And,
AA 5001.
501.
AA and AS. AS was,
Miscellaneous 51 of 2016. That is
that was for
transfer.
transfer petition under section 24.
That was filed by you only.
No, it was filed by the appellant hearing.
Then why have you mentioned as respondent in your?
Appellant, it was filed by the appellant and we gave no objection.
AA 5001 of 2016. There is one more 5001. of-
AS, that is AS, arbitration suit.
This appellant filed. That is miscellaneous. See, earlier, AA number 5001 of 2016 was filed by them. AS 5001 of 2016,
Filed by the appellant hearing.
appellant for seeking what relief?
Setting aside of the
Setting
award.
aside the award. Then they both of them were transferred.
Please.
14 and 17.
No, the dates should be in. Similarly, the appellant filed AS number 5001 of 2016 before the third additional district judge Srirangpatna under section 30 and 33 of the Arbitration Act. Theirs were under 14 and 17 and yours were 30 and 33 Act for setting aside the award of the umpire dated 26/6/2016. So that was filed after noticing this AA 5001 of 2016.
AA 5001 of 2016 notice was issued and they filed AS 5.
Thereafter,
Please.
the said application was filed after the appellant receiving notice in AA number 5001 of 2016 on 5/8/2016. The appellant filed on 24/10/2016. The appellant filed miscellaneous petition number 51 of 2016 before the principal district and session judge Mandya under section 24 of Civil Procedure Code to transfer. Seeking transfer of AA number 5001 of 2016 and AS number 5001 of 2016 from the file of third additional district and session judge Srirangpatna to the court of principal senior civil judge JMFC Srirangpatna. The said application was allowed on 28/1/2017. And the learned principal district judge Manda transferred withdrew and transferred A number 5001 of 2016 and AS number 5001 of 2016 to the Court of Principal Senior Civil Judge Srirangpatna. On such transfer, A 5001 of 2016 was renumbered as AA number 1 of 2017 and AS number 5001 of 2016 was renumbered as AS number 1 of 2017. On such transfer, on 10/3/2017, in fact, instead of giving narrating it instead of giving it in a narrative way, better to put it in the tabular form only.
It gives more
Because,
I have referred to parties in claimant and respondent ಅಂತ refer ಮಾಡಿದ್ದೀನಿ.
now we'll refer here as appellant
please,
and respondent. That will avoid confusion. On such transfer on 10/3/2017, the records of AS number 1 of 1993 were traced and placed before the court. Learned senior civil judge consolidated AS number 1 of 2017, AA 1 of 2017 and AS number 1 of 1993 together on 15/4/2017. The appellant filed restriction number WP number 14,329 of 2018 before this court, claiming that the notice of award was not served in terms of notice of award by the arbitrator or this in writ petition number 14,329. What was your ground notice of by the court?
Court of jurisdiction.
Notice of the award was not issued by the court as required under section 14(2) of the Act. This court by judgment order dated 3/4/2018 dismissed the writ petition. Otherwise, liberty was given to raise this point.
Before the
Reserving liberty to the appellant to raise that ground in the proceeding before the senior civil judge Srirangpatna in AS number 1 of 2017 and other connected matters. That was on 29/5/2018 dismissal. The date tappaitu. Date dismissed on 29/5/2018 and 3/4.
liberty was given to raise this objection before this honorable court in appeal, not before the civil
Raise
judge.
these objections at the time of hearing of the matter on merits 2018. Now this order was passed
WP copy
2018.
to 2018, please.
These appeals are filed in 2019.
19.
But where is the question of there raising these contentions here?
What happened? ಈಗ object ಮಾಡ್ಬಿಡಿ, let the proceedings take place. You can take it as a ground for setting aside the award in the appellate court ಅಂತ order ಆಗಿತ್ತು by this honorable.
Copy is at page.
Copy has been
Paper book page.
In 2879, appeal number 2879.
No, this paper book you have given.
ನಾನು ಫೈಲ್ ಮಾಡಿಲ್ಲ. Appellant has filed it along with the appeal memo.
Is that correct? Was it in the arbitration suit or in the
106.
106 RF MFA number?
4668.
4668.
2879.
4668
2879 ಅಲ್ಲ?
466 ಯಾವ್ದಾದ್ರು ಕೊಡಿ, ಮೂರರಲ್ಲೂ ಇದೆ.
ಲೈನ್
4666.
ಅಲ್ಲ 466 ಇದು ಅಪೀಲ್ ಪೇಜ್ ನಂಬರ್ ಎಷ್ಟು? 106. Without what stands reserving liberty to the petitioner to raise this ground in the event of orders adverse to the interest of the petitioner being passed in case number so and so in the appeal filed under section 38 of the Arbitration Act. 1996 ಆಗಿದೆ.
ಹೊಸ ಆಕ್ಟ್ ಆಗಿದೆ, but it is actually under section 39 of.
So it is in the appeal, not in the arbitration. But the suit was not yet disposed of by that time.
Because the trial judge found it sufficient compliance of notice because both appeared anta order was passed. Since there is sufficient compliance agide, you can take that ground before the
That could
appellate.
have been urged even by hearing the main matter also, that liberty could have been reserved. Because this award was passed in 2019, 21st February 2009.
In fact, I will not read the memo, what I had filed before the trial court.
Memo is at page number? Trial court.
Before
Right, you raised this point before the trial
Yes,
court,
one of
but that was not accepted by the trial court.
No, the reason why I was pointing out was, since the Srirangapatna court was the court which had the jurisdiction, that should have issued the notice first. Only then my 30 days for filing contesting the award starts. So the exercise of jurisdiction by the Srirangapatna court was important.
That you have raised even now also here, right? But when this judgment was passed, yes, was still pending.
Please, it was pending.
My first part was.
Why that liberty was given to urge it in the appeal? You could have raised it in even in the main matter. That was at the initial stage, like IA and main matter.
No, it was heard on this, without recording any evidence, it was disposed of by hearing.
Recording, generally in these cases, evidence will not be recorded.
No, in AS1, in the case what I have filed, it has to be treated as a suit.
Yes.
Rule 7 of the arbitration rule says, it has to be, because there are certain documents, all these things I have the liberty to contest as a suit. But
even now, under section 34 also, they are contested as the suits only, but their evidence will not be recorded.
Depending on the circumstances. The Supreme Court has permitted adducing evidence.
Okay.
In this case, what had happened was.
Is that so?
No.
Lordship, serial number 42.
Appeal, no? The liberty was to raise this
Raise in the
grounds.
appeal, because.
Raise such contentions in the appeal to be filed under section 38. Now this appeal is not under section 38.
By mistake, that is.
To be filed before this court under section 39. 39 of the Act 1940. 38 of, even 38 ಅಲ್ಲ 37 ಅಲ್ಲ ಬರೋದು. ಅಲ್ಲ ಈಗ 96 ಆಕ್ಟ್ ಆದ್ರೂ 37. That is a typographical error. 39 of Act 1940. Okay. Thereafter, the learned senior civil judge, thereafter, the appellant challenged the proceedings before the learned civil judge in AS number 1 of 1993 and 1 of 2017. On the ground that the award was bad in law due to misconduct of the arbitration proceedings.
Sufficient notice was not issued and
That will come, that is second point. Misconduct of the arbitration
Misconduct.
proceedings and for want of notice as required under section 14(2) of the Act 1940. These two grounds, no?
section 30 hakdaga, they say about non-issuance of notice under 14(1) also,
Arbitrators.
arbitrators.
ಅಥವಾ on the following grounds ಅಂತ ಮಾಡ್ಕೊಂಡು on the following grounds. Number one, that that is misconduct of proceedings.
Please.
Misconduct of the arbitration proceedings by the umpire. Number one, two, non-service of notice of award as per section
14(1).
14(1) of 1940 Act, the Act 1940, and non-service of notice by the court under section 14(2) of Act 1940. Let's senior civil judge and hearing the parties by the interim common judgment dated 21/2/2019 dismissed AS number 1 of 2017. 1 of 2017. And allowed decreed ಅಂತ ಮಾಡಿದ್ದಾರೆ.
Decreed 1 of 1993.
And decreed AS number 1 of 1993 and A 1 of 2017. 2017. By which the award of the umpire became the decree of the order of the court. The said judgment is challenged by the appellants in the above appeals. The DS Manjunath, Learned Senior Counsel for the appellant reiterating the grounds of appeal. The same grounds, no, here also again.
Yes.
The grounds of appeal.
In fact, the trial court has culled out 1 to 36 order sheet. Same can be referred for convenience.
1 to?
At page 17, internal page of trial court judgment.
You have very elaborately taken other grounds also, it seems.
Yes, yes.
Trial court. Now you have confined here these three grounds. Okay. So we don't think it is necessary to call out all those non-application of. We have noted also misconduct of proceedings, non-application of mind, non-application of mind. That misconduct
at
of
the
the
time of-
arbitrator.
In fact, the grievance is the trial court has not considered any of these grounds.
At the time of admitting this appeal, the appeal was restricted to only quantum.
Where is
There's an order to that effect by this honorable.
show us from the which order date? Order sheet.
Can you
Just
permit it?
check if that is the case, you may not be having those grounds.
Please, ma'am.
Alla, order sheet. Which?
I'll point out. 28/7. No, correct.
Order sheet also tell you.
17/3/2021, my lord.
Common order, ಎಲ್ಲದ್ರಲ್ಲಿ? 7. Assailing the award of the honorable umpire. It doesn't say that it is admitted only to consider that point. It doesn't say. It is, it appears
Opinion
that
of-
counsel who argued, you only argued.
Yes, yes.
It appears they argued
What
and the
happened was
quantum.
acting stay.
And you two have not filed any appeal seeking enhancement of the
I have not.
That's what that is called. Interim stay of the award of so and so. That it doesn't say that the appeal is admitted only to consider this point. So we'll continue in the afternoon. Yes.
Serial number 48.
Just
Please.
ಇದೆಲ್ಲ related. Yes.
Serial number 49 you are asked.
Hmm.
Next week.
Who is there?
48,
I am for
48,
respond.
well,
48, 49.
well, 48, we are exploring the possibility of settlement.
ನಮಗೂ ಆಗೋದಿಲ್ಲ ಈಗ ಈ ಕೇಸ್ ತಗೊಂಡಿದೆ 1990 ಕೇಸ್ ಅದು
49.
40,
when do you want it?
2 weeks, my lord, exploring the possibility of settlement. Well,
I appear for the respondent. They are offering a settlement. I will speak to them, but a date may be fixed.
Arbitration ಇದನ್ನು
Please, 2 weeks, my lord.
both councils seek
Could a date kindly be fixed?
that the parties are trying to explore the possibility of settlement.
Please.
Serial number
As-
49.
Just after 2 weeks.
2 weeks.
Could it be on the 24th?
24.
24th, 2 weeks.
Just after 2 weeks, ಬೇಡ list on 24 9.
49 you are
Keep
asked.
Serial
number 47 please.
49.
Yes sir.
ಯಾರು ತಗೊಳ್ಳ ನೀವೇ ಹೇಳಿ 47 49
49 weeks.
ಯಾರೋ ಒಂದು ನಿಮ್ಗೆ ಕೋಟಾಲ್ ಮೂಡಿದೆ ತಡೀರಿ ಅದು
ನಂದಿಲ್ಲ.
ಅಲ್ಲ ನಿಮ್ದಲ್ಲ ನಿಮ್ ಕೇಸಲ್ಲಿ ಮೂಡಿದೆ 49 ಅಲ್ಲಿ ಯಾರು ಮೂವ್ ಮಾಡಿಲ್ಲ ಕೇಸ್ ಲೀಲಾಧರ್ ಇದ್ರಲ್ಲಿ ಯಾರು
Respondent.
ನೀವು both of you are for respondent
47.
ಸರಿ 49 ನಲ್ಲಿ who is appearing for the appellant ಇಲ್ಲ
ಕೃಷ್ಣಮೂರ್ತಿ ಡಿ.
ಇಲ್ಲ ಬರ್ಕೊ as requested by response counsel list on ಏನಾದ್ರು ಡೇಟ್ ಕೊಟ್ಟು ಡೇಟ್ ಗಿವನ್ ಯಾಕೆ ಅವ್ರು ಇನ್ಸಿಸ್ಟ್ ಮಾಡಿದ್ದೀರಾ
Yes, yes.
specific performance suit
Yes, sir.
you have succeeded or
We have succeeded.
plaintiff
Suit is
succeeded?
dismissed.
Suit is-
Deposit the amount we have deposited.
Date
2310.
2310 yes
Much of-
47 ಆಯ್ತು
47
ಹಾ.
partition and some settlement talk is on. So
ಹೌದಾ?
19th ಕೊಟ್ರೆ ಡೇಟು
ಯಾರು
other side ಇದೆ.
ಕರೆಕ್ಟ್ ಸೆಟಲ್ಮೆಂಟ್ ಆಗ್ತಾ ಇದೆ ಅಂತ ಅಬೌಟ್ ಕೌನ್ಸಿಲ್ ಸೀಕ್ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಆನ್ ದ ಗ್ರೌಂಡ್ ಆಫ್ ಲೈಕ್ಲಿಹುಡ್ ಆಫ್ ಸೆಟಲ್ಮೆಂಟ್ ನೆಕ್ಸ್ಟ್ ಟು ರಿಪೋರ್ಟ್ ಸೆಟಲ್ಮೆಂಟ್ ಲಿಸ್ಟ್ ಆನ್ ಯು ರಿಪೋರ್ಟ್
ನಾವ್ ಬೇಕಾದ್ರೆ ಸೆಟಲ್ ಮಾಡ್ಕೊಂಡ್ರೆ ರಿಪೋರ್ಟೇ ಮಾಡ್ಬಿಡ್ತೀವಿ.
ಈ ಆರ್ಬಿಟ್ರೇಷನ್ ಗಳು ಸೆಟಲ್ ಆಗ್ತವೆ ಯಾಕಂದ್ರೆ ಅವ್ರು ಸ್ಟ್ರೇಂಜರ್ಸ್ ಇರ್ತಾರೆ ಈ ಫ್ಯಾಮಿಲಿ ಮ್ಯಾಟರ್ ಸೆಟಲ್ ಆಗೋದಿಲ್ಲ ಪಾರ್ಟಿಷನ್ ಸೂಟ್ಸ್ ಎಸ್ ಲಿಸ್ಟ್ ಆನ್ ದರ್ಶನ್ 19 ಎಸ್
My lords.
ಮತ್ತೆ ಯಾರ್ದು
58, my lords.
58
I'm appearing for the
I
respondent.
appear
my
for the
lords.
appellant, my lord.
My lords, I have just received the entire appeal copy today and I have to collect the paper book also. If my lords may kindly have it on 28th, my lords.
In this case, I appear for respondent. The matter is not at all,
58 who appears for the appellant
I appear for respondent.
ಅವರು ರೆಸ್ಪಾನ್ಸ್ she is also
Appellant, my lord.
respondent
I appeal for the
ಆಕರ್ಷ್ ಕುಮಾರ್ ಗೌಡ ಅವ್ರ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕೇಳ್ತಾ ಇದಾರೆ
25th, my lord.
25 ಇದರಲ್ಲಿ ಡಿಲೇ ಏನಿಲ್ಲ
The lordship will kindly sir, make the submission.
ಲಿಸ್ಟ್ ಆನ್ 25/9
In this
Yes.
case, my lord, this matter has not been admitted,
ಹೌದು ಅಡ್ಮಿಟ್ ಆಗಿ
not been, let the matter be posted for admission.
IML ಬಂದಿದೆ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ
Final hearing ಅಂತ ಆಗ್ಬಿಟ್ಟಿದೆ, ತಪ್ಪಾಗಿದೆ last time post ಮಾಡುವಾಗ. So it may be posted for admission.
by response counsel
So simply they are dragging.
so and so for admission admission all right.
The matter is dragged from.
Serial number 45.
Hmm.
I appear for appellant in 2 cases. Vijay
My lord, I am
Kumar
for the
respondent.
appellant, my lord, in the connected appeal.
Take it up on 25th, my lord.
Hello, I am ready, my lord.
Etcetera ಏನಾರ ಇದೆಯಾ
My lord, I am ready.
is for the appellant
I am ready, my lord.
claimants
I am for a claimant.
25th.
claimants
25th, my lord.
we are taking up some very old matter today not possible
Please, my lord. Otherwise, I am ready, my lord.
25/9.
25.
ಜವಳಿ ಅವ್ರದ್ದು ಏನಿದೆ
That is MSME matter, your lordship. Records have to come from.
ನೀವು ಅವ್ರು ನೋಟಿಸ್ ಹೋಗಿದೆ ನೋಟಿಸ್ ಹೋಗಿ ಬಂದಿದ್ದಕ್ಕೇನು ಕಾಣ್ತಾ ಇಲ್ಲ ನಿತೀಶ್ ಪಾಟೀಲ್ ಅಂತ ಯಾರು ಡೈರೆಕ್ಟರ್ ಇದಾರೆ ಅಂತ
43, your lordship.
ಹೌದು ಅದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಹೋಗಿದ್ದಕ್ಕೇನೋ ಇದೆ ನೋಡಿ ಲಾಸ್ಟ್ ಟೈಮ್ had issued notice to inform.
Please, your lord.
ಅದ್ರಲ್ಲಿ ಒಂದು ನೋಟಿಸ್ ಹೋಗಿತ್ತು you submitted that records are required
Please, because your lordship wanted to know what was the methodology followed for termination of the conciliation under the MSME Act, because the same body continues to pass an award. The records bandilla, then it will become difficult.
But we have to take further. You do one. ಅದಲ್ಲ ಅದರಲ್ಲಿ ಅವ್ರಿಗೊಬ್ರಿಗೆ ನಾವು ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ವಿ ಇದೇ ಕೇಸ ನಿತೀಶ್
Please, your lord. Yeah, your lordship had to, that MSME council ಇಂದ ಬರ್ಬೇಕು.
ಅದಕ್ಕೆ ಏನಾಗಿದೆ ಅಂತ ಫರ್ದರ್ ಸ್ಟೆಪ್ಸ್ ವಿ ಹ್ಯಾವ್ ಟು ಟೇಕ್.
Please, your lord.
Because if you are served and if he has not submitted, then we will have to. ಸರ್ವ್ ಆಗಿದ್ದಕ್ಕೆ ಏನು ತೋರಿಸ್ತಾ ಇಲ್ಲ ಅಲ್ಲ ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ತೋರಿಸಿಲ್ಲ.
Await notice.
49 ಇಶ್ಯೂ ಆಗಿದೆ ಅಂತ ಇನ್ನು ನಮ್ಗೆ registration the status of service of notice on ಅದೇ ಮ್ಯಾನೇಜಿಂಗ್ ಡೈರೆಕ್ಟರ್ ಏನೋ ಇದೆ ನೋಡಿ ಇಂದಿನ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ and list on date 39
13. 30th, 30. Okay.
yes 60 or 660 ನನಗೆ ಯಾರೋ 130 ಗೆ ಯಾರೋ ಬರ್ತಾರೆ ಅಂತ ಹೇಳಿದ್ರು. ಒಂದು ನಿಮಿಷ 60 parties are presented. See and other side ಆಯ್ತು 230 ಗೆ can come.
Court officer. Court officer, serial number 50 ಇದೆಯಾ ಅಥವಾ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಆಗಿದೆ ಮೇಡಮ್? ಕೇಳಿಸ್ತಾ ಇಲ್ಲ, ಕೋರ್ಟ್ ಹಾಲ್ ಮ್ಯೂಟ್ ಆಗಿದೆ. ಕೋರ್ಟ್ ಆಫೀಸರ್, ಸೀರಿಯಲ್ ನಂಬರ್ 50 ಇದೆಯಾ ಅಥವಾ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಆಗಿದೆಯಾ ಅಂತ?
ಇದೆ ಕಳಿಸಿದ್ದಾರೆ MFA ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಟ್ ನಾವು ರೆಸ್ಪಾಂಡ್
ಯಾರಿಗೂ ಪಾರ್ಟೀಸ್ ಕರೆಸ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಮತ್ತೆ ಪಾರ್ಟೀಸ್ ಆಯ್ತು ಸೆಟಲ್ಮೆಂಟ್ ತಗೊಳ್ಳಲ್ಲ. ಇನ್ನೊಂದು ಯಾವ್ದೋ ಪಾರ್ಟೀಸ್ ಪ್ರೆಸೆಂಟ್ ಇಡಕ್ಕೆ ಹೇಳಿದ್ರೆ ಅಂತ ಇವತ್ತಲ್ಲ ಹೇಳಿದ್ರು. ಬೆಳಿಗ್ಗೆ ಬಂದಿಲ್ಲ. ಆಯ್ತು ಕರ್ಸಿ.
Cell number 60, Irshad Ahmad, Madhuri Gaikwad.
Here for the appellate. So Lordship had directed, keep the party both the present. Appellate is present. But the respondent is not.
Respondent is, counsel is also not present.
We'll wait for some more.
No, whether you spoke to your colleague. Memo dated. Proposed settlement filed by advocate for the appellant. Memo
No.
respondent. Both of you have given a proposal.
Proposal.
Memo.
They just put to the intervene in between deciding. A simple
But did it-
clarification is required.
Whether Madhuri, she has informed you, ನಿಮ್ಗೆ ಏನಾದ್ರು information ಕೊಟ್ಟಿದ್ದಾರಾ? ಬರ್ತಾ ಇಲ್ಲ ಅಂತ. Appellant. And his counsel.
May I submit your only the difference I can enlighten the court.
Yes, yes, yes. Hey,
Now, your lordship may kindly take the memo of proposal for settlement filed by me on dated 28/8/2024.
20th August.
20th August.
Is it a case where both of them have remarried?
Lord-
Is it the same case? In this case, whether the parties have remarried?
No, no,
In-
no.
Yes, your memo dated 20th August 2008. Yes.
Yes. Now, in this case, I have proposal is that the appellant is entitled custody of minor child appellant equal. That is to say, the order directing the respondent to hand over the custody of the appellant number physically every Saturday and Sundays. He is permitted to take the child Friday night and return the child on Sunday night. That is my proposal, Your Honor. Custody and appellant every Saturday and the school holiday. Therefore, that the minor child appellant is take the respondent mother 22 to 24 days, only 6 or 8 days will be in the custody. Respondent, the appellant. Now, second is to allow the appellant number directing the respondent to have a video conference every Monday, Wednesday, Friday, at least for half an hour, between 6 PM to 9:30 PM. They are also proposed in this area. I will come later. Now, later on, permit the appellant to celebrate the festival.
One second. Another concept. Even if we hear you in the absence of the other side, we'll not be able to do anything today because one side settlement is not.
I indicate so that the court will be in a position.
Yes, she can. Yes.
Oh,
My apologies.
yeah, well, understand.
My apologies, Milord.
Where is your party?
Milord, she's there, she's just downstairs, Milord. Not well. I asked her to come otherwise also.
Oh,
She's
right.
just,
Yes, she was submitting that the area of difference is small.
Milord,
Very small.
there are certain on the days of visitation, during the holidays, the vacation, Milord. That is the main,
No, holidays, my proposal is this. Let him enjoy the child for 50% of the holiday. If it is 1 month.
Child is not for enjoyment. Child is not for enjoyment.
No,
Yes.
let him have the custody of the child, 50% of the holiday.
What he is doing,
If it is 1 month, let him get the custody.
what he is doing,
Who-
appellant,
The appellate is running the fitness classes here, fitness center. And he is well educated, has
Gym.
qualification of
Gym,
MBA.
gym.
Gym. MBA qualified.
Oh.
And also trainer training
What she is doing,
Milord, sir, she's working with the company here, Milord.
in Purankara.
Milords,
What, I mean,
the only, Milords, it's learned that what has happened last time when the custody of child was there with the father, the child recently stated that there was an unknown lady who was with the appellant, and she identified that lady in a hotel, and she said that she was sleeping it between the father and that unknown lady during that time. We do not know who that lady is.
correct, no.
No.
Even, 1 second, even both of you agree, we have to listen to the preferences of the child.
Please, my lords.
That is the purpose of CNWC.
Even this.
No, even if both of you settle, court cannot grant it.
Milords,
like
I'll keep
that.
the child present. You can talk to the child, Milords, next week, anytime when there's a. I'll have the child present.
Observe in the order sheet that the child was very comfortable with the father. When the child was not given the custody, the court had directed to hand over the custody of the child. Then after doing
That
this,
in which,
not in this case, your lord, but in writ petition have filed of the, in that
it
case.
said here.
Not in this case, your lord. In the earlier, I filed she filed the petition for transfer of the.
Milords, if I may, Milords,
Sneha,
I'll keep the child present. Milords may interact with the child, Milords.
Only little bit difference, if the court intervene, I think it will solve the problem of both the parents and the child.
see, we have to interact both the parties as well as the child.
I'll keep the child present, Milords.
Tomorrow itself, I will, my party will be there.
Milords, tomorrow even my mother is unwell. I have to be in the hospital.
Tomorrow, it's not possible for us.
I
Tomorrow
cannot
or
this
day
week.
after tomorrow.
This week I cannot, Milords. My mother is unwell, Milords. Next week, Milords.
So, ನಮಗೊಂದು date ನೋಡಿ.
19.
Where is your party?
Milords, she was near gate number 5. She was not well, Milords. I told her to wear a mask and come up. I will.
Both counsel.
Anyhow, what happened, one way or the other, she is taking the time. My party is feeling.
They are not, she is not taking time. Now we are,
No,
on
no.
hearing you, we are finding that we should hear the child also and both the parties separately.
Next week, Monday, you will have. Monday or Tuesday,
Thursday, sir, 19th.
Monday or Tuesday,
Monday is holiday, Tuesday.
Tuesday,
Monday is holiday. Tuesday ತುಂಬಾ posting ಆಗಿದೆ ಅಂತ ಆಯ್ತು. Wednesday, Thursday.
Wednesday,
18th.
Is it okay?
Milords, 19th is okay, Milords.
No, Monday. But we are not recording the presence of your party.
Milords,
Where is she? Unless she is there, we cannot record her.
Milords, just here only, Milords.
ಬಂದ್ರೆ ಬರ್ಕೊಳ್ತೀವಿ ಅಷ್ಟೇ. Both the council are present on hearing the signature. Both council, we find it appropriate to interact with both the parties and the ward. They shall be present before the court on
18th, you will have.
19th ಅಂತ ಹೇಳ್ತಾರೆ.
ಇಲ್ಲ 19th ಇವ್ರಿಗೆ convenient ಇದೆ.
Milords, 18th.
Because
Okay, Milords.
18.
18-9.
He is coming from which place?
Bangalore,
Bangalore, no?
Bangalore,
Both of them are from Bangalore.
Please, Milords, they're from
At
Bangalore.
1:30 p.m. 1:30.
much of it.
Please, Milords.
ನಾನ್ ಬಂದ್ರೆ ಬರ್ಕೊಳ್ಳೋಣ, ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ. See, only,
Child is also should be present.
yes, child.
ಬರ್ತಿದ್ದಾರೆ, she's climbing the stairs. ಬರ್ತಿದ್ದಾರೆ.
ಬಂದ್ರೆ ಆಮೇಲೆ ಹಾಕ್ತೀವಿ.
Please, please.
Yes.
Madam, order sheet ಅವ್ರು ಬಂದ್ರೆ.
Next, sign off.
For further hearing, seal number 41.
We forgot to mention one more ground in that. You raised 4 grounds and the 4th one is limitation. We said only
Limitation.
3 grounds. ಅದು ಯಾರು ತಗೊಂಡ್ರು? ಹ?
A and B.
But this will not, ಮಾಡಿದ್ದು misconduct of the proceedings limitation. Service of notice ಅಷ್ಟೇ. Now it appears you are not pressing that contention that reconstruction of record or authenticity of the record. Are you pressing still those contentions?
My lord,
You had argued on that point.
I have argued on the head.
So we have to raise point for consideration and answer that. Now it appears misconduct of the proceedings.
So that all these contention of mine, my lord, gets summed up under the point that the application for production of document which was filed before the trial court is not accepted. Are not even considered. These documents, what they under that AA 501 under section 14, what they filed for production of documents.
A file,
Application AA 501, that is A1.
I mean arbitral report.
All the documents from the arbitral umpire.
Trial court has considered, they have mentioned para 622, 6 to 62, etc.
No order is
17 is considered as section 14 is the
What he is trying to say is that along with this arbitration award, you had produced certain documents.
yes.
Those documents were not considered by the civil judge.
To produce the document only.
Not application, that is.
Application is under section
Along with
14,
the award.
filing the award along with
That
depositions.
is,
They were
see, in the ordinary course, they could have filed it in that AS 1 of 93 only.
Yes.
Probably they were not aware what has happened to that because 17 years only
It
for
was
the
not
appointment
traced.
of the arbitrator.
We tried to trace it. It could not be traced. We waited for a week. It could not be traced.
So they find it. It is part of that AS 1 of 93 only virtually. No, his submission was that those documents are not considered by the senior.
That's,
civil
there are 10 volumes of documents, which is not collected by them. They are set. It is still before the court
Yes,
at
we'll record
Srirampatna.
that. Sign Nakis Kalsi. Ask her to sign it.
Even for the trial court.
Correct. Now we are formulating the points.
And
Point
that's
number
why-
one.
That's why I'm summing up. That's why I'm summing up. The application filed.
ಮೊದಲಿಂದ ಯಾರು ಕರ್ಕೊಂಡಿದ್ದು ಇವ್ರೇನ? ಆ points for consideration ಮಾಡಿದ್ರಲ್ಲ ಅದ್ರಲ್ಲಿ ಬೆಳಿಗ್ಗೆ ತಗೊಂಡಿದ್ರು. The challenge to the include award in his arguments is on the following grounds. Number one, we have already said that the umpire misconducted the proceedings. By not issuing
Notice.
issuing notice.
By handing over documents without giving notice to.
No, your contention is that award was not handed over to you. Award was not served on you.
What was not served on?
That was first contention.
14-1 notice.
By not serving the notice of award on the appellant. Number two, the award was submitted. The award was not submitted in accordance with section. Section
14-2.
14-2.
14-1 and 14.
14-1 of the 1940 Act, the Act 1940. Number three, the award was filed beyond the period of limitation. Beyond the period of limitation. Fourth one, construction, what is that? The learned district, this senior civil judge. Learned senior civil judge, so the trial court. The trial court did not consider the documents produced along with the award. These are the 4 points. So,
And the other important point is that
notice of the court.
jurisdiction.
Okay. The award was not submitted. Award was not submitted
31-4.
before the jurisdictional court
As per section 31-4.
as per section 31.
4.
ಅವ್ರ ಹತ್ರ ನಾವು 31-4. Application should have been made before that AA.
Once AA 1 of 93 application was filed.
You mean to say that this AA 1 of 2017 was not before the jurisdictional court?
That court alone, even the statute.
Correct. That it should not have been filed in AA 1 of 2017. It should have been filed in AS 1 of 93. Correct. Correct. Sentence. As per section 31-4 of the Act, the award should have been filed in AS 1 of 1993 before a senior civil judge Shrunk Patna. Filing of AA 1 of 2017 was contrary to section 31-4. That is the sum and substance. So, limitation.
Continuation application in
That is already there. No, point for limitation is. We'll do one thing. We'll on these points. We consolidate the submission of both of you point wise. Then we'll answer that on some other day.
Okay.
Because now we have to point wise. Can you do it point wise citations of both sides?
I can. Because I've
Now,
already.
you take these points. Based on these points, your rival contentions, rival judgments, so that we can point wise, so that it becomes easy for us. Sorry, we need your assistance.
Let it be uploaded on online, my lords.
ಇಲ್ಲೇ ಅವ್ರು ಮಾಡ್ಕೊಡ್ತಾರೆ. ನೀವು ಅದನ್ನಷ್ಟು ಪಾಯಿಂಟ್ಸ್ ಅವ್ರು ಮಾಡಿ. ಏನ್ ಮಾಡ್ಬೇಕು?
For academic interest, my lord, I was just telling.
That
Where evidence was how in arbitration.
that section 34 ಅಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ರೆಕಾರ್ಡ್ ಮಾಡೋದು. ಯಾವ್ದು ಜಡ್ಜ್ಮೆಂಟ್?
Alpha in housing development.
Yeah, when should we have it? The next is the remote. Can you do it 2-3 days?
2 days I can do. 2 days.
Next Tuesday. ಅಂದ್ರೆ ಅವ್ರು ಮಾಡಿದ್ರೆ ನಾವು ಒಂದ್ಸರಿ ನೋಡಿ ನೋಟ್ಸ್ ಮಾಡ್ಕೊಂಡು ಬಂದ್ರೆ ಈಸಿ ಆಗುತ್ತೆ. Citations ಅದ್ರ ಪ್ರಕಾರ ನಾವು ಅರೇಂಜ್ ಮಾಡ್ಕೊಂಡು ಬಂದ್ರೆ.
Please.
We'll have it on Tuesday then.
Please.
Dictated in the part for further dictation list on Tuesday. This is Alpine Housing. Point. It is from Karnataka only.
Evidence.
That is here. The party who has assailed the award under section 34(2) can be permitted to file appeal form, but only in exceptional cases.
But what was once defined that you can't even deal, Now it is.
This was under the new act that opposed to in conflict with law idella. Ali there are judgments. If the award is perverse, if it doesn't refer to any evidence or apparently against the evidence, then that amounts to in conflict with public policy. In that context, it is held, not in the old act.
2013 I have cited, old act. It's there, compilation is there.
See,
Like was neither of the parties option or there's no application filed for adducing any additional
they have
evidence.
to file affidavit. You have not
Please,
filed
that
affidavit.
attempt was not made. Now there's no question of.
In general, he is saying, but even this judgment, it says it is under section 34, 1996 Act. 1996 Act, now it makes a ground that is the award is in conflict with the public policy of India. Then what is the public policy? In some judgments, it is held that if the award is perverse means totally contrary to the evidence on record or without looking into that, then it becomes perverse. In that's what in exceptional case.
One more, the visa developers case, both I have cited. In fact, together lays down the scope of using evidence.
This is also under 1996 Act. This is number 18. Scope of proceedings under section 34. Pleadings and proof required in section 34. Proceedings. Routine procedure followed. Scheme and provisions of the Arbitration Act. Role of courts vis-a-vis arbitration. And it is difficult to envisage proceedings under section 34 as full-fledged regular civil suits under CPC. Application under section 34 are the summary proceedings, like order 37. If we can do it, I mean, so holidays we can summarize.
We will take the points for consideration.
Yes, she will give it.
Okay.
17-9.
Let's do it, no?
For further hearing, seal number 42. Mohammed Tahir, Viresh Arbutha.
My lords, permit me to give a very quick recap, my lords, of the facts, my lords.
Acceptance of salaried copies for verification of item number 1 for president stated along with schedule. Yes.
Because the appellants have filed the instant appeal, my lords, on two grounds. One, my lords, that they had an interest in the property, hence they should have been notified and they should have been heard by the special court. Not having been given opportunity, the order is void ab initio, is the first submission. And second submission, my lords, is that they had no opportunity of knowing regarding the pendency. And since they are in possession of the property by virtue of an unregistered sale deed, they have a right to present the instant appeal. These are the two contentions. But the office, my lords, has raised objections on two aspects. One, my lords, they have sought the leave of the court to file the instant appeal, in as much as it is their contention that they have not been heard, my lords, by the special court. I have filed comprehensive objections. And secondly, my lord, since the appellants claim that they are the owners of the property, the office has raised the objection to produce documents to show their ownership. And since, my lord, some unregistered sale deeds have been filed, because the office has raised its objection, and that objection raised by the office is actually my argument, please. My first submission, my lords, is that the contention of the appellants that they were not heard by the Honorable Special Court, and hence, but right from day one, the argument has been that the matter should be remanded. And my submission, my lords, has been this. On a principle of law, MC Mehta, my lords, Aligarh Muslim University case, useless formality theory cannot be a ground now for seeking a remand. And to substantiate this, my lords may kindly see, my lord. I'll take my lords to the provisions of the act.
Not heard by the court.
Please, first submission of this, my lords, is that they, having had an interest in the property, ought to have been notified and heard by the special court, and not having so done, the order is void ab initio. This is the first submission. But to this submission,
yes,
my lords may kindly permit me to say this. The act, my lords, provides for three opportunities for the landowners or any person to have an interest in the property to know about the proceedings. My lords may kindly take, my lords, 3 clause 3, my lord. Clause 3, my lords.
Act KPID.
KPID FE Act, my lords.
Yes. Your act's titles will be so long. It is difficult to spell. Section 3.
Section 3, my lord. Once, my lords, it is published, any ad interim attachment is published, my lords, the government takes a decision to attach the properties, 3, my lords. The government shall also notify the ad interim order made under section 2 in the official gazette. I stop there for a while. The first one, my lords, it is notified in the official gazette. My lord, the appellants might say that they might not have seen the official gazette and hence they were not aware. But let me accede and concede to that point, my lords. The second one, my lord, and 2 newspapers having a wide circulation. Because if indeed I have an interest in the property, if indeed, my lords, it has been published in the 2 newspapers, but let me also accept the fact that they may not be in the habit of reading 2 newspapers. Argument. Kindly see, my lord, the next one, and shall also cause to be affixed a copy of such order on some conspicuous place of the property so attached. But for some persons, not to have read the official gazette, my lords, is acceptable. Not to have read the newspapers, my lords, is maybe understandable. But my lords, the last one, when, my lords, a notification or a notice is affixed on the part of the property to say that was unaware of the proceedings pending, my lords, may not be correct and is not sustainable, is my submission. Lords, and secondly, my lords, the argument is that I have not been notified. My first submission is they were indeed aware of the proceedings, my lord. And secondly, my lord, law contemplates that the special court, the designate court, shall have to issue notice to all persons who claim interest. Because interest would be, my lords, interest in the eyes of law. I'll come to that point, my lords, when I'm making the submission to the second point. And the proviso says, and the second section says, that even if at all no notice is issued, it is open for any such person who claims any interest, my lords, to approach the honorable court by filing objections.
Subsection 2 of section 3, no?
Plus 3, my lords.
3.
3, my lords.
No, persons interested, where did you draw that? 4.
Plus now 12, my lords. 12, my lords.
12.3.
12, my lord. After having read 3, my lords may kindly take, my lord, section 12, clause 3, my lord. Section 12 would read, my lord, powers of special court regarding attachment. Section 12, my lord. Any person claiming an interest in the property. Because what is this interest? I'll come to it, my lords. Attached or any portion thereof, notwithstanding that no notice has been served upon him under this section, make an objection as aforesaid to the special court at any time before an order is passed under subsection 4 or 6. But this is the 4th valve for anybody to vent the grievance.
Yes.
But the question that falls for my lord's kind consideration is, appellants who choose not to utilize the opportunity given by the statute under section 3, clause 3, and for that matter, section 12, clause 3, can now come before this honorable court after having chosen not to use those opportunities to come and say that the order is void ab initio and the matter shall have to be remanded.
Yes.
My humble submission, my lords, the Supreme Court long has held that sitting on the fence litigant is not to be entertained once the orders are passed. But I wait for the orders to be passed. If at all the order is in my favor, I have no grievance. If the order is not in my favor, make the reason as a ruse for filing an appeal, and my lords, seek an interference in the indulgence from this court on the ground of violation of principles of natural justice. So my first submissions, my lord, is that not having utilized the opportunity given by the statute, the appellant is too late in the day for him to come up with an afterthought of a defense saying that I have not been heard. Secondly, my lord, section 16 may kindly be seen. Lord, any person who's aggrieved can file the appeal. That's the reason why, my lords, a leave has been sought. Section 16 of the Act, my lords. May be permitted to read, my lords.
Yes.
Any person, including the competent authority, if aggrieved by an order of the special court, may appeal to the High Court within 30 days from the date of the order. Because now, my lords, the question as to whether the appellant can be considered to be a person aggrieved, my lords. My lords, may kindly take the pleadings, the memorandum of appeal.
Now here the appeal is in time.
My lords, in fact, there's a delay, my lords, but as a state, I will not stand on the technicality of a delay, my lords.
Is there any provision to condone this delay?
Plus, there is no specific provision, my lords, either before the special court or before this honorable court, my lord. But under similar enactment, my lords, the provisions of the Tamil Nadu protection of interest and the Pondicherry in the Maharashtra, the courts have held, my lord, since there is no exclusion, express exclusion of section 5, the courts can entertain, my lords, is the law laid down. So I'll not stand on hyper-technicalities.
No, because under the Arbitration Act, the Supreme Court has ruled that 34, 37, 120 days when it is provided in the Act itself, Limitation Act cannot be applied on.
Please, my lord, because, my lords, in fact, my lords,
That is the law there.
there, my lords, the enactment provides for a specific exclusion. But the same is not found in this act.
But I think in 34, 37, such exclusion is not there.
Well, Andre,
Still, the Supreme Court held that only, that is the period. Outer limit was provided. That cannot be extended beyond that of the Supreme Court in the judgment.
please, in fact, my lords, I will indeed have an opportunity of arguing about the Limitation Act and this act, my lords, in some other appeal.
Not argue, but duty has on us.
In matter there, other argument ಮಾಡಬೇಕಾಗುತ್ತೆ. I may have to assist the court, my lords, in terms of the applicability of section 5 to this enactment, because in some other appeal, a question has been raised because the honorable court below has condoned the delay, my lords. So the appeal has been filed and it will be listed before your lordships, my lord.
No,
Please.
this is period prescribed for the appeal. That condoning delay in before the special court in the application.
Please, my lord, and
Attachment.
section 5, my lord, section 5 to petition. Because the law says I have to file within 30 days. And then the proviso says, my lord, that I have to seek, my lords, the permission of the Secretary Revenue.
The competent authority shall within 30 days from the date of receipt of the order made under section 33 apply to the special court for further order of attachment.
Please. So I'll indeed assist the honorable court, my lords.
Extend this period by another 15 days. Cases.
So my lords, now may kindly take the pleadings, my lord, the memorandum of appeal, my lord. But this argument, my lords, is as far as whether the appellants can be held to be persons aggrieved either to be heard before the honorable court below or before this honorable court, my lords. Kindly take paragraph 2, my lords. Paragraph number 2, my lords, at page number 12 of the appeal memorandum.
Page 12,
Paragraph 12, my lords. Page 12, paragraph 2, my lords. Respondent number 3 has developed a layout in the name and lake view layout without converting the usage of the land and formed sites and sold these sites to these appellants. The total 29 sites are consisting in the layout. All the schedule of each site is more fully described, put as Schedule A, and by giving specific item number 1 to 29, item number 2 is jointly possessed by the appellant number 2 and 3. Is jointly possessed by the appellant 6 and 7 and unregistered. How, my lords, they become the owners is mentioned therein. An unregistered notarized sale deed.
Last time you have addressed this point, it seems. You have addressed last time.
Please, I'll just give a very quick recap, my lords, of what submissions I have made, my lords, because.
Just see, last time you have noted no sale deed, no revenue records, etc.
Please, my lords.
So not person interested. Illegal acts cannot be legalized.
Please, my lords.
It does not apply. You have argued this last
Please,
time.
please, my lord.
You are accused. Appellants do not even comply registry's office objection here, yeah,
Please,
regarding non-production. section 16 aggrieved person, at that stage we had stopped. Nothing stated about flaw in the impugned judgment, that also had argued. This, we want to say the same thing again or anything new?
I'll only, my lord, give one judgment, my lords. For two judgments for two prepositions, my lord. One, my lords, is the useless formality theory in Aligarh Muslim University case. That is, my lords, even if this honorable court, for a minute were to hold that none of the provisions under section 3.3 and 12.3 can come to the rescue and they ought to have been remanded. Even then, because I ask myself, what is the defense that the appellants can go and take before the honorable court below? Because I can understand if at all any evidence is to be led, if at all the appellants were to say that I have a registered sale deed in my favor and in terms of law I am the owner which has not been considered. But yes, please, my lord, that question of ownership or otherwise would have to be considered by the honorable court below. Even if at all they go before the court below, my lord, they're going to produce the same documents. So my submission is that only for the purposes of determining as to whether at all they ought to have been heard in view of the unregistered sale deed that they call, my submission is that sending it back would only mean, my lords, a useless formality theory. Before Aligarh Muslim University case, my
Any law is laid down about person interested in this context?
in this context, in specifically in terms of section.
Property Act.
Well, I have got judgments in other, in general, what would be the definition under the umbra and penumbra of the word aggrieved and the locus standi? Because my lords, they are in a way related to each other. Though, my lords, they are not specifically under the similar act or act pari materia, but the definitions, my lords, may kindly permit me to take, my lords. For Suraj Lam's, my lord, the constitutional courts have held that no person can even seek a semblance of right by virtue of an unregistered GP or unregistered sale deed. If section 17 stands violated, no legal interest qua the right would stand vested in such a person. But here is an appellant who comes before this honorable court and says, I've committed illegality, gross illegality, yes. But then by virtue of a judicial imprimatur, I should have to be protected, is a submission. My lords, may kindly permit me to refer to the judgment, my lords. Lords, indeed, I'm referring, my lords, to a judgment of another high court, not as much for the ratio laid down by the honorable high court, my lords, but because of the precedents referred to by the said high court, my lords. Sir, I'm referring to Union of India versus Association of Class 1. I don't have a copy, sir.
You must give a copy. Now we'll see in one document. Idu onde namgu onde kottidira? We can see. Illandre supported indra book tagokku. Uttarakhand High Court. You are referring to Uttarakhand High Court judgment?
Yes, I am sorry, I marked the copy, my lord. I'm sorry, my lord. Same copy of marked, my lords. Plus, I'm not referring, my lords, the ratio laid down by the Honorable High Court. I may perhaps be wrong, because, my lords, I cannot be citing, my lords, a judgment of another High Court before your lordships. But I'm only referring to the extracts, my lords, or the exceptions that, my lord, the Honorable Court has made, referring to some Supreme Court judgments, my lord. Because I'm now on the point that they are neither aggrieved nor have a locus to present the instant appeal. Now, page number 7, para 13, my lords, may kindly take, my lords.
Yes.
The contention regarding the applicants not having locus standi to question the appointment of army officers in the defense stream has not been examined by the tribunal in the order impugned in the writ petition, as the very jurisdiction of the tribunal to entertain an application is contingent on the applicants being persons aggrieved. Failure to determine this jurisdictional issue would vitiate the order passed by it. I stop here for a while, please, my lord. So the first question, my lord, even if at all the matter is remanded, whether at all, my lords, the appellants would have the locus in as much as their names are not found, my lords, in the revenue records. They perhaps cannot be.
Yes.
Where the error, irregularity, or illegality touching jurisdiction or procedure committed by an inferior court or first instance is so patent and loudly obtrusive that it leaves on its decision an indelible stamp of infirmity or vice which cannot be obliterated. I'll skip this, my lords. Para 17, my lords, may take at page number 8, please, my lord. Locus standi to approach the tribunal relates to the maintainability of the petition application. In case of defect of jurisdiction, an aggrieved person will be entitled to relief, including for a writ of certiorari as a matter of course. But if it does not fulfill the character and is a stranger, the tribunal will deny him this remedy, save in special circumstances. To have standing to sue, which means locus standi to ask for relief in the court by tribunal, the petitioner applicant must show that he is injured, that he has been subjected to or threatened with a legal wrong. Courts can intervene only where legal rights are invaded. Legal wrong requires a judicially enforceable right, and the touchstone to judiciability is injury or a legally protected right. A nominal or a highly speculative adverse effect on the interest or the right of a person is insufficient to give him the standing to sue for judicial review and for administrative action. Again, the adverse effect requisite for standing to sue must be an illegal effect. That's para 19, my lords, at the foot of the page. Even assuming a wrong was committed, it alone would not create a right in favor of an applicant in the absence of a legal right followed by a legal injury. So and so, the Supreme Court held, so and so, my lords, in Muhammad Ibrahim on 5th line, the Supreme Court held that a right to notice by reason of any rule of natural justice which a party may establish must depend for its existence upon proof of an interest which is bound to be injured by not hearing the party claiming to be the entitled to notice and to be heard before an order is passed if the duty is given notice and to hear the party is not mandatory. Lords, para 21, my lords. I'm only, my lord, reading the 11 portions, my lord. A legal right means an entitlement arising out of legal rules. It may be defined as an advantage or a benefit conferred upon a person by the rule of law. The expression person aggrieved does not include a person who suffers from a psychological or an imaginary injury. A person aggrieved must therefore necessarily be one whose right or interest has been adversely affected or jeopardized. Page number 11. A legal right is in fact a benefit conferred upon a person by the rule of law. Thus, a person who suffers from legal injury can only challenge the act or omission. There may be some harm or loss that may not be wrongful in the eye of law because it may not result in injury to a legal right or legally protected interest of the complainant. But juridically, harm of this description is called damnum sine injuria. My lords, I'll skip, my lords, all the paras. Para 26, my lord. Para 26, my lords, may kindly take, my lords. Page number 13. 5th line from the end of para 26, my lord. The expression person aggrieved means a person who had suffered a legal grievance. But if the applicant had no right under the statute and no legal right of his had been infringed, he is not entitled to challenge the decision. Para 27, among the meanings of the words a person aggrieved is that a person will be held to be aggrieved by a decision if that decision is materially adverse to him. Normally, because I'll again skip, my lords, the same paragraph. Para 29, 31 and 32, my lords, say the same thing, my lords. In fact, my lords, para 32, para 29 also, my lords, would define, but para 32, my lords, a fanciful or a sentimental grievance may not be sufficient to confer locus standi to sue upon the individual. There must be injuria or a legal grievance which can be appreciated and not a stat pro ratione voluntas reasons. That is a claim devoid of reasons. I stop here for a while, please, my lords. As per the very admissions made, your lordships have held that a judicial admission stands on a much higher pedestal than the evidence led in the witness box. Naginda's judgment, my lords. Now, by virtue of para 3 and various pleadings, they are on record to show that they are not owners of the property. They claim ownership by virtue of an unregistered sale deed. So, my lords, no right where the liability is under a statute created in their favor. But at best,
in sum and substance, your argument is that they are trying to claim under a document which is not in accordance with law.
please. So they are
no interest devolve upon them unless there is a registered sale deed.
obliged.
So they do not become the aggrieved person or interested person.
Please, either to be heard.
they can claim interest only if they have a legally enforceable right.
Please, Lord. Either before the court below, my lords, or before this honorable court is my humble submission.
Yes.
And my last two submissions, my lord, is that by virtue of my undertaking before this court, that they shall not be dispossessed, my lord, for a certain point of time, there's an interim order operating in their favor. My submission is, if indeed, my lords, this honorable court, my lords were to kindly hold that they don't have a locus. Because in terms of restitution, my lords may kindly put me on the same status as I would have been, but for the directions of this court or my undertaking before this honorable court.
We couldn't follow.
Please, my lord, because now that they're in the possession, my lords, by virtue of an interim order either operating or because of my undertaking, but they are in the possession by virtue of the pendency of this litigation. My submission is, if your lordships were to hold it in my favor, but there may be a direction to them, my lords, to hand over the possession without compelling me, my lords, to initiate other proceedings is my humble submission in terms of the doctrine of restitution.
No. See, it is not your case that you are dispossessed now because of this order.
Well, I'll be dispossessing them because I'm under an obligation.
You were dispossessing them now because of the order.
I have not, miss.
That is deferred.
Please,
No. You want us to give a direction to them to hand over the vacant.
for this reason, my lord, because your lordships, your lordship, because of the matter of the pending appeal, I board on my lords. I take the point, my lords. I will.
What is the revision and purpose section 17 of the registration act? Registration act.
For the doctrine, my lords, of useless formality theory. That is, my lords, even if by remanding the matter, if at all the outcome is not going to be any different from it is going to be here, only for the purposes of statistics, the matter should not be sent back, my lords, is the principle of law. My lords may kindly permit to place on record, my lords, Aligarh Muslim University case, my lords, reported in AR 2000 Supreme Court 2783, my lord. It is reported with me. I don't have a copy. I don't have a copy, sir.
I will not carry all the reported judgment with me.
My lords, in para 22, my lords, please. Para 22, please, my lord. Pagination is, my lords, at the right hand foot of the page, my lord. In MC Mehta. It was pointed out that at one time it was held in so and so that breach of principle of natural justice was in itself treated as prejudice and that no other de facto prejudice needed to be proved. I stop here for a while with lost permission. Because there's absolutely no violation of principles of natural justice, but arguing against myself. And even if at all my lords were to hold that there is a violation of principle, there is no violation, even if at all, arguing against me, worst of the case. But since then, the rigor of the rule has been relaxed not only in England, but also in our country. In so and so, and set aside the order of suppression, the proceedings were quashed on the ground of violation of principles of natural justice. But even in the case, certain exceptions were laid down to which we shall presently apply, my lords. I'll refer to para 24, unnumbered paragraph 3, my lord. Since then, this court has consistently applied the principle of prejudice in several cases. The above ruling and various other rulings take the same view as have been exhaustively referred to in so and so. In that case, the principle of prejudice has been further elaborated. The same principle has been reiterated again in so and so. But para 25, that's, my lord, the useless formality theory. So my humble submission is, my lord, that not having given them an opportunity of hearing, plus cannot be complained of before this honorable court for this reason, that they did not have a right of audience at all. Even if at all they did, lords, they can as well establish the right before this honorable court, which, my lords, they have not been able to do so. With my humble submission, my lords, I rest my submissions with this, please, my lord.
I cited only these two judgments.
Only two judgments, please.
Yes.
You can now copy that, whatever copy you're reading.
Consider, and we have waited for a period.
No, you answer this point. He says that you have no legally enforceable right.
Coming into that.
Yes, yes.
That's just time. And, Section 6 of specific relief act.
Hmm.
We are in a position, we cannot be disposed without a.
No, this is
Even a trespasser.
we are under the special enactment. That
for
act
that-
says that person interested shall be heard. Person
I'll coming back
interested,
into
what is
that.
the meaning?
Coming back into that, what my learned friend has pointed out, I will need to give answer on that aspect also. But kindly
So
appreciate.
that hinges the whole issue here.
No, interest when we are in a position, that's order is not that, they dispose it. Kindly see the
No, no,
order.
no.
It
Not
is not
order.
a- it is not
Attachment.
suit for declaration.
No, Leonard Council, you go through the provision of this special enactment.
It is not,
It
not
says
for declaration.
it is not a suit for declaration, but this provision says this is a special enactment. It says section 12(2).
Yes, I am not even
12(2) says
assailing the
that
order, I was assailing the conduct of the competent authority. He would have taken a position even before preliminary notification. That is the law. If they would have taken all this procedure, followed this procedure, we would not have any right at all. What is happening is, what you kindly appreciate, in the petition, in their application before the trial court, for the special court, they are demonstrating that the scheduled property is agriculture property. It means there nobody is there in the position. Then my learned friend is saying that we have conducted a Mahajan. Then it becomes a disputed issue. Where they have conducted the Mahajan, when they are saying it's a correct agriculture property.
no, you should have some right to raise all this. See, principle of natural justice or right of hearing is it should be given to a person who is entitled.
I cannot be even if you want me to dispose this from even assume for the sake of argument, I am a trespasser, I am an occupier, illegal occupier. Even then, Lordship, I have a right because of my position, and that is settled position. I presented certain judgments in last occasion, which I cited, I have narrated, I read over.
See, you are in this appeal because according to section 12(2) and 12(3) is not followed, right? Right, 12(2) says that issue notice to other persons represented to having are being likely to claim any interest in or title in the property.
Has to be examined. The way, Lordship, kindly appreciate, the law is not that every property of the partner, Lordship, kindly take the judgment. I'll just see the fact, I'll just demonstrate from the input notice. What was the claim and what was placed before the trial court? And that was the diligence done by the competent authority. Page number 52.
Yes.
Page number. It's the improved judgment of. It is contained by respondent number 1 is a registered partnership firm which were registered on 7 to date. Respondent 2-3 is partner. Respondent 2-3 have also started registering company and developer private limited on 12/5/2015. Being this director, they also started Injas Shoharda Cooperative Limited for the interior decoration, construction and maintenance of building, etc. The respondent and the people associated with them on the false assurance and promised by the deceitful means induce the general public to invest their hard-earned money with respondent number 1 firm and its associates in entities over a period from 2015 to 2018. They have collected the amount of 291.60 crores. And from the 9,862 investors, and they paid 199.7 crores to the investors, and they are yet to return the amount of 91.89 crores. This is the allegation against the company, which the competent authority has to recover and to distribute it to the investors. Now, I should kindly turn to page number 12, page number 60, internal page 12. Apart from this two scheduled property, no property, no document, no bank account was put for the attachments.
Yes.
Page number 61, para number 11. The true copy of the sale deed, dated 10/8/2016 and 23/12/2016, and RTC related to shipping properties, revealed that respondent number 2 had purchased the petition A and B scheduled property for valid consideration and thereby acquired the title possession over the said property. is also found in respect to the letter issued by the Axis Bank, produced by the petition. As per Annexure P2 makes it clear that the total sale consideration of scheduled property is rupees 19,77,000 rupees was paid by the respondent number 1 firm. Further, the income certificate produced by the petitioner makes it very clear that since from the date of the purchase of the scheduled property, till now the said property in the name of respondent number 2. Thus, on going through the document, it is clear that the petition out of the funds of the respondent number 2, 1, so far as the issue property is concerned, the petitioner has specifically contended that said property is also purchased out of the depositor's fund and the respondent number 1 firm. In this regard, the content of the sale deed dated 10/8/2016 as looked into it. It is noted that the total sold consideration 42 lakh rupees and was paid in cash. Respondent has not disputed the said condition of the petition. So it was the ex parte order, nobody was contested. Now, only these two property they have presented before the trial of the special court for the attachment. Apart from this, there is a no whisper regarding a 91 crore rupees. No account was seized, no personal property was seized, no investigation was there. Law is not that. Law is that, Lordship, kindly appreciate. There is a rules also is there.
Now the question is whether these contentions are open to you.
But certainly
Respondent number 2 had
our
this.
contention, Malo, our contention very simple. Our contention is that we have purchased this property from the respondent number 2, who is the Indian partner. So before
You
attaching
should have purchased it when it amounts to purchase, when you purchase it under a registered sale deed.
we have under registered
Any
sale-
transfer,
registered sale agreement was there. Some money was transferred.
whether
We
any
have-
interest is created thereby.
When we
How
have
it
seized the
creates-
property, even under registered sale deed, we have registered sale, we have constructed the building, we are in the.
That doesn't amount to, because some authorities, if they are not vigilant, that does not create. How the interest in a property is created, that is only under the Transfer of Property Act.
Even a trespasser, law of India says that, even a trespasser
That is under
cannot
the
be
general
removed
law.
without following any procedure of law. Lordship.
That is under the general law. These are all special.
This
This is not this. This act is not a
this
special law.
act, this CPC applies in this act.
The act is not a, it's a special act.
It is special act, but for the state special act, for a certain purpose. It is not, the purpose is not that to snatch the property of third person. Even there is also provision if property is illegally transferred, the transferor has to pay the differences, not the entire amount.
So your remedy is against the transferor.
No, our remedy is against this, against the entire act of the competent authority. Competent authority deliberately left all of the property.
Section 19 Act to override other laws. Section 19 of this act. As otherwise provided in this act, the provisions of this act shall have effect notwithstanding anything inconsistent. They will continue in any other law for the time being or any.
Anything inconsistent, if any inconsistent with that, there will contain any other law for the time being in force of any custom or use of any instrument which is affected the virtue of any situation. Any inconsistency, will that be even known? If any procedure is inconsistent with the procedure of another act, then the procedure of this particular act will be applicable.
Yes.
Lordship, there is a rules also is framed under this law. Or kindly see the rule.
Which rule you are referring?
Rule. 2006 rule.
Correct. ಯಾವ ರೂಲಿಗೆ ರೆಫರ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಅದರಲ್ಲಿ?
Rule kindly appreciate. Page number, rule number 5.
Rule number 5. Amendment of section 5. 1 second.
Rule 5. Even there is also opportunity under rule 3.
Just a minute.
Examination of complaint.
ಇದು ಆಕ್ಟ್ ಇದೆ ರೂಲ್ಸ್ ಇಲ್ಲ. ದಿಸ್ ಇಸ್ ಆಕ್ಟ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿರೋದು. ರೂಲ್ಸ್ ಇಲ್ಲ ಇದರಲ್ಲಿ.
So, rules are there with you or not?
Not with any taking the rules.
ಇದೆ ನಮ್ಮ ಹತ್ರ ಇದೆ.
controversy because the competent party has not performed its duty before seeking the attachment or before notifying the preliminary attachment.
Rule is to
Rule 3 also.
prohibition.
An interim order and examination of the complaint and witness. Upon the receipt of the order of the government under subsection 2 of the section 3, the competent authority may examine the complaint and such examination shall be reduced in writing. Then subsequent rule 5.
Yes.
Rule 5.
Yes.
Power to leave or seize property, where a competent authority is certified or is legal property is liable to attach under that, like to concede, transfer, or in any manner which may result in defeating the purpose that it may make an order seize such property, or where it is not able to seize such property, we can order the property shall not be transferred, otherwise this property except the period permission. Also kindly appreciate this. Last occasion, I highlighted the duty and power of the competent authority. Is of competent authority under section 6. Section 6.
Yes.
And the duty clearly says that after the appointment, shall take such necessary action if necessary to take taking physical possession of all the monies and assets of the concerned financial establishment, expeditiously and the authority shall have all the power which is necessary for the purpose. So what procedure has to be followed by the competent authority to take the possession of the property? That has not been done. If once they will take a position, we have any right or not, the controversy will rest there. Then they would have a approach to the special court for the confirmation of the attachment. After the confirmation of the attachment, then they will get an order from the special court to dispose the property. Now they receive only the order to for the realization of the by selling the property.
Yes.
There is no order to take a possession. There is no order to dispose. My learned friend was reading out three provisions, and he also stated that if we assume that we have followed all the procedure, but no notice was been served.
Yes.
First was publishing a gazette notification, then in the newspaper, then was referring is a Mahajan. If the Mahajan has been convicted, certainly there is a property which is the house are built from 2020 onwards, from 1918 onwards. That Mahajan would have reflected there is some properties are there. Somebody would have witnessed that proceeding.
He did not speak about the Mahajan. He said the notice was attached on the
attached in the sense, if the notice affects by any authority, some proceeding has to be done in that aspect also. If suppose according to them it's agricultural property, that is their case, that is agricultural property. In agriculture means probably it's an open land. So where they had affects the notice. And all this aspect, this property, this particular money is the proceeds from the financial institution or not. That is the crux of the matter. We have to establish that we have paid so and so money, so and so person, and that money is that he has received it. That opportunity was not given to us. We ourselves is admitted that we have an unregistered document, and for what reason we have unregistered document, that also I narrated. I have not concealed anything, which my learned friend is trying to highlight. I have not concealed anything. I have said narrated all the facts about my position, about my status, about my documents. Only my grievance, Lordship, the property which they are claiming is worth around 60 lakh rupees. And they're supposed to recover 91 crore rupees. No effort was done. It is the order passed with the collision of the respondents. 1 or 2 or 3, Lordship. The reason is, Lordship, kindly appreciate, not even a single bank account was seized, which was attached.
See, you have to seek only protect your interest. Now we are not examining their entire things.
No.
Whether the order of the special court is right or not, that we have to consider. Your only
I have
point
no
was
opportunity. This all aspect has to be
Sir,
tested in the
only
trial.
point was that you were not given the opportunity of hearing.
This aspect, these are the valid aspect. Lordship, the law says that
consider.
the property of the
Unless-
financial establishment has to be attached. Kindly appreciate.
A third party, a stranger
No,
cannot
it is
raise
not.
all this.
Lordship,
You claim that you have an interest in the property. If you have interest, you have right to.
we have
claim
an
these
interest
things.
because we are in the
But
possession of the
you-
property.
This says person interested. What is the meaning of the person interested? We repeatedly asked you, what is the
Lordship,
meaning?
interest is
Because Act
also-
does not define that.
No, Lordship, law act does not.
How do you
define
get the interest in the?
interest, the person who is there in the property, he is interested. It is not that only title deed only does not give a right interest.
Yes, that's
Even a
a-
person who is there holding
You
the
have no
property.
repetition, learned counsel. How many times you repeat that? You are in possession, you have said that. Any new point if you want to say, you can say.
What I am trying to demonstrate that in this case, no
What are the
opportunity
judgments?
was provided, and it was uncontested to verify the claim of the competent authority.
See, to raise all these points, we are repeatedly, we are not granting any further time to submit on this. We are asking you, you show us please that some authority that you are the person interested.
I provide that, Lordship, when I am in a position, I cannot be disposed without properly
That-
procedure of
that-
law.
that
And
point-
procedure of law is that I should give an opportunity to
that-
test the claim,
All right, that you have already submitted.
to test the claim of the competent authority.
No, what is that judgment you are saying, you are saying, what are the?
Or last opinion, Lordship, I have given judgment. Supreme Court judgment as well as our own High Court judgments.
Supreme Court judgment, this, it's citation. Yes, 1977 one SCC, 1995 ILR and 1991 ILR Karnataka. So there is nothing, nothing new other than these things, no?
These judgments very specifically deal with the position and how the person has to be removed from the position. This particular is of our own High Court.
Section 1, 3 and 2 is violated. 1 is 2 and 3 and 1 are person interested. Whether the difference person interested, that is the question. No transfer in the eye of law. Or in 46. District legislature cannot be assigned to the person who are already related to the
The same citations.
Heard further and reserved. ಇದು ಕೊಟ್ಟಿದ್ರಲ್ಲ ಅಲ್ಲ ಹಿಂದೆ ಕೊಟ್ಟಿದ್ರಲ್ಲ ಅದೇನಾ
Other three judgment, earlier judgment I have given at the High Court.
ಅಲ್ಲ ಒಂದ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಎರಡು ಕರ್ನಾಟಕ ಹೈಕೋರ್ಟ್ ಅದ್ರಲ್ಲಿ
These are other two judgments,
ಏನು ವಾಟ್ ಇಸ್ ದ ಪಾಯಿಂಟ್ ಇನ್
of Supreme Court. One is my learned friend is citing Sugar Land judgment.
19/4/2024 ಅಂತ ಬರ್ದಿದ್ದೀರಲ್ಲ ಇದ್ರ ಮೇಲೆ ಇವತ್ ಕೊಟ್ಟು ಆಮೇಲೆ ನಾನು 19/4 ಇಂದಾನೆ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದೆ ಅಂತ ಹೇಳ್ಬೇಡಿ.
Three judgments have been.
See the date on your presentation for.
Maybe the date should be there. 19/4. I just correct the date. He did it on that day.
But other set you had given in 88. 19.4 ಅಲ್ಲಿ ಇಟ್ಕೊಂಡಿದ್ದು 88 ಅಲ್ಲಿ ಯಾಕೆ ಕೊಡ್ಲಿಲ್ಲ?
All these judgments ready, then after the relevant judgment I got it from our own high court, I cited those.
So
Even a copy of these
they are
judgments
not
also-
relevant according to you now. You said that you gave relevant judgments.
Already relevant judgment are in addition to this Supreme Court judgment I am giving. Where very specifically.
What is the point said? There?
In this
They are
judgment,
law laid
one
down.
is the Suraj Lamb judgment.
What is the law laid down?
The law laid down in para number 9 and 11 also, page number 9. Where we say that
Yes.
the records of Supreme Court, section 54, it may not be. Page number 8 also.
Page number 8. This was
Bar position is handed over in
section
58.
17 of it. Page number 8.
Page number 8, section 54, the relevant is page number 9. The protection provided in section 53 of the Act is proposed transfer is shield only against the transferor. If this is entitled transfer from discussing the position of the proposed transferee, who is put in position pursuant to the agreement, if it is nothing to do with the ownership of the proposed transfer, who is remain full owner of the property, till it is illegally conveyed by the executing the registered sale for transferee, if the right is protected. Question petition against the proposed vendor, not repress in service against the party.
Page 8.
Contract itself does not create a right ಅಂತ ಹೇಳ್ತಾರೆ. ಅದಕ್ಕೆ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಬೇಕಿಲ್ಲ.
Number 9. Another judgment or a full bench judgment.
Sorry to interrupt, my lord. Page number 9, unnumbered paragraph 3, my lord, that sums up the law. It is thus clear, by page number 9, my lords, unnumbered paragraph number 3, my lords.
ಇದು unnumbered ನೀವು ಯಾವ ಎಸ್ ಜರ್ನಲ್ ಇಟ್ಕೊಂಡಿದ್ದೀರಿ ಅವ್ರು ಯಾವ
ಅವ್ರದೇ ಸ್ವಾಮಿ, ಅವ್ರು ಹಾಕಿದ್ರು.
unnumbered
He
para
was relying the judgment, I just.
unnumbered para 3 ಏನಂತ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ?
It is thus clear.
Second paragraph.
It is thus clear, unnumbered paragraph. It is thus clear
Transfer.
that a transfer of immobile property by way of sale can only be by a deed of conveyance, sale deed. In the absence of a deed of conveyance duly stamped and registered as required by law, no right, title or interest in an immobile property can be transferred.
What exemption is 53A and possession has been provided.
53 is for agreement of sale.
Worship 53A in position is handed over.
Protection of possession of an agreement holder, not sale deed that is.
Worship this, even unregistered, we had all unregistered document. It will be amounts to, it amounts to agreement.
Yes.
It's the exception of this rule is 53A when possession has been handed over.
Protection part performance. Yes. The sold ಅಂತ ಇದೆ. It can be sued.
Page number 19, para number 21, full page. The High Court has also right in the view that the common principle law that even a trespasser who is established property could obtain exemption, however the matter will be when the plaintiff himself innovates the plan about the dispute appears to make a prayer for the arbitration criteria along with the exemption.
Where are you reading?
Page number 19, para number 21. If the settled position, established position is there, then he has a right for against the original owner.
Yes.
Section 20, para number 20, page number 9. Then last judgment in respect of the lordship application of that is in respect of birth act, because I find a IA stating that the KOPD will not be applicable in this case, only the birth act will be applicable. So the last judgment is that is on that law. So now that IA has not been considered, for that reason there is no need to plan the last. My humble submission is lordship, the aspect that competent authority has why only see this property but say 58 lakh rupees, leaving aside other properties.
How many times you will repeat that? You have said several times you have argued no. 91 lakhs was the total sum. 91 lakhs or you have argued it. You said why they have gone only for these two properties, why they have, what action they have taken. Please don't repeat it. We have some limit for our tolerance also. Yes.
I'm not arguing earlier.
You have
I
argued.
just find it out now.
You have argued it. 91 lakhs was there. Why they have come only argument ಮಾಡಿದ್ರು. We still do not get that Alzheimer.
So
So that-
I
Heard further resort.
take it said it appears repeatedly, but I have not argued last one. I've argued.
You have
91
argued it
crores.
just now, few minutes back. you
Yes,
have
yeah,
argued.
this I argued now. only.
This is only
Earlier I
reply.
haven't argued.
It is not reply, it's only reply.
Yes, sir.
Yes, perfect. Heard further resort was it. Yes.
Obliged, please. I'll be permitted to give a written,
No further arguments, no further.
return the submissions I will take it out.
You could have given it now only. Sorry, yes, next.
Obliged.
Cell number 44, Vanita UM, Shilpa Shah.
I appear for the petitioner counsel, my lord, in this
Here
matter.
that, I have aggravated the law.
No, not aggravated. See, learned counsel, you are the officer of the court. Right? If you sit here, what are you going to do? Look at the people behind you. Your matter is of which year? 2000?
Last year.
2025. There are people sitting for 2014-15 matters. You seek the expedited.
Labor rights of the property is involved.
Maybe they also involve the rights of the property only for others also. And see,
The rights of the people who are affected.
you are entitled to seek the indulgence of the court for justice, but not abusing the process of the court. Yes, repeating the same arguments again and again. Yes.
Cell number 44.
My lord,
Vanita UM.
appearing for the petitioner counsel, my lord. The petitioner counsel is also before this court, my lord. In all these three matters, my lord, we have filed an appeal against the order passed by the district judge as well as the
Yes.
arbitrator, my lord. The land was.
Yes, you are ready. Yes.
Hello. Yes, my lord. In the first matter, my lord, 4809, my lord.
Oh, sorry. Yes, sorry. 48. I'm sorry.
4809, my lord.
48.09 ಅಂತ ಹೇಳ್ತಾ ಇದಾರಲ್ಲ.
ಇಲ್ಲ, 4809, my lord. First matter.
Yes,
Adರಲ್ಲಿ we have filed for enhancement, my lord. And along with that, we have filed an application along with one document, my lord. The petitioner, the appellant.
Setting aside the abatement, what is that?
That is a second matter, my lord.
Notice ಹೋಗಿಲ್ಲ.
ಅಲ್ಲ, appellant ತೀರೋಗಿರೋದು.
That has to be completed, alva now. What do you
ಹೌದು, ಹೌದು.
This 44.1 is LR application, sir.
LR application.
You are appearing for the respondent. Correct. First, we'll complete those preliminary aspects.
So that is their appeal.
You have to bring the LR.
It is my application, my lord. The LR has to be.
4809 of 2016 to that 4807 of 2016 is connected.
Yes, my lord.
4807 of 2016 LR applications are pending.
876.
What have you got to say
Yes.
for that?
That is, my lord, she is for the appellant.
She has filed, right? She has filed applications to come and record. What have you got to say for that?
We will leave it to the honorable court. We'll fight on merits and not on.
Sole appellant.
Awesome. Sole appellant.
Eight 76 days delay, na?
ಹೌದು ಸ್ವಾಮಿ.
What is that? 876?
ಇಲ್ಲ, ಅದ್ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ಅವ್ರಿಗೆ ಲಾಸ್ಟ್ಗೆ. ಇದು ಅಪೀಲ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಅವ್ರಿಗೆ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ಸ್ವಾಮಿ, ಹಂಗಾಗಿ ಅಷ್ಟು ಡಿಲೇ ಆಗೋದು.
He died in 2021.
All about its COVID time, my lord.
The COVID time was between
No, they have-
2021-22 when we have filed application. ಅದು ಸಿಗ್ತಾ ಇಲ್ವಾ ನನಗೆ? We have filed application in 2024.
Yes, my lord.
Then how did you come to know about this appeal? You are not mentioned in this affidavit. How did you come to know about this appeal? We were not aware of limitation aspect, we were not aware of.
Lord, it is their appeal, my lord. It is landlord's.
No, they say the original appellant died, they were not aware of these proceedings. Then how did they come to know about these proceedings? That they are not stated. We are the only legal heirs to the deceased. In the entire affidavit, you do not say how you came to know about these proceedings. You only represent the appellants in this case also, no? Who is that?
Yes, ma'am.
Virupakshaya or ಬೇರೆ ಯಾರು?
ಅಲ್ಲ ಅವ್ರು ನೋ
You represent them also.
ಅವರು ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಬೇರೆ ಕೇಸಲ್ಲಿ.
ನಿಮ್ಮ ಹೆಸರು ತೋರಿಸಿಲ್ವಾ ಇಲ್ಲಿ ಹಾಗಿದ್ರೆ?
ನನ್ನ ಹೆಸರು
ನೋಡಿ, whether you are appearing in MFA 4807 of 2016 also.
Yes, my lord.
Then your name is not shown, no?
My name is not shown, my lord. Her name is shown.
You have filed Wakalat.
Yeah, filed it.
What is your name?
Vanita UM.
Vanita?
UM.
ಅದೇ ಹೆಸರು ಬರ್ಕೊಡಿ.
ಫಸ್ಟ್ ಕೇಸಲ್ಲಿ UM.
ಫಸ್ಟ್ ಕೇಸಲ್ಲಿ ಇದ್ದಾರಾ? ಈ ಸೆಕೆಂಡ್ ಕೇಸಲ್ಲಿ ಬರ್ಕೊಡಿ. 44.1 ಅಲ್ಲಿ. It is submitted that Srimati Vanita UM has filed Wakalat this case for the applicants. Along with the applicants ಗೆ no objection ತಗೊಳ್ಳೋ ಪ್ರಶ್ನೆ ಎಲ್ಲಿ ಬರುತ್ತೆ? He died. Original appellant for the applicants. Okay. Orders and I number 123 of 2024. The appellant died on
37/2021.
The above applications are filed by his legal representatives for condonation of delay, setting aside the abatement and permission to come on record. There is 876 days delay. Will impose heavy cost, madam. This is
My lord,
land acquisition, no? Land acquisition case alla
minimum.
idella agodu.
ಇಲ್ಲ so minimum cost may be, my lord, because
The only ground urged that
dismiss ಆಗಿದೆ ಸ್ವಾಮಿ ಹಂಗ.
are not aware of the proceedings. In the affidavit, it is not stated when and how they came to know about the proceedings. However, to give a fair opportunity, delay of 870 days, 76 days in filing the appeal, filing IA number 1 of 2024. IA 2 and 3 of 2024 is condoned on payment of cost of rupees. Rejected on what ground?
Whatever that is awarded by the arbitrator is correct ಅಂತ ಹೇಳಿ ಸ್ವಾಮಿ. 50 rupeesಗೆ per 75 rupees ಎನ್ಹಾನ್ಸ್ ಆಗಿತ್ತು, ಅದೇ ಕರೆಕ್ಟ್ ಇದೆ ಅಂತ ಹೇಳಿ ಅವರು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತಾರೆ, ಎನ್ಹಾನ್ಸ್ ಮಾಡಲ್ಲ.
Payable to the High Court Legal Services Committee. The abatement of the appeal is set aside and the applicants are permitted to come on record as legal representatives of the deceased appellant in the interest of justice. IA 1 to 3 of 2024 are disposed of accordingly. Appellant's counsel, you pay the cost.
Yes, my lord.
Will deposit the cost and amend the cost title of the appeal memo and furnish the copy of the amended appeal memo within 1 week. One ವಾರ ಆದ್ಮೇಲೆ release ಮಾಡಿದ್ದೀನ. What about the other two? Other two have to be heard along with.
Yes, my lord, along with this, my lord.
List on ಒಂದು ವಾರ ಬಿಟ್ಟು 10 days ಬಿಟ್ಟು ಹಾಕ್ಬೋದು. You have to
25/9.
25.
Much obliged.
Still number 45 adjourned. Still number 46, B. Pradeep.
ಇದು ಪ್ರದೀಪ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು. Adjourn at request.
47 adjourned. 47 to 49 adjourned. Still number 50, Siddharth B. Muchandi.
I am appealing for the respondent insurance company, in this case.
I 2015 ಹಾಕೊಂಡಿದ್ವಲ್ಲ ಇವತ್ತಲ್ಲ. Mutation. Yes.
Case of, the injury, but accident, occurred on the 2017. It was 42 years as on the date of the incident. And, he suffered fracture, this upper arm, and left humerus fracture. And, the doctor, PW2. And then the
Yes. You are on the point of assessment of disability. Date of accident is 26/5/2017. So disability, PW2. How much is the disability considered by the tribunal? Page number, judgment page number. He was working as
Software engineer, Your Lordship.
software engineer. Huh?
Yes, senior engineer software.
Oh.
Your Lordship, since, may I, with a kind permission, Your Lordship, since the petitioner continued in the same service according to his own admissions.
Injuries in para 23, na?
Yes, Your Lordship. Left upper arm fractured, left humerus.
Examine Dr. B. Ramesh PW2. Left upper arm fracture and shaft of left humerus community. Left upper arm fracture and the shaft of left humerus.
Humerus.
Regarding the at page number 27.
Humerus. Comminuted fracture. Yes. He underwent surgery, etc. The petitioner has suffered 29 upper limb, left upper limb 29%, 10% to the whole body. 29% to the upper limb. %10% to the whole body. So how much is taken by the student?
Taken 8%, but not guaranteed compensation of 25,000, not lump sum 25,000.
160. Tell where do we find that?
Page number
8%, para 25. 8% taken by. So this is one grievance. And the second one?
The pain suffering.
How long he was hospitalized?
For 3 days, Your Lordship, 26/5 to 28/5/2017.
3 days.
26/5 to
28/5.
Okay. How much is awarded on pain and suffering?
35,000.
35,000.
According to you, how much should have been given?
Taxes, not at least not.
Hello, ನಿಮ್ಮ ಲೋಕದಾಲತ್ ಚಾರ್ಟ್ ಪ್ರಕಾರ
No, no, it's not.
ವೇಟ್ ಬೇರಿಂಗ್ ಫ್ರಾಕ್ಚರ್ ವೇಟ್ ಬೇರಿಂಗ್ ಬೋನ್ ಆದ್ರೆ
40,000 and plus for every one additional fracture, 10,000, Your Lordship, as per the Lok Adalat.
so comes to 40,000 plus 10,000, 50,000.
50,000, yes, Your Lordship.
Fact that is had not doctor's evidence, but restriction is not of the movement of the arm. Paragraph number 6 of the.
Now according to our Lokadalat chart, now it is standardized. One weight bearing bone 40,000, additional bone 10,000. That's all, no? This is about the pain and suffering. Now next point.
Loss of amenities.
Disability.
All right, we'll, let madam say how 8% is justifiable, then we'll come to that. 10%.
Your
She
Lordship.
says she said that he is a software engineer. Adre kai operate madbekana.
Swami, may I take your Lordships to paragraph 20? Yes.
Madam,
Yes, Your Lordship.
ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಅಂತ ಗೊತ್ತಾಗೋದಿಲ್ಲ. Next
I request the learned counsel to.
suffering ಇದು ಸ್ಪೀಕರ್ ಅಲ್ಲಿ ಮಾತಾಡಿ. ನಾವು ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ಸ್ಪೀಕರ್ ಸರಿಸಿ ಮಾತಾಡಿ ಅಂತ ಹೇಳ್ಬೇಕಾಗುತ್ತೆ, ನಿಮ್ಗೊಬ್ಬರಿಗೆ ಸ್ಪೀಕರ್ ಅಲ್ಲಿ ಮಾತಾಡಿ.
Sorry. So, my lord, in the discussion regarding, my lord, the disablement.
Loss of amenities.
Loss of amenities.
Do you have any grievance for loss of amenities?
For amenities, I will leave, my lord, some enhancement may kindly be done, my lord.
25,000.
25 is being granted, my lord.
ಲೋಕದಲ್ಲ ಚಾರ್ಟರ್ ಅಮ್ಯುನಿಟೀಸ್ ಬಗ್ಗೆ ಇದೆಯಾ? 30,000 ಅಂತ. Where is that? 30,000 ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
My lord, enhanced by a little more money. That is.
ಇದರಲ್ಲಿ ಏನಾದ್ರು ಮಾಡಿದಾರಾ? ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಎಲ್ಲ ಇದೆ. ಅಮ್ಯುನಿಟೀಸ್ 3 days ಹಾಸ್ಪಿಟಲ್. ಆಯ್ತು. ಎಷ್ಟು ಅಕಾರ್ಡಿಂಗ್ ಟು ವಾಟ್ ಇಸ್ ಜಸ್ಟಿಫೈಯಬಲ್?
But I would, my lord, 50,000, my lord, considering, my lord, the injuries that is suffered. And I will also produce, there is a, my lord, a plate hospitalized, my lord, and thereafter, my lord, a thing was inserted, my lord, is removed subsequently. Please, my lord, that is, my lord, is mentioned about it. And I have also produced the photographs also.
ಫೋಟೋಗ್ರಾಫ್ಸ್ ಅಲ್ಲಿ ಏನು ಗೊತ್ತಾಗಲ್ಲ.
And regarding insertion of, my lord, thing is also.
PW2's evidence.
PW2's evidence, please. Para number 3. I submit that on examination of medical records, he has sustained grievous injury, left upper arm, shaft of left humerus committated, underwent OR and IF. I submit that I examined recently on 14/1/2019 for disability assessment. He complained me of pain in left arm, weakness of left elbow, a disability to lift weight with left upper limb, and difficulty to carry out routine activities. I submitted on examination. I found that the assessment of the disability are as follows: restriction of joint movement of right elbow, flexion extension degree normal 100 to 150 degrees, power to left elbow 4.5 normal 5.5/5, difficulty to lift weight over the head with left upper limb. Not absolution. I submit that on examination.
If he is not able to enjoy his routine things for a considerable length of time, that doctor has not only he said.
Basically, my lord, lifting the arm, my lord, after a particular, my lord, degree, my lord, there's a restriction of movement. But for any other purpose, my lord, apart from, my lord, here, my lord, has to while traveling, my lord, or.
Do you find any authority or anything? How much can be granted on this head? How much you expect on this head?
My lord, what has happened, my lord, he have considered as a lump sum, my lord, 25,000 has been awarded. My lord, neither 8% nor 10%, my lord, has been considered, 29% to the.
By one. Now we are on the point of amenities.
Community.
How it is less?
Amenities, my lord, regard to my thing, my lord, 25,000 which is awarded, my lord, it could, my lord, increase, my lord.
Not 55, it is 25,000 is
25 is awarded, it could, my lord, be increased, my lord, I leave it to my lord, honorable.
Yes. Next is attendant nourishment and conveyance charges, 5,000 is awarded.
But my lord, there is no, my lord.
Attendant charges, nourishment, 3 days hospital. How long he was laid up period, ಎಷ್ಟು ದಿವಸ ಆಯ್ತು? ಅದು ಬೇರೆ, ಅಂದ್ರೆ it depends upon that ಅಲ್ಲ. ಎಷ್ಟು ದಿವಸ ಅವ್ರಿಗೆ ಅಟೆಂಡೆಂಟ್ ಬೇಕಾಗಿದ್ರು, ಎಷ್ಟು ದಿವಸ ಅವ್ರಿಗೆ ಟ್ರೀಟ್ಮೆಂಟ್ ಬೇಕಾಗಿತ್ತು ಅಂತ. ಕನ್ವೇನ್ಸ್ 2 months ಅಲ್ಲ. 2 months ಅಂತ 2 months ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರೆ 5,000 ಕಡಿಮೆ ಆಗುತ್ತೆ ಹಾಗಿದ್ರೆ. ಎಲ್ಲಿ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 25,000 ಅದಲ್ಲ. Extend throughout his life. Compulsion under the head of loss of amenities. Discharge summary shows that he was taken treatment on other 3 days.
For 3 days, for 3 weeks, he could not work.
Manipal Hospital. Further, petitioner has also produced exhibit P7 discharge summary. It reveals that petitioner has taken treatment as inpatient from 28/6/2013. 2013 ಅದು. ಅವ್ರದ್ದು ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿರೋದು 2017 ಅಂತ.
13.
ಯಾವ್ದು 2013 ಎಕ್ಸಿಬಿಟ್ P7. 23 ಹೋಗಿ 17 ಆಗಿದೆ ಹೇಗೆ?
17
P5 P6 P7, 26th May 2017 to 28/5/2006, sorry. P7, 27/5/2017 to no, P7 in correction. P7, this is discharge summary. Okay. Date of discharge 36/2013 and date of admission. Correct is our accident in Badlena, sir.
One more accident he had suffered.
But how that comes in this?
Lord, the same part, Lord, he has suffered one more. That's only to demonstrate that, not claiming under that thing. But he already suffered an injury which already had a weakness. That's the reason, Lord, he has produced that document.
Date of discharge, right shoulder, Banker's lesion. Patient came with a complaint of right shoulder pain. No, this is not accident. Sir. ಇದೇನೋ ಇವ್ರು ಬರೀ ಅದನ್ನೇ ಆಪರೇಟ್ ಮಾಡ್ತಿರ್ತಾರಲ್ಲ ಅದಕ್ಕೆ ಇರ್ಬೇಕು. Clinically evaluated, investigations were done. Patient underwent right shoulder Banker's repair. No, this is totally either.
Prior injury which was sustained by him, which already.
This becomes relevant for this case then.
Lord, but only to demonstrate, Lord, that he had already had a issue with that particular limb.
It was made 3 months ಅಂತ ಮಾಡಿದ್ದಾರೆ. This was much before that.
No, but what is awarded, Milord, is 78,000. It is, Milord, for 3 weeks.
He was only for 3 days hospitalized.
3 weeks since his evidence, Milord, is met. 3 weeks he could not attend his work.
Doctor ಹೇಳಿದ್ದು ಆಯ್ತು 3 weeks.
3 weeks, Milord, that is considered, Milord, by the court. It is not for a period of 3 months. 3 weeks is considered. His salary is, Milord, 1,52,000. What is considered by the court, Milord, is 78,000.
Just forward 5,000. 3 days ಮತ್ತೆ ಇನ್ನು ಡಾಕ್ಟರ್ ಹೇಳಿಲ್ಲ he was on follow-up treatment. Doctor also does not say that he was on follow-up treatment for
But he follow-up treatment, Milord, is not.
whether he needed an attendant because only one hand fracture.
One hand fracture. There is, Milord,
So at the most that can be done. ಒಂದು 300 rupees per day ಹಿಡ್ಕೊಂಡ್ರು 10,000 ಮಾಡಬಹುದು.
I leave it to Milord, to my Lord's consider.
Attendance charges, etc.
10,000.
3 weeks, huh? So now loss of earning capacity. Paid up period. Yes, yeah, examined
78,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
1,78,000 laid up period. Have you examined the employer?
Not, employer is.
Paid salary during that period.
Employee is not examined, but.
So 78,000 because they are not questioned.
They are not questioned. Only thing, Milord, that during that for 3 weeks, Milord, he could not work is the evidence.
Correct. ಅದಕ್ಕೆ ಅವ್ರು ಸ್ಯಾಲರಿ ಕೊಡ್ಲಿಲ್ಲ ವರ್ಕ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ. We have to balance that. Now loss of earning capacity. Reduced eligibility of employment 1,000 ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. Where is the material to show that you have lost your earning capacity?
Paragraph 22 of the judgment, Your Lordship.
The salary detail letter, etc. Reveals that petitioner was working as senior engineer, software engineering at Xerox Business Private Limited, Whitefield, Bangalore. His gross salary was 1,52,151. The cross examination of PWR, it reveals that he has continued the same work in the same company and getting higher salary compared to the date of accident. Therefore, as per the judgment of the Supreme Court, and so also, the petitioner is not entitled for compensation for the head of loss of future income. Kotilla.
Adu kotilla. Under the head, Milord, regarding further disability.
Then reduced eligibility of employment or damages due to disability. So general lump sum kottidare.
Lump sum kottidare.
There is no loss of earning capacity.
What they have not considered 8% to the whole body. And
correct. Even 8% or 50%, it should have caused him the loss of earning capacity.
That is, they have mentioned that lump sum amount of 25,000 has been considered.
Oh, 1 lakh.
1 lakh. They have not given anything on that. They have general lump sum 1 lakh
1 lakh
damages ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ.
That my lord, my submission, my lord, is that my lord,
It
because
can come under
the-
pain and suffering and amenities etc.
because restriction of
General damages.
restriction of movement is there, my lord, that doctor has not spoken, because what happens apart from that,
He may not be able to enjoy other
even if my lord, he has to travel, in fact,
activities or.
he had to
playing,
you know, take a cab to go to work later also, he could not, my lord, drive he could not, all that is on record.
Doctor has said he cannot drive etc. ಅಂತ.
Doctor has
He
not
has
mentioned
not
about
said.
the drive, because it was examination after 2 years, please. After 2 years, examination was happened. Accident was caused.
Yes, what? You expect something and loss of earning capacity.
My lord,
The trial court says that your records only showed you are earning more than what you were earning at the time of the accident.
my lord, and so far as disablement is, disability is concerned, my lord, there,
Copy of the charge sheet. ಇಲ್ಲಿ ನೀವು ಎಂಪ್ಲಾಯರ್ ನೀನು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ.
employer exam.
But what is the document trial court relies to say that you are earning more than what you were earning at the time of the accident?
Admission by the petitioner himself.
Oral evidence.
Cross examination, my lord.
Admission by PW1 himself, your lordship.
One.
Cross examination of PW1.
Paragraph? ಇಲ್ಲಿದೆ ಪ್ಯಾರಾ 3 ನಲ್ಲಿ ಪ್ಯಾರಾ 3 ನಲ್ಲಿ ಅಲ್ವಾ? ಕಂಪನಿಯವರು ಚಿಕಿತ್ಸೆ ವೆಚ್ಚವನ್ನು ಮರುಪಾವತಿ ಮಾಡಿಕೊಂಡಿದ್ದು ಎಕ್ಸೆಟ್ರಾ ದೇ ಹ್ಯಾವ್ ರಿಇಂಬರ್ಸ್ಡ್ ಇಟ್. ಅಪಘಾತ ಸಮಯಕ್ಕೆ ಪ್ರತಿ ವರ್ಷ 18,70,000 ಇತ್ತು. ಈಗ ನನಗೆ 20 ಲಕ್ಷ ವಾರ್ಷಿಕ ಸಂಬಳ ಬರುತ್ತಿದೆ. ನಾನು 3 ವಾರಗಳ ಕಾಲ ಕಂಪ್ನಿಗೆ ರಜೆ ನೀಡಿದ್ದು ನಂತರ ದಿನದಲ್ಲಿ ಕಂಪ್ನಿಗೆ ಹೋಗುತ್ತಿದ್ದೇನೆ, ಆದರೆ ಕೆಲಸ ಮಾಡಲು ಆಗುತ್ತಿರಲಿಲ್ಲ. ಸಂಬಳವನ್ನು ಸಂಪೂರ್ಣವಾಗಿ ಕಂಪನಿಯವರು ನೀಡಿದ್ದು ಇರುತ್ತದೆ. ನಾನು ಕೊಡೈಕನಲ್ಗೆ ಹೋಗೋದು ಅಪಘಾತದಿಂದ ನಿಂತು ಹೋಗಿದ್ದು ಇರುತ್ತದೆ. So he has deposed that he has admitted that he was earning.
Yes, that is not in his.
ಇದೆಲ್ಲ ಒಂದೊಂದು ಹೆಡರ್ ಬರ್ಕೊಂಡು ಬನ್ನಿ ನೋಡೋಣ. 29% pain and suffering 35,000 ಇತ್ತು 50,000 ಆಗುತ್ತೆ. Amenities 35,000 ಇತ್ತು 30,000. 25 30,000 ಆಗುತ್ತೆ. ಅಟೆಂಡೆನ್ಸ್ ಚಾರ್ಜಸ್ 10,000 3 weeks ಇಟ್ಕೊಂಡ್ರೆ ಆಮೇಲೆ 78,000 made up period ಆಗುತ್ತೆ. Yes, madam, what have you got to say?
My only submissions, your lordship, as this honorable court has rightly appreciated that he deserves towards pain and suffering more enhancement up to 50,000 is correct, your lordship. Since the trial court tribunal, relying upon 2 judgments of this honorable court, has come to the conclusion that the petitioner has continued in the same job as per his own evidence.
That he did not much
Yes, your lordship. Yes, your lordship. Amenities ತಾವಂದಂಗೆ ಇನ್ನೊಂದು 5,000 ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ, ಅದ್ ಬಿಟ್ರೆ ಬೇರೆ ಎಲ್ಲೂ ಕೊಡೋಕೆ ಸ್ಕೋಪ್ ಇಲ್ಲ. ಈವನ್ ದೋ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಕಂಪನಿ ರೀಇಂಬರ್ಸ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಅವ್ರ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಹೇಳಿದ್ರು ಕೂಡ ಟ್ರೈಬ್ಯುನಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಸೊ ಅದಕ್ಕೆ ಅಲ್ಲ ನಾವು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ. ಐ ಆಮ್ ನಾಟ್ ಇನ್ಸಿಸ್ಟಿಂಗ್ ಆನ್ ದಟ್, ಓನ್ಲಿ ಫಾರ್ ದ ಕೈಂಡ್ ಕನ್ಸಿಡರೇಷನ್ ಆಫ್ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್, ದಟ್ಸ್ ಆಲ್, ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್. ಅಂಡ್ ಲೇಡ್ ಅಪ್ ಪೀರಿಯಡ್ಗೂ ಲಾಸ್ ಆಫ್ ಸ್ಯಾಲರಿ ತೋರ್ಸೇ ಇಲ್ಲ ಅವರು, ಆದ್ರೂ ಕೂಡ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು. ಸಿನ್ಸ್ ದ ಕಂಪನಿ ಹ್ಯಾಸ್ ನಾಟ್ ಚಾಲೆಂಜ್ ಇನ್ ಅನ್ ಅಪೀಲ್, ಐ ಆಮ್ ನಾಟ್.
suffering 50,000.
35 ಬದಲು ಅಲ್ಲೊಂದು 15,000 ಇನ್ಕ್ರೀಸ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ. ಅಂಡ್ amenities another 5,000, your lordship. 25,000 has already been awarded.
30,000. Okay. Then
and towards attendant charges, nourishment and all, another 5,000, your lordship. 5 has already been awarded, and he was only hospitalized for 3 days.
ನಾವು ಎಷ್ಟು 10,000 ಹೇಳಿದ್ವಿ. 10,000. Then
loss of income during laid up period.
Laid up period that has to be maintained.
Yes, your lordship.
Laid up period loss of income. 78,000. 78,000. ಇನ್ನೊಂದು
Reduce the liability of employment due to disability or.
ಅದನ್ನೇ ಡಿಸಬಿಲಿಟಿ ಕೆಳಗಡೆ 1 ಲಕ್ಷ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅವರು.
ಅದು ರೆಡ್ಯೂಸ್ ಆಗಿಲ್ಲ, ಬಟ್ ಅಂದ್ರೆ ಕಾಂಪನ್ಸೇಷನ್ ಪರ್ ಅಮ್ಯುನಿಟಿ ಅಲ್ಲೇ ಜಾಸ್ತಿ ಮಾಡ್ಕೋಬೇಕಾದ್ರೆ ಅಷ್ಟೇ, ಅಥವಾ ರೆಡ್ಯೂಸ್ಡ್ ಕರಿಯರ್ ಗ್ರಾಫ್ ಅದು ಆಗಿರೋದಿಲ್ಲ. ಇದರಲ್ಲಿ ಕರಿಯರ್ ಗ್ರಾಫ್ ರೆಡ್ಯೂಸ್ ಆಗಿರೋದಿಲ್ಲ. ಅಂದ್ರೆ ವಾಟ್ ಅದನ್ನ ಇದನ್ನ ಮೇಂಟೈನ್ ಮಾಡ್ಬೇಕಷ್ಟೇ. ಅದನ್ನು
He has.
ದಟ್ ಈಸ್ ಎಷ್ಟು 1 lakh ಕೊಟ್ಟಿದ್ದಾರೆ.
He has not produced any evidence before the tribunal to show that his career has been has come down or
challenged that.
Yeah.
Not
ಅಲ್ಲ
challenged.
true your lordship. ಅಲ್ಲ ಫರ್ದರ್ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಗೆ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೀವಿ.
No, ಇಷ್ಟೇ ಈಗ ನೀವು ಹೇಳಿದ್ದಷ್ಟೇ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಆಗುತ್ತೆ.
Yes your lordship.
2,68,000 ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಕರೆಕ್ಟ್ ಇದೆಯಾ? 50,000 3780 plus 1090 1,90,000 plus 1,78,000 2,68,000 ಆಗುತ್ತೆ.
Minus 2 lakh.
ಅಲ್ಲ ಇದು ಅಂದ್ರೆ modification minus
43,000.
Why did you prepare this appeal? ಅಂದ್ರೆ 25,000 ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರೆ we can enhance it to rupees 2,68,000. ನೀವು ಹೇಳಿದ್ ತಗೊಂಡ್ರು.
Yes your lordship. Yes your lordship.
Why did you prepare the appeal?
Only on the question of disablement, we thought that because the only consideration was if we thought on the percent of disability, we would have gone to 2 lakhs.
Appeal is partly allowed. Disability ಆಗಿಲ್ಲ ಅಂತ ಜಡ್ಜ್ಮೆಂಟ್ ಅವರು ಒಪ್ಕೊಂಡಿದ್ದಾರಲ್ಲ, ಅದಕ್ಕೆ ಇವರು ಇಲ್ಲಿ ರೆಡ್ಯೂಸ್ಡ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ. there is no actual disability is functional disability. There is no functional
Problem, he's not a laborer, he is a software engineer.
We told madam that ಅವರು ಇದನ್ನೇ ಆಪರೇಟ್ ಮಾಡಬೇಕು ಯಾವಾಗ್ಲೂ.
Because a software engineer will sit on a table. If it had a manual work, that difference would have been there. But he's a software engineer, so he'll have to.
Now that also has gone. Earlier they used to operate these keys. Now artificial intelligence has come. Only vocal. ಅಷ್ಟೇ 2,68,000 ಮಾಡಬೇಕು. The bill is partly allowed. The impugned order is modified minus ಅಂತ ಮಾಡೋದು as follows. ಹಂಗಂದ್ರೆ ಅದು enhanced compensation ಅಂತ ಮಾಡೋದು modified. Bill is partly allowed ಆದ್ಮೇಲೆ the appellant is entitled to enhanced compensation of rupees 25,000. Adar mere interest with interest there are
6% your lordship as per this.
From the date of the petition till its realization. Respondent number 2 alla name.
2 please.
Yes. Yes your lordship.
Deposit the said amount before the tribunal within 4 weeks from the date of receipt of the copy of this order. On such deposit, the tribunal shall release the said amount to the claimant/appellant.
The records may kindly be.
Follow reasons to follow. Judgment
Please.
very record.
LCR good may not transmitted. The trial court records may could be transmitted.
Transmit the records. PCRs to the tribunal.
Please.
Some judgment ready.
Number 51, D. Nagaraj Reddy, V. Pradeep.
Serial number? No pass over. Pradeep again, there is some problem on the 51. Legend at the request of counsel for respondent number 2. Yes.
Serial number 52, Ravi HK, Gautam S. Bharatbaj.
ಮತ್ತೊಂದು ಅದನ್ನ ಡೇಟ್ ಅಲ್ಲಿ ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೊಂದೊಂದು ಮೆಮೊ ಕೊಡ್ತಾರೆ ನಾಗರಾಜ್ ರೆಡ್ಡಿ ಅವ್ರದ್ರಲ್ಲಿ.
For the appellant, request for
List on 26 9. Yes.
for a shorter date.
ಯಾವ್ದು
52.
52 ಅಲ್ಲ ಕೊಟ್ಟಿರೋದು ಡೇಟ್. ಇದ್ರಲ್ಲೇನು ಪಾರ್ಟಿಷನ್ಸ್. ಥರ್ಡ್ ಗೌತಮ್ ಭಾರದ್ವಾಜ್.
Yes.
Here for the respondent, your lordship, if there is any
Why,
possibility of.
urgency in 2020 matter?
We'll finish it, madam.
You want to finish it, but we have 2015 matter ನೋಡಿ ಇವ್ರು ಇದಾರೆ ಅಲ್ಲಿ ವೆಂಕಟೇಶ್ ಅವರು ಮೊನ್ನೆ ಯಾವ್ದೋ 2015 ಮೋಟರ್ ಆಕ್ಸಿಡೆಂಟ್ ಕೇಸ್ ಇದೆ. ನೀವಲ್ಲ. ಅಲ್ಲ ರೀ ನೀವಲ್ಲ. ಸಿ ವಿ ಹ್ಯಾವ್ ಸಮ್ ವೆರಿ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ಸ್. ಹೊಸ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ ಇದಕ್ಕೆ ಅರ್ಜೆಂಟ್ 52 as
Your lordship, if I just make one submission, your lordship, if there is any possibility of settlement, your lordship.
we'll be more happy if we can settle. ಏನು sister and brother?
Yes, your
Yes, my
lordship.
lord.
It's between the
Are
family
you ready to
members.
settle? ಏನು now suit is decreed.
Yes, your lordship.
ನಾವು
Suit is
ನಿನ್ನೆ ಒಂದು ಕೇಸಲ್ಲಿ ಟ್ರೈ ಮಾಡಿದ್ವಿ.
Your lordship, the trial court says that the properties that is left out in the larger proportion of the property.
We are not contested. ಇದು ಯಾವ್ದು ಬೇರೆ MEC ಕೇಸ್ ಕೊಡ್ತಾ ಇದ್ರಲ್ಲ RFA 26 of 2020. Yes, there is no. Are you ready to settle the matter with your sister?
ಒಂದ್ಸಲಿ ಟ್ರೈ ಮಾಡಿತ್ತು ಮೇಡಮ್, ಬಹಳ ಲೋ ಅಂತಂದ್ರೆ ಅದಕ್ಕೆ ಅನ್ಕಂಪೇರಬಲ್ ಆಗಿ ಮಾಡಿದ್ರು, ಅದ ಬೇಡ ಅಂತ ಕೋರ್ಟ್ ಬಂದಿದ್ದು ಅದಕ್ಕೋಸ್ಕರ ಮೇಡಮ್.
I leave it to your lordship.
ಅಲ್ಲ ನೀವೇನಾದ್ರು ಇಬ್ರು ನೀವು both of you can
I'll speak to my clients.
ಅದೇ ಮಾಡಿದ್ದು ಮೇಡಮ್.
66 years.
ಈಗ around 72 ಆಗಿ.
7 ಅಂದ್ರೆ ಅಷ್ಟು ವಯಸ್ಸಾದ್ಮೇಲೆ ಏನಾರ ಒಂದು ಗಿವ್ ಅಂಡ್ ಟೇಕ್ ಮಾಡ್ಕೊಂಡು ಮುಗಿಸ್ಕೋಬೇಕು.
We'll talk to you.
ನೀವು
Your lordship, I'll speak to them. I'll speak to my clients. If there is any possibility of settlement, we'll report settlement on next date. All else, I'll leave it on your lordship.
mediation ಗೆ ಏನು ರೆಫರ್ ಆಗಿಲ್ವಾ ಇದು?
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಇಲ್ಲ.
ರೆಫರ್ ಮಾಡೋಣವಾ?
ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ.
mediation ಗೆ ರೆಫರ್ ಮಾಡೋಣವಾ? ಏನ್ issues ಏನಿದೆ ಇದರಲ್ಲಿ? What were the issues?
Your lordship, what is the issue is there is a larger extent of a property which is around 7,000.
Issues frame, what was the defense ಅಂತ ನೋಡೋದಕ್ಕೆ?
Your lordship, my
The
defense,
defense prove that Nagbhushan has executed a will.
indeed, your lordship, I
Very difficult.
don't have the possession of the will, in fact, your lordship. I
Will
don't have
produce ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ ಸ್ವಾಮಿ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಆಗಿಲ್ಲ will produce. However, in the trial court has held that there is no leftover property, but
Defense prove that section 40 paid. ಅದನ್ನು ಕೂಡ ನೆಗೆಟಿವ್ ಅಂತ ಮಾಡಿದ್ರು. That plaintiff is entitled for reliefs as paid for. Dismiss ಮಾಡಿದ್ರು. Why the suit is dismissed then?
your lordship, it's only dismissed on the ground that there is no leftover property.
There is
How? No leftover property in the larger extent of the property.
Why?
But there's some leftover property, your lordship. I'll admit to that there is a leftover property.
So you represent the brother.
Respondent number 1 and 2, yes, your lordship.
ಮತ್ತೆ ಇವ್ರು ಯಾರು?
She's my sister.
Sister, my lord.
Sister.
ಅವ್ರ ಯಜಮಾನ್ರ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿನ ವುಮನ್ ಎಂಪವರ್ಮೆಂಟ್ ಅವ್ರನ್ನೇ ಕಳಿಸಿ ಮುಂದೆ ನೀವ್ಯಾಕೆ ಬಂದ್ ನಿಲ್ತೀರಿ? ಹಾ
ಈಗ ಇದು ಪ್ರಾಪರ್ಟಿ ಉಳಿದಿರೋದ್ರ ಬಗ್ಗೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಸಬ್ಮಿಟ್ ಮಾಡಿ.
ಅಲ್ಲಮ್ಮ ಆಯ್ತು ನೋಡಿ, ಎಲ್ಲರದು ಆಯುಷ್ಯ ಮುಗಿತಾ ಬರ್ತಾ ಏನಾರ ಒಂದು ಕುತ್ಕೊಂಡು ಮಾತಾಡ್ಕೊಂಡು ಸೆಟ್ಲ್ ಮಾಡ್ಕೋಬಾರ್ದ ಮ್ಯಾಟ್ರನ? ನೀವು ಅವರೇ ಹೇಳ್ತಾ ಇದಾರೆ, ಅವ್ರ ಕ್ಲೈಂಟ್ಗೆ ಅವ್ರು ಹೇಳ್ತಾರಂತ.
ಕೊಡ್ತಾ ಇಲ್ಲ ಮೇಡಮ್, ಅದರಿಂದ ನಾವು ಫೈಟ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ.
ಈಗ ಅವ್ರು ಹೇಳ್ತೀನಿ ಅಂತ ಅವ್ರ ಕ್ಲೈಂಟ್ ನಿಮ್ ಕ್ಲೈಂಟ್
ಮಾಡೋದು ಇಲ್ಲ, ಬರೀ ಸುಳ್ಳು ಹೇಳ್ತಾ ಇರ್ತಾರೆ.
ಪಾಪ ಅವ್ರ ಮೇಲೆ ಯಾಕ್ರಿ ಹೋಗ್ತೀರಿ ನೀವು? ಇಲ್ಲೇ ಹೇಗ್ ಮಾಡ್ತೀರಿ? ಕೋರ್ಟ್ ಹೊರಗಡೆ ಹೇಗ್ ಮಾಡ್ತೀರಿ ನೀವು?
ಪ್ರಾಬ್ಲಮ್ ಬಂದಿದ್ದೇನು ಅಂತ ಕೊಡಕ್ ರೆಡಿ ಇದೀವಿ, ದುಡ್ಡು ಎಲ್ಲಿದೆ, ಯಾವ ತರ ನಮ್ಮ ಕೋರ್ಸ್ ಕುಡಿತ ಕೇಳ್ತು, ಅದು ಕೂಡ ನಮ್ ಸೆಂಟಿಮೆಂಟ್ಸ್ ಡಿವೈಡ್ ಮಾಡಕ್ ತಯಾರಿಲ್ಲ ಅಂತ ಯಾರು.
ಏನೀಗ ಮೀಡಿಯೇಷನ್ ರೆಫರ್ ಮಾಡ್ಬೇಕಾ?
One chance may be given to mediation.
When ರೆಫರ್ ಮಾಡೋಣ ಮೀಡಿಯೇಷನ್ಗೆ ಬರ್ಕೊಡಿ. When the matter is taken up for hearing, it is found that there is an element of settlement in the matter. Therefore, the matter is referred to Karnataka Mediation Center for mediation. Party shall appear before the mediation center on date
Next week.
You represent all the respondents?
No, 1 and 2. 1 and 2.
ಯಾರೋ ಒಬ್ರು
1, 2 and 3 also, your lordship. I'll take
ಸರ್ವ್ ಆಗಿ ಅನ್ರೆಪ್ರೆಸೆಂಟೆಡ್ ಇದಾರಲ್ಲ, ಹೇಗೆ ಮೀಡಿಯೇಷನ್?
They are not contested in the trial court, your lordship.
What interest they have?
They are the brothers, sisters, other 2 sisters of them.
They are not contested.
They have contested, they have filed written statement, or they have memo,
No,
they have
whether
filed.
they are sailing with you or sailing with them.
No, they have filed a memo adopting my written statement. They have filed a memo adopting my written statement in the trial court.
Yeah. You only take them to the mediation center because they are served unrepresented.
Indeed, Your Lordship, I
Matter is
understand.
referred to. Party shall appear before the mediation center on
23/9.
339 at 3 p.m. ಅಂತ ಬಿಡೋಣ. At 11 a.m. ಅಲ್ಲಿ ಇವ್ರಿಗೆಲ್ಲ ಅಡ್ವೊಕೇಟ್ಸ್ ಇಲ್ಲಿ ಕೆಲಸ ಇರುತ್ತಲ್ಲ ಅವರು ಹೋಗಕ್ ಆಗ್ತಿರೋದಿಲ್ಲ ಅದಕ್ಕೆ at 3 p.m. without any further notice. List on after ಅದಾದ್ಮೇಲೆ
1410.
Much obliged.
Cell number 53, A. Venkatesh, Prakash Image.
Yes.
For the respondent.
Ready or not ready? I'm ready. Yeah, ready. 440 ಆಯ್ತಲ್ಲ ಆದ್ರೆ
ಯಾವತ್ ಕೊಡ್ತೀರಾ ಕೊಡಿ ಶಾರ್ಟ್ ಡೇಟ್ ಶಾರ್ಟ್ ಡೇಟ್ ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಸೆಪ್ಟೆಂಬರ್ ಮೇಡಮ್.
This matter has been heard for quite a long time before Your Lordship, Your Lordship. So they had filed an application to secure the CD insofar as the accident which was occurred.
CC footage.
CC footage, and they had filed, my senior counsel had filed an application which has to be heard, Your Lordship.
that has to be heard along with the main matter.
Please, yes. A short date may be fixed. Because this has been
urgent to date
26/9.
ಏನ್ ಮಾಡ್ಬೇಕಲ್ಲ
Fine for first year.
ಅಲ್ಲ ಫಸ್ಟ್ ವೀಕ್ ಆಫ್
No, Your Lordship, 26.
26.
Obliger.
26/9.
Yes.
Cell number 50. Cell number 54, NS Bhatt.
Waiting for respondent.
ಯಾರಿಗಾರ ಅವ್ರಿಲ್ವಾ? ನಿನ್ನೆ ಹೇಳಿದ ಇವ್ರಲ್ವಲ್ಲ ಶಂಕರ್ ನಾರಾಯಣ್ ಭಟ್ ಅವರು representation for the
Short date. Date.
list. It is urgent for you. And then a specific performance.
Yes, ma'am.
List on and date.
1510.
1510.
Long date.
Cell number 55.
ನೀವು ನೋಡ್ತಾ ಇದ್ರೆ ಹಳೆ ಕೇಸ್ ಬಿಡಿದೆ ಅದನ್ನ ತಗೋಬೇಕಲ್ಲ ಮೊದಲು 1510.
55, Girish Kumar.
Yes, apply for the respondent.
For specific performance. Really fix a date in the.
And yeah, last it before. ಏನಿದ್ರಲ್ಲಿ refund order ಆಗಿದೆಯಾ?
Refund ಆಗಿದೆ. Even though there was no prayer for refund of earnest.
But
We have filed, there's a connected appeal, my lord, where
It's
we
there,
have-
ಇದೆ ಇಲ್ಲ ಕೆಳಗಡೆನೆ. List on
2310.
2310.
No date, any date in September. 27.
ಅದಕ್ಕಿಂತ ಮೊದಲು ಅಕ್ಟೋಬರ್ ವೆಕೇಶನ್ ಬರ್ತಾ ಇದೆ ಅಲ್ಲ
3 weeks ಇಲ್ವೇ ಇಲ್ಲ.
2310.
56, M. Shivaprakash.
I appear for the respondent here, my lord. Last time,
May be grant, my lord. Really,
As requested by the applicants.
my lord, there's a case where I've been staying separately from my husband, my lord, since several years. I've been filing application after application and winning in all the trial courts. However, my husband still doesn't want to live with me, my lord, and now he's filed this appeal seeking against a decree of restitution of conjugal rights, my lord.
He is one for restitution of conjugal rights.
I'm seeking restitution, my lord. I'm seeking to live with my husband.
Entitled for enhanced maintenance of, this is for maintenance.
It is a number of petitions together, my lord, but the main appeal here, the MFA, is against the decree of restitution of conjugal rights, my lord.
The respondent is directed to pay enhanced compensation, maintenance of rupees also, respondent pay arrears. ಇದ್ರಲ್ಲಿ ಇದೆ ಮೇಂಟೆನೆನ್ಸ್ ಇದೆ ಇಲ್ವಲ್ಲ restitution.
Main application is for restitution itself, my lord. But last time ಅವರು ನಾನು advocate change ಮಾಡ್ತಾ ಇದೀನಿ ಅಂತ ಹೇಳಿದ್ರು, my lord. ಅದಕ್ಕೆ
Yes, my lord.
ಬೇರೆ ನೋಡ್ತಾ ಇದೆ.
I think
Legally wedded wife. Oh, marriage dispute ಮಾಡಿದಾರ.
marriage ಹೌದು.
She is legally wedded wife.
Yes.
The respond to withdrawn. Case is
The
not reached.
matter needs to be heard, my lord. Any date in the near future.
2110.
2110.
An earlier date, kindly, my lord,
Not
because
possible, madam. In the 2022 matter, yes.
Cell number
Okay.
57.
Obliged.
Choda, Ambachira Rajre.
None appears urgent.
Cell number 58 urgent, cell number 59. Dilraj Rohit Sekwara.
My lord, so for the appellant, 6 time for 2 days, my lord.
Sir, would understand. As requested, list on
2310.
2310.
Much obliged.
Cell number 60 adjourned, 61. Patta BC, Ramesh Babuyan.
This
First week of October will be.
first week holiday ಬರ್ತಾ ಇದೆ
Yeah.
for first day of time adjourned to
2410.
24.
62, Abu Bakr.
Appear for the appellant, my lord. This is challenging the order passed by the judgment and degree passed by the trial court. Conjugal,
444.
ಆಯ್ತು 20th ಹಾಕೊಳ್ಳಿ ಸಮ್ 20th.
ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇದೆ?
ಅಲ್ಲ ಅರ್ಜೆನ್ಸಿ ಉಂಟು ಯಾಕಂತ ಹೇಳಿದ್ರೆ ಮೈ ಡಾಟರ್ ನೌ 24 years my lord. She has to be married and my conjugal rights has been dismissed. ನಾನು ಮದ್ವೆನೇ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ತಾ ಇಲ್ಲ ಯಾಕಂತ ಹೇಳಿದ್ರೆ ನನ್ನ ಮೇಲೆ ಇದೊಂದು ಬ್ಲಾಕ್ ಇದಾಗಿದೆ ಯಾಕಂತ ಹೇಳಿದ್ರೆ he says ಇದು ಎಂತದ್ದು ಸಬ್ಸಿಸ್ಟಿಂಗ್ ಮ್ಯಾರೇಜ್ ಇತ್ತು ಅಂತ ಹೇಳಿ ಮ್ಯಾರೇಜ್ ಆಗಿದೆ admitted, marriage is admitted, child born is admitted, everything is admitted.
Now the matter is.
Now he is saying, when I married her in the year 1999, I was already married. ಈಗ ಹೇಳ್ತಾರೆ now.
ಅವ್ರ ಮೈಕ್ ಆಫ್ ಮಾಡಿ. ಮೈಕ್ ಆಫ್ ಮಾಡಿ ಅವರು. ಇದರಲ್ಲಿ ಏನು ರಿಲೇಶನ್ಶಿಪ್ ವಾಸ್ ಡಿಸ್ಪ್ಯೂಟೆಡ್.
ಅವ್ರು ಹೇಳೋದು ಏನಂತ ಹೇಳಿದ್ರೆ ಆಲ್ರೆಡಿ ನಾನು restitution of conjugal rights ಗೆ ಹಾಕೊಂಡು.
Right, you filed petition for
Petition for conjugal rights. Conjugal rights ಅಲ್ಲಿ ಇವರು ಏನ್ ಹೇಳ್ತಾರೆ all of a sudden in the evidence ನಾನು ಇವರೊಂದು ಮದುವೆ ಆಗುವಾಗ ನನಗೆ ಆಲ್ರೆಡಿ ಮದುವೆ ಆಗಿತ್ತು ಬಟ್ he admits
marriage was not
second marriage
ಅಂತ ಹೇಳಿದ್ರು ಬಟ್ he admits that ಮ್ಯಾರೇಜ್ ಅಡ್ಮಿಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಮಗಳು ಹುಟ್ಟಿದ್ದು ಅಡ್ಮಿಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಎಲ್ಲ he admits everything he admits but he says this is the second marriage. And now, my lord, my daughter is 24 years and now I'm a teacher. Now I should get her married because of this stigma. I'm unable to. That's why I filed this restitution of conjugal rights.
She herself filed a complaint before the learned magistrate under PCR, my lord, regarding the 493, 494, that offences also. She is admitted that first marriage.
No, I never admitted.
She married her anta complaint.
Not suppressed, my lord.
No, whether complaint was filed saying that suppressing the.
Suppress the first marriage. That is their allegation. That is their allegation.
Evidence part.
I cannot hear you on merits.
And another thing is, we are paying the maintenance to my daughter.
20th.
Now she has completed the education and joined in the service.
ಆಯ್ತು ಅಲ್ಲಿ ಯಾವ್ದಾರ ಮೊದಲು ಹಾಕಿ ಇಷ್ಟೊಂದು ಮಾಡ್ತಾ ಇದ್ದಾರೆ ನೋಡಿ.
21/9.
ಇಲ್ಲ 21 ಆಗುದಿಲ್ಲ ಸುಮ್ಮನೆ 20th 20ನೇ ತಾರೀಕು.
ಸಾಟರ್ಡೆ ವರ್ಕಿಂಗ್ ಡೇ ಇದೆ ಅಂತಲ್ಲ 20.
ಅಲ್ಲ ಸಾಟರ್ಡೆ ನನಗೆ 20ನೇ ತಾರೀಕಿಗೆ
20 ಇದೆ.
20 ಉಂಟು.
ರೀಚ್ ಆಗೋದಿಲ್ಲ.
ಓ ಸಾರಿ 3 dates in ಹಿಂಗೆ ಆಯ್ತು.
20
ಅಲ್ಲ 20ನೇ ತಾರೀಕಿಗೆ.
ಆಯ್ತು 29. See, try to understand. We have the cases 2014, 15 MEC ಗಳು.
ಇದ್ರಲ್ಲಿ ಏನ್ ಅರ್ಜೆನ್ಸಿ ಅಂತ ಹೇಳಿ
ಅಲ್ಲ ಅವ್ರು ಹೇಳಿದ್ದು ಸಫ್ರೆಸ್ ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳಿ.
ಹಿಸ್ ಕನ್ಸರ್ನ್ ಇಸ್ ದಟ್ ಡಾಟರ್ ಇಸ್ ನಾಟ್ ಗೆಟಿಂಗ್ ಮ್ಯಾರಿಡ್. ನೀವು ಮಗಳು ಅಂತ ಒಪ್ಕೊಂಡಿದ್ದೀರಿ ಅಂತ ಹೇಳ್ತೀರಿ, ಮದುವೆ ಮಾಡಿ.
paying the maintenance regarding education.
ಬರೀ ಮೇಂಟೆನೆನ್ಸ್ ಕೊಟ್ರೆ ಆಗುತ್ತಾ? ಮದುವೆ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಮತ್ತೆ ಅಂತಂದ್ರೆ ನೀವು ಎರಡೆರಡು ಮದುವೆ ಮಾಡ್ಕೋಬಹುದು.
Let us file the application before the trial court regarding the marriage expense and other things, not within this petition.
Marriage expense ಕೊಟ್ರೆ ಮದುವೆ ಆಗುತ್ತಾ? It appears you are not
The family members under the
64, Dilraj Rohit Sekwara, Dhananjay Kumar.
My lord, for the petitioner. Two days adjournment may be given, my lord.
Pradeep.
ಅಲ್ಲ ಮೇಡಮ್ 64 ಬೆಳಗಿನ ಅರ್ಜೆಂಟ್.
Serial number 64.
64.
ಇದರಲ್ಲಿ 2 days ಏನು ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ? ಸ್ಟೇ ಇದೆ ಅಲ್ಲ? ಕರೆಕ್ಟ್. What is that? Yes.
I'm for the respondent.
Why stay application was ordered to be heard along with the main matter? stay grant ಆಗಿಲ್ವಾ?
No, my lord, it was not granted.
What is the decree passed? It's after 1 week. No representation,
Yes.
ಹಿಂದೆ ನೀವು ಬಂದಿಲ್ಲ. Submit she has
was-
filed wakalat for respondent. This is very much. Interim order was not granted. ಇಲ್ಲ.
No.
Third, admit issue notice to respondent.
Yeah, we have filed the wakalat.
2023. There is a bit, we can. No. Then what is the judgment passed? ಏನ್ judgment appeal memo ನೇ ಇಷ್ಟಿದ್ದ ದೊಡ್ಡದಿದೆ. Judgment ಗಿಂತ.
The appellant filed for the divorce petition, my lord. That was
She filed
rejected.
the petition for divorce, that is
Yes.
dismissed.
Yes, it was
What is there
rejected.
to stay then? Why stay application? The petition is dismissed.
Yes,
ಅದಕ್ಕೆ application ಇದು ಮಾಡಿಲ್ಲ.
appeal, they have gone to the appeal, my lord.
As requested, list come later. After 2 weeks is okay.
Yes, my lord.
As requested, list after 2 weeks. ಅಲ್ಲ ಇವ್ರು ನಮ್ಮ ಆಫೀಸಲ್ಲಿ ಮಾಡ್ಕೊಟ್ಟಿದ್ರು. ಹೀಗೆ ಮಾಡಿರ್ತಾರೆ. ಇಲ್ಲ ಇದನ್ನೇ ಕೊಡ್ತೀವಿ, ಇದು ಕೊಡ್ತಾರೆ ಅದನ್ನ ಇದೊಂದು ಕೊಟ್ರೆ ಸಾಕು. ಹಾ ಸರಿ, ಮೂರು ಇದಿಷ್ಟೇ ಪಾಯಿಂಟ್ಸ್. ಸರಿ, ಎಸ್ ಏನಿತ್ತು ನಾಗರಾಜ್ ರೆಡ್ಡಿ ಅವ್ರದ್ದು?
Sorry.
ಹಾ?
ಪಕ್ಕದ ಕೋರ್ಟ್ ಇದೆ, ಸಾರಿ ಫಾರ್
ನಿಮ್ದು ಯಾವ ಕೇಸ್ ಇದೆ? ನಿಮ್ದು ಯಾವ್ದು ಪಾಸ್ ಓವರ್ ಆಗಿಲ್ಲ, ಎಡ್ಜನ್ ಆಗಿದೆ ಎಲ್ಲರೂ.
ಅರ್ಜನ್ ಆಗೋಗಿದೆ.
26/9.
ಯಾರು ಇದ್ರಲ್ವಾ?
ನನ್ನ ಕಲ್ಲಿಗೆ ಇದ್ದಿಲ್ಲ.
Yes.
ಮೇಡಮ್
ನಿಮಿಷ ಇರ್ಲಿ.
ಓಕೆ
ಅಲ್ಲಿ ಕೇಳಿ.